Hello. Bit of a different intro today. I've checked everything, so I'm ready to go. So, as some of you, hi Rumble, hello Twitter, Sugar, hello Facebook, hello YouTube. I think most people are in Rumble. Let's get ready. Let's get ready. Let's get ready to rumble. So, we know that today it starts at 8:15 or 3:15 my time, and it finishes to, well, I mean, witnesses and closing arguments finish today, so they will begin deliberating, they hope, around 12, 12, at the very latest 1 o'clock, the judge said. He does not mess about, which is good. It's good to know, though. I mean, hello, everyone. Oh, it's comment. Who's in? Nasa. Hello. How are you? I hope you're well. I hope you're very well today, on this fine Thursday, shall we say. Um, I'm just trying to find the live stream I am now, so we can stream it. Oh, wrong one. Oops. I thought it was organized, but actually, I still got to find a stream. Law and, oh, here we go. Law and crime, isn't it? That's what I want. I hope it's better today than it was yesterday. Um, right, that is. I'll open it up. New tab. Drag it over. Fine. Now yeah. Thought I lost my mouse there for a minute. Yeah, so welcome to that. Well, oh, we had like five there, then they all disappeared to one. Hello, Rumble. I hope you're well in Rumble as well. That's it. It's just been launched in Rumble. Oh, and there's a viewer on Twitter. Feel free to come over to YouTube or Rumble. And somebody's come back on YouTube now. Hello. So that's that. I hope you've had a great morning. I hope you can hear me okay. I'm going to try not to shout today. I'm trying to keep my audio down. So if you're still there, that's that. Or if anyone else is there, how is my audio? I've still got. I'm taking medicine. I am for my. I'm not sure if you can. Oops. Not sure if you can see that. Bickernaise or whatever. Because I've got congestion right down here. Ah, yeah. I was there for about half an hour today trying to sort your audio out just to make sure you're all balanced. Um, and so I'm glad you've gone back there because I was the only one there for a while. I had to leave earlier just to set everything up here. So I was with her for about half an hour. I'm sure she was a bit it's your first stream, you could be a bit nervous. I wanted to just make sure that I was there to support her for her first one anyway. So yeah, so I can't hear from my left ear properly. You know what that tinnitus where it's like buzzing. I got had that for like 2 months now. Still haven't fixed it. Oh, I'm glad there was a few there. Glad. I'm glad. It was when I left, there was no one there, so I was like, oh, I didn't want to leave, but I knew I had to set this up. So I had to make coffee and you know what I mean, get everything done. How is my audio? Is it? Can you hear me okay? Because I'm a bit quiet. People keep coming in now. I don't understand why they keep coming in now. Twitter, hello, hello, Rumble. If you in Rumble, welcome. Oh, the Twitter person's left now. Cool. Thanks enough for that. This, with paranoid. Normally I speak too loud. Hi Stacey, how are you? I hope you're well. Uh, It's weird to me because I've got one person in here in YouTube. I'm not sure who it is, and if that or Stacey now. Um, because I've got no one now on Twitter, but I got a few on Rumble, morning or afternoon or evening, wherever you are. Hello, Rumble. Hello, people, peeps. Little stream, chat away. Okay, so that Rumble sorted for a bit. Stacey, now, what have you forgotten? What have you forgotten? And I just clicked on me. Whose birthday is it today? Who's having a birthday today, Stacey? Happy birthday to you. I think it's you anyway. No. Yeah, absolutely. You see, I remember before you even told me. I remembered. Happy birthday. Uh, 100%. I'm grateful you've made an appearance. Thank you for coming in. Yes, I remembered. I don't know how I remembered, but I remembered Stacey. Yeah, just Russell was there for the birthday. Well done. 61. 61 young. Have you got like a party or people around and stuff, Stacey? I don't personally I don't like birthdays. But I love other people's birthdays, if that makes sense. I love my niece's birthdays, my parents and stuff like that. I just don't like my own. Welcome other people. It's Stacey's birthday today. I would say we'll sing happy birthday, but it's only me singing, so we ain't doing that. Those that keep leaving, don't leave. We don't bite you. I don't know why people do that. Pop in for like 1 second and then leave. It's like, well, why pop in? Right, I'm gonna put stream up so people know that it's coming. If I can find the bloody thing. Watch live. Ah. Yeah, but that's fine though. There's nothing wrong. Do you know what? It's probably the best birthday you can hope for. Just peace and quiet. That sounds like a dream birthday to me. Laying down the couch, feet up. That's a dream. Well, I do hope you have a great day today. And it's the last day of trial. Well, witnesses and stuff. So here we go. They are now back on. Oh, geez, look, hey, I 100% understand. Look, if I was you, I'd be doing the same. Don't worry about it. I have to stay in the stream all day. But in your shoes, yeah, I don't expect people to stay in the stream at all. It's a long day, so it was about 8 hours, I think, yesterday for me. Oh no, it was more than that. It's about nine. The other night, it was exactly 10 hours. I was like, oh, I'm tired. So yeah, right, checking on. No one yet on there. Okay. Notification. Okay. See, I don't have to say nothing when nothing I say it. She just tells everyone, "Do you know what? Right, hang on, let me check now. Then, unbelievable, unbelievable. This is." Also, just by the way, Nathan, you weren't here. I'm running a competition on Twitter. Um, but some people don't have Twitter. So I've said everyone in chat here, like yourself and that, you're all in. You're all in the competition anyway. Like Stacey hasn't got it, Giovanna hasn't got Twitter. And you guys are all in. And it's a competition to win $25 for 10 people. I miscounted. I was supposed to say five, but I did 10. My big mouth, you know. Sometimes my big mouth runs out and I post stuff without looking. Next thing I know, I'm down $250. But anyway, let's have a look to see how many I've got here. Studio. So, so I started yesterday. If you fell asleep during your, I don't. Yeah, no. And Runkle's good. Look, also, this for record for people. I 100% know there's better streamers than me out there. So 100%, if you would need legal advice, Runkle's a good one to be and watch as well. So I appreciate that from people. If people can support me as much as they can, I'm happy. But 100% understand. Uh, I if I was in your shoes, I'd be falling asleep watching me as well. Do you know what I mean? I fall asleep sometimes on the stream. I have to wake myself back up. But Runkle's very good. I like Runkle. I only watch his highlights normally. Same with Peter Trigos. I don't watch his highlights. I don't watch Emily anymore. That's all I can ask for. Right. Started the day yesterday, this time, nearly, with 248 subscribers. I've now got 430 subscribers. But no one's into the competition. I was just saying, I had about 3.5, 4 hours sleep. I hate it. I can't sleep at night. I don't know what's wrong with me. Oh, look at me. Hello, people that are here. Anyone that's not joined the competition on Twitter, please do so. All the details are on my Twitter account, Dylan12D. If you've subscribed, there's like free money being given out. Join it or just chat in here. You're automatically in there. That's in. Stacey's in. Giovanna's in. Erin's in. Rosie's in. Everyone's in. So if you just want to chat, just jump in and chat. You're in. So I've had like maybe 180 subscribers in 24 hours, and no one's joined the competition. Only 2 people have joined it, but they were subscribed anyway.
Yes.
Okay. Defense?
Here we go.
Yes.
Okay. So are we on the record?
Yes, we are.
Okay. Calling the case of Sanderson versus Paltrow. Attorneys are all present. We're here for some matters outside of the hearing of the jury. I believe the defendant is now rested. Did you resolve the exhibits yesterday?
They need to look at them because we kept going. Do we have the indexes?
Jury has ours, but I have to print it out.
Hi, Rosie.
Okay, so
Welcome.
I'll tell you what we did is we pulled a bunch of exhibits, narrowed our index, but you need to go through them, and I wouldn't mind thumbing through theirs really quick too. So the master copy that goes to the jury is the one that said judge copy, actually. That's the one we worked from last night.
Okay.
And I think
It's Stacey's birthday, though.
Mr. Sanderson's address is on a few that we need to
Happy
black out. So I think
birthday,
that
Stacey.
actually needs 5 more minutes of work,
Okay. And
but I think we're close.
so you're not ready to rest until you receive those exhibits? Until the court receives the exhibits?
Yes,
Do you
but
have-
again, I think we could stand right there and do one last thumb through.
Do you have the list of exhibit numbers for the record?
Yes, and I think, did I understand Peter just emailed you that? And,
I do have them. I mean, I have the list.
but I always want him to make 4 hard copies of everything. So, and is the plaintiff's counsel on that list, the email you just received from Peter?
Yes.
So I want to make sure there's no funny business here. One of the things that we inserted,
Well, we'll see what the jury think. It depends if you believe that he smashed it to her or she smashed it to him. So
which I don't think was clearly done.
I think
There were a
if
few of these before and after things addressed by Dr. Black. And we marked them as 101, A, G, H, and I. And those were not in the binder, and I couldn't remember. I would like those to go back to the jury, but I can't remember if Your Honor already ruled on that issue.
my opinion is
They
no.
were admitted. Well, anything that's on a poster would be only demonstrative.
Right, and this would be on a little piece of, a regular piece of paper.
Yeah, I don't think there were small versions of any of the poster board stuff that were received by the court.
Okay?
I
And
don't
so
know.
we may need to strip a couple things off the bottom.
It's fine, Kate. I mean, that's your opinion.
For instance, like
That's what's good about it.
Mr.
We can all have
Sanderson's
different opinions.
history, pre-collision medical conditions. Was that going back to the jury or it's not going back?
No.
All right, so we still have 5 minutes of adjusting to do on that.
Okay.
Oh yeah, not cheap. No.
Directed verdict motion may be made at any time, and
Okay.
we're ready to do that right now. I don't think it'll be affected by the exhibits.
All right. Great.
And just for the record, because I think it'll speed things up if we can.
Sure, Mr. Bueller. I guess
Mind-
whoever's going to make the motion, why don't
Mind
you
if
go
I
ahead and
sit down
proceed?
and just make those, or would you like me to stand up?
Why don't you come up here so I can?
Okay. This gentleman will go first.
Okay.
I mean, his defense, his plaintiff lawyers aren't cheap.
Thank you, Your Honor. This
some
motion
of the best.
is a motion for directed verdict on Ms. Paltrow's claim for attorney's fees. Under Utah Code 78B5825, attorney's fees are only available in Utah where there is an action or defense in bad faith. In civil actions, as you're aware, Your Honor, there's only attorney's fees to a prevailing party if the court determines that the action or defense was without merit and not brought or asserted in good faith. These are two independent requirements. They have not been met in this case. As the court's aware, we filed a motion for summary judgment earlier on in the case when Your Honor was not the presiding judge. That was denied based on questions that the judge had regarding the press conference that was held. And so what I want to talk about first is the standard for the court to utilize in the bad faith statute. It is narrowly drawn, and it's not meant to be applied to all prevailing parties in all civil suits. An action or defense is without merit if it is frivolous, if it is of little weight or importance, having no basis in law or fact, or clearly lacks a legal basis for recovery. A finding of bad faith turns on a factual determination of a party's subjective intent. A party acts in bad faith when he brings an action or defense and either lacks an honest belief in the propriety of the activities in question, intends to take unconscionable advantage of others, or intends to or has knowledge of the fact that his actions will hinder, delay, or defraud others. So therefore, Your Honor, an unmeritorious action, if that's how this turned out, and who knows, that's up to the jury, an unmeritorious action may still be in good faith as long as there is an honest belief that it is appropriate and as long as there is no intent to hinder, delay, defraud, or take advantage of the other party. That's what's key in this particular case, Your Honor. As the court's aware, the reason for awarding attorney's fees based on bad faith is to punish the wrongdoer, not to compensate the victim. And that fees should therefore only be awarded upon specific evidence of bad faith.
60
There is
grand.
no specific evidence. There is no evidence of bad faith in this case. This is clearly a he said, she said ski accident. We've heard the testimony of witnesses, of eyewitnesses. Mr. Sanderson had an independent witness that saw the accident. There were also experts who have testified that because of the location of his rib injuries, that he had to have been struck from behind by Miss Paltrow. There's clearly, and obviously the defense has their own side of the story, but there is
I need to put
clearly
it back up.
evidence-based support for his claims in this case. Further, his damages. The damages are clear. There's no dispute that he sustained 4 broken ribs. And then obviously there's the claims for the brain injury. Yesterday, there was a great deal of medical testimony that was brought by the defense. They all agreed that Mr. Sanderson was not malingering. So he is not, fraudulently or lying about his injuries in whatsoever. Ms. Paltrow from the very beginning has brought this claim for bad faith and attorney's fees as a weapon to try and compel Mr. Sanderson to dismiss this case. As I said, the summary judgment was denied because of this allegation, this loose allegation that, well, there was a press conference. So we've now heard from the defense. There has been no evidence brought forth by the defense that the press conference was brought to take advantage of Ms. Paltrow's celebrity or that it was in bad faith. In fact, the only evidence regarding the press conference was brought through my questioning of Mr. Sanderson, and he testified that it was his personal injury counsel that held the press conference, that it was their idea, and that the purpose of that press conference was to seek to find witnesses to the accident.
So there was a motion in limine that sought to exclude evidence that related, or I don't remember what the motion sought, but the result of it was an order from the court saying that evidence that relates solely to the bad faith claim isn't part of the jury trial. And so the court was contemplating that there would be, that if the jury found for the defendant, that the court would take additional evidence on the bad faith issues or those that related solely to the bad faith. Was that your understanding as well? And what do you think? What are your thoughts on that?
Well, I think, Your Honor, that there's been sufficient evidence that has come through through the trial that there is no evidence of bad faith. It's a very, very high standard to meet. And there's so much evidence here that shows it is clearly a he said, she said case. This was not based on Mr. Sanderson trying to have an ill motive. And there's a great deal of case law that I could go into, but I don't want to take the court's time right now on that. I think that the evidence that has been presented has been very clear that there is no bad faith in this case, that they could not prevail on that. And at this point, I really think that a directed verdict on the attorney's fees would be appropriate.
Okay, thank you. Mr. Owens? Do you have, well, first of all, I had 2 questions. Do you have more evidence other than what came in here today to support a bad faith claim? And number 2, isn't the fact that your directed verdict motion was denied evidence that there is a basis for the plaintiff's claims?
Yes and yes.
Okay.
I was precluded from talking about this stuff by their motion. So I can't be handcuffed and then slapped. I need to be able to defend a claim. I specifically wanted to talk about this stuff, but based on Kristen's motion, I couldn't. And now I shouldn't be slapped down about it.
So I would take the motion under advisement, Ms. Orman. I'd like to hear what additional evidence the defense has on the issue.
May I ask when you anticipate doing that? At a
Let's see.
later date, or is that today?
At a later date? Well, I guess it depends. I mean, if,
Not today.
when the verdict comes in, then we can make a decision about when to hear the additional evidence.
That's fine.
I remember raising this issue and said, Your Honor, did you envision then?
I remember
having
that.
A later hearing
Right.
at a time convenient to the parties?
Yes.
Thank you.
Mr. Bueller?
Good morning, Your Honor. On the issue of spoliation, there's a jury instruction. And we believe there's been no shred of evidence presented in this case that the plaintiff had a GoPro video. He denied he had a GoPro video. The only evidence is an email from his daughter who says, "Oh, I can't believe there's a GoPro." And
Daughter as well, Shay.
yeah, that's who I'm referring. But that doesn't mean. I mean, it could be anyone that had the GoPro video. Could have been the Deer Valley. Could have been anyone. But there's just absolutely no evidence. It was a mistake, and it would be absolutely erroneous if the court gives this jury instruction, because other than that mention in that email, which the defense, and there's been no evidence at all brought in this case that there's anything to it, would be clearly erroneous, and therefore we request that the spoliation issue be stricken from the instructions, as it would prejudice the plaintiff on something that has no basis, it has not been proven, that they have nothing. In fact, the late produced meetup.com comments verify that, because the defense had been saying or implying or insinuating that, oh, the GoPro video must be in that stuff because it was mentioned in that same email chain with the daughter, Shay, and there's just nothing there.
Okay.
Thank you.
Thank you. So I'm going to deny the directed verdict motion on the spoliation instruction. The defense, have you reviewed the instruction? There's a new one that came out,
Yes.
removing the word "the" from the bottom.
It's acceptable.
Okay. And Mr.
And the,
Bueller,
I've had two root
you're
canals.
certainly
Or
welcome to
okay.
to submit or request to the court some additional interrogatories so that it's clear from the record whether the jury made findings under spoliation or not. I think it could track the instruction itself. That way, if there's a verdict that's adverse to your client, you would know whether the spoliation instruction, whether there was any inference taken by the jury on the GoPro video.
Yeah, it gives more credence to the lack of evidence of this.
And that's
So
with it, though,
we'll
yeah.
consider that, and I guess we would have to do that pretty darn quick.
Yes, we would. I think that the daughter Shay testified that when she got off the phone, she thought there was a GoPro video, and I think reasonable inference from that, the jury could decide that there was a GoPro video and that your client had some control over that video. They could make that decision.
Right, but there was no evidence that he had control over it. It was just there was
Absolutely.
one. It was mentioned, and
Thanks for popping in
means
there.
that every time a piece of evidence that's mentioned that turns out to not have any basis, then it becomes a
What time's
spoliation
your root
issue.
canal?
We think that's an erroneous level of proof. I've got two others, or actually, and then finally, do you mind if I go ahead now, Your Honor? On the
Go ahead, please.
Okay. On the issue of
That's what I
negligence, and I'm going to talk
An
about both
infection.
defendant's negligence and plaintiff's negligence. On defendant's
Drugs.
negligence, at least for the record, we assert that there should be a directed verdict on liability, causation, and damages, and that is based on the evidence that's been brought before the court. Likewise, on the plaintiff's side, on the defendant's side, we should have a directed verdict in favor of the plaintiff. On the plaintiff's side, the charges from the defense against the plaintiff on the issues of liability, causation, and damages should also be brought. And I could summarize the whole case, but I don't think it's necessary. I think the court realizes that. But if you'd like, I could add more detail for the basis of that directed verdict motion. Two of them.
Are we talking about the $1?
Yes, the $1 that we would owe you. That's the second one. The first one is a directed verdict in our favor for our damages.
Just make sure your husband looked after you, yeah?
And, the only issue would be the amount of the damages for us. So I combined them
You
two.
beat
So
them.
it's actually two directed verdicts with three subparts each: liability, causation, and damages.
And I have given it some thought, anticipating your motion. And based on my review of the evidence, I would deny both motions with all three parts in both motions.
Okay, thank you, Your Honor. Then I have one other. It's not a directed verdict motion, but it's a motion to take judicial notice of Terry Sanderson's life expectancy according to the Social Security Administration life expectancy tables and calculation. This is something that's commonly done. I'll just advise the defense that we're planning to use in our closing reference to the life expectancy of Terry to calculate a per diem.
Have you disclosed to them what number that you plan to use?
Yes, I'm ready to do that.
Hi, Gio.
It's, you know, they change with each day.
Right.
And,
It was Stacey's birthday today. She's 61.
In principle, does the defense have any issue with that?
Well, he's got 20 some odd health conditions, some of which are impact life expectancy. So I have some problems about it, but it'd be nice to know what they want.
yeah, we're actually going to go lower than that. Would you like to approach?
Sure.
10 additional years.
Yeah, just 10 years, even though it says 10.8. It could be argued that Terry's he's a non-smoker. He has other
Stacey's
health
61 today.
factors in his favor, that he's conscious about his health. And so we just want to, in closing argument, mention that he has a potential life expectancy of this, and then argue that on a per diem basis for his future non-economic damages. Non-economic damages, as you know, are not precisely derived. They have, it's more of a subjective viewpoint of the jury and the parties' arguments in favor of.
How about to address the defendant's issues with, the comorbidities, let's call them?
They can argue that too.
I realize they can argue that, but how about to address that if what the court takes judicial notice of is that a person who is 76 years old has an approximate life expectancy based on the Social Security tables of 10 additional years?
Yes,
Is that
Your Honor.
that way? I'm not taking judicial notice of the plaintiff's life expectancy, but rather what the Social Security tables say.
Right, Your Honor. And
Or I'll give you 5 as it relates to Terry.
I know what they are, counsel. Let me just say this. We don't plan to reference the Social Security tables. It would be just as simple that statement that Terry's life expectancy could be calculated at approximately 10 years. And the past 7 years since the trial date, it's like taking cognizance of the.
How do I make that conclusion because it involves an individual?
Oh, you don't have to make the conclusion. I'm just more.
You just laid it out. I would.
Well, I'm just previewing what the closing argument will mention, and that it's not evidence
like
in the
those.
case. It's argument.
If I'm taking judicial notice of it, it is evidence.
Well, I don't think the court needs to take judicial notice, but if the court would like that, we did produce this. I'm just giving you a preview and the defense counsel that we will be making this argument that he could potentially have 10 years of life, and that that's the basis for our damage claim. And then we're not raising it to the level of something evidentiary. It's pure argument for calculating non-economic damages.
Okay. Mr. Owens?
I don't have an objection to Your Honor's approach, which is under Social Security tables 6-year-old man is expected to live 10 more years.
And Mr. Bueller's is proposing that not what happened,
Well,
but
yeah.
that they just refer to it in closing argument. I mean,
Yes.
not that they don't refer to any particular table, but they just say, a man at his age, he's probably got about 10 years. Do you have any objection to that?
In its argument. But if the court is inclined to not prohibit the plaintiff from making that argument, then we would ask that the court take judicial notice of what I just gave you.
They can argue it. They can argue it.
Okay, so you can argue it without any reference to the table or me taking any judicial notice.
Unless counsel wants reference to it or the court does.
If you're going to talk about Terry, I'll stipulate to 5.
No.
Okay, then we'll keep it as argument.
Okay, which brings up a very important point I wanted to raise. There have been a lot of evidentiary objections during the trial that a particular question misstates prior testimony in the case. What I want to avoid is a lot of that kind of objection happening during closing argument, that, hey, he's not saying what really happened here in trial, or he's misstating what really happened here in trial. I don't want to see a lot of that objection during closing arguments, because my reaction will be the same as it has been throughout the trial. The jury will remember what people said. So if you think that the other lawyer or lawyers say things that aren't supported in the record, then bring that up in your part of the argument.
Fair enough, Your Honor.
And so because what I expect you to do, with this one exception of this 10-year thing, I expect you to tether your arguments to the evidence that was in front of the jury and any reasonable inferences from them. Not to bring in outside data, not to bring in outside evidence, but just the evidence that was here in this courtroom. Okay?
Just to give you a sample, we would argue that Terry has approximately 10 years left, at least in his life. He's lived a healthy. He's not non-smoker.
And there's not any objection to that.
Thank you.
Okay. Turning now to the jury instructions. Does anyone wish to object to any of the closing jury instructions that the court put together?
We're reviewing them. I know you gave them to us yesterday. Give us one moment, please.
The only one that we might have a small suggested change or objection to, Your Honor, is the spoliation. Sorry, it's the spoliation instruction that we have here.
Okay.
It's that first sentence. We don't believe that there's been any evidence that Mr. Sanderson was in possession of a GoPro. And so we would want the first sentence to be changed to, Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. So it'd be because there's been no evidence put on that he possessed it. There's been an inference of that, maybe at best, but it's, again, coming through his daughter's email to him.
I think that's a reasonable request.
Because there's been no evidence of his possession.
It's more neutral, I think.
So it would read now.
Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed, period, and everything else remains the same.
Okay.
Any other objections from the plaintiff to the jury instructions?
No, Your Honor, as we looked through them yesterday, we were that.
Okay. How about the defense?
Your Honor, one thing I noted on the violation of a safety law instruction, the last sentence reads, if you decide that Mr. Sanderson and or Ms. Paltrow did not violate the safety law, you must disregard the violation. And I'm thinking maybe that should read safety law, because in the
Yes.
prior clause, there's no violation.
Thank you. That's correct. And then I did not include the inherent risk of skiing that the defendant requested. Is that one that are you dropping that request, or would you like me to give my reasoning why?
We want it, and we would like your reasoning.
Okay, here's my reasoning. So the defendants have requested a jury instruction that was entitled the inherent risk of skiing. And They were basing that on Utah Code 78B-4-401 and what follows, as well as the Donovan versus Sutton case. And so the courts reviewed those very carefully. A plaintiff asserting that a statute, and they're asserting that this statute provides support for the applicable standard of care, or that relates to the standard of care in a tort claim. And if a party is planning or is asserting that, they must demonstrate that the purpose of the statute was to protect a class of persons of which the plaintiff in this case is a member, or the parties in this case are a member, and to protect them against injury or death resulting from the kind of harm contemplated by the legislature. And that comes from the Colosimo versus Gateway case. Further, a plaintiff must show that the law was intended to protect persons in the plaintiff's or the defendant's shoes from the type of harm that befell them. So the Utah Code 78B-4-401, the Inherent Risks of Skiing Act, is not a safety statute as is anticipated to be read through a jury instruction, but a limitation of liability statute in which the persons protected are ski area operators, not skiers. The act is not affording any protection to the skiers against injury, which is the type of harm at issue here. So looking specifically at this instruction as it has been submitted to the court believes that this inherent risk of skiing proposal, this jury instruction proposal, circumvents the proper application of the elements of a cause of action for negligence to the extent it allows the jury to reach a result without following the principles set out in the usual negligence instruction. It also creates a substantial potential for confusing and misleading the jury. A jury could rely on a more general understanding of inherent risk of skiing and that it is simply an unfortunate and unavoidable injury causing event for which there is no responsibility, even though under traditional tort concepts, the accident was caused by negligence. Compounding this confusion is the implication that the inherent risk of skiing constitutes a second ground of non-liability. An instruction carries a substantial risk. This instruction carries a substantial risk of diverting the attention of the jury from the primary issue of negligence and has a significant chance of creating the impression in the minds of the jurors of a second hurdle that the plaintiff must overcome if he is to prevail. This instruction creates a spurious additional issue in the case when in fact the sole issue is the presence or absence of negligence proximately causing the accident. The jury is faced with complex, conflicting, and less than compelling evidence, and the imprecise rules of causation and comparative fault create a significant temptation to abandon a rigorous application of the instruction and the elements of negligence and the burden of proof and return a verdict based on the simple notion that an accident was an inherent risk of skiing or somehow unavoidable. Apart from the inherent confusion, the instruction tends to reemphasize the defendant's theory of the case that the defendant was not negligent. To that extent, the instruction then constitutes an inappropriate judicial comment on the evidence. Of course, there are collisions caused by the inherent risk of skiing for which the defendant or defendants are not negligent. In such cases, if supported by the evidence, the defendant can certainly argue that they were not negligent and that the accident was the result of an inherent risk of skiing. And I think that would be appropriate argument in this case. So defense can certainly argue inherent risk of skiing. There's been evidence of inherent risk of skiing. They can argue that neither party was negligent and this was purely an accident, and that neither party was negligent. But in terms of the court reading the instruction, those would be the reasons why I've declined to do so.
Your Honor, I actually misspoke earlier. I think I've got one thing that I just noticed to other instructions if we're ready to move on.
Sure.
On jury instruction, page 16, mitigation of damages. I believe the second sentence, it says, any damages awarded should not include those that could have, I think, been avoided needs to be added in there.
Thank you.
Thank you.
Do the defendant have any other exceptions they want to take to the jury instructions?
Yes, Your Honor, thanks. Yesterday, are you okay if I sit here?
Sure.
Yesterday, Your Honor granted a directed verdict on behalf of the defendant on the issue of post-collision hit and run. Help me if I'm missing something, but we previously provided to the court defendant's proposed instruction 45 entitled Gwyneth Paltrow did not hit and run and flee the scene. I have a copy. It's marked up if you want it.
I've got it here.
Just finalising the closing arguments for the jury instructions, sorry.
Your Honor, I think the denial of the directed verdict, it doesn't use the word hit and run. And what we talked about yesterday was post-impact or post-crash conduct is still relevant to the
Yeah, the failure to render aid portion of the ordinance is still being read. It's the failure to give a phone address and contact information that was directed out. So if you have an instruction that relates to that, I'd be glad to consider that.
And it also included Dr. Goldstein's testimony. That was also the basis to demonstrate the availability of the post-crash actions or events.
So do you have
Yeah,
another instruction that's more closely tailored?
I think the first sentence of the two sentences. So Your Honor chose to split the issue and this is the heading. So the first sentence is what we want. I have already determined that Gwyneth Paltrow did not hit and run and acted maybe that's the extent of it.
Your Honor, I think that's inappropriate. It's preloading an issue that what is an issue. It's not something that we're asserting, and that there's the motion in limine stands for, and we think that we could put in a lot of things on both sides that are at this stage irrelevant and distracting. And
There's been
prejudicial.
There's been evidence as well as argument, opening statement and cross-examination implying that the defendant left the scene without giving, in violation of some ordinance or some requirement that she give her contact information. So what I could read is that I have already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information.
That's reasonable, Your Honor.
So you know, my heart, Aaron. Thank you. Mwah. Why, do you girls want to go on Tinder
Any
after
other,
or free
from the
holidays?
defendant, any other exceptions?
Yes, Your Honor, and you did rule on this, so I don't want to irritate you, but Deer Valley's resort's dismissal, I do like the words "for no payment," and this was previously argued. I'm rendering an objection. I always get a kick out of this idea. It's so obvious we don't have to say it. Well, then why don't we just say it?
That's noted. I mean, the instruction's already been read. It's in the opening instructions. Any others?
Yeah, I think it's all they decide to can't be on them after this trial. Yeah. Yes, but free
Your Honor, I've
holiday.
had a lot of paper thrown at me. Is the oral argument, is the, jury instruction that says if you find that there was no negligence, you can disregard the remaining damages instructions?
You'll see that when we get to the special verdict form. It's incorporated into the special verdict form. It indicates that if you find no negligence on the part of either party, you sign and date the form and turn it into the court.
So I think in the opening instructions, it said something to that effect. There is a standard emoji that says, I'm now going to instruct you on damages. If you find that there's no negligence, you should disregard these instructions.
Okay, yeah, it looks like it's on the introduction to tort damages page. I think it's 12 or 13 in your packet.
That's that. You get a free holiday,
Thank you.
and
No
you
other
don't have to have sex with him.
Okay. Turning to the special verdict form, I realize you
Unless
just
you want
got my
to,
version
well, then
of
it's
it.
shit.
Have you had a chance to decide whether this meets your needs? I took this from the Florida claim counterclaim verdict form. I took the
Can't date
concepts
anymore.
here.
What a shame.
Your Honor, oh, you printed it. Sorry, I was looking on my email. I see. Thank you.
Did you get that, Mr. Bueller?
Yes, we did. And we're just
Well,
wondering if,
sure.
before closing argument, we could get another copy because to counsel, I think.
Sure.
You don't have to have
I
sex with
just
the guy.
wanted to, there's one
No
change
pressure.
that I think I might need to address with you whenever you're ready. And then we'll have to print out new copies.
So what we need to do. This is a second exact copy.
Thank you, Johnny.
Oh. So they're just finalising everything. Jury should start in 9. I think he's pretty. How can he
I mean,
be
we
there?
can
His
wait
lawyers.
to look at this until we just before reading jury instruction, because I would like to read this to the jury during that part of things. If you're not quite ready.
He probably is confident. You're right, but how?
Can we tell you in 2 minutes?
Sure.
I think everyone knows that Gwyneth threw in this trial.
The one I can tell you when you're ready, it's the one change that I see.
The
It's 2/3 of the way down on page 2. When you get to the bottom of the comparative fault questions, there's that separate section. Just above the damages line, it says, if Terry Sanderson's fault is 50% or more, rather than proceed to question 9, because that one's already filled in, I suggest that we just say, sign and date the form and turn it into the court.
we all are. I think most of us are. That's that. I could think if we came into this, probably most of us go in,
Yep.
just pay him. Now it's like, don't you fucking dare pay him. Also, there's going to be a separate hearing for whether Gwyneth gets her lawyers paid for and stuff. That's for another day. Oh, we're here with last day, guys. Well, I mean, verdict watch then, but
Am I thinking that through right on the comparative fault? If Terry Sanderson's fault is less than 50%, then you answer the damages question. If it's 50% or more, you just sign and date it, and that means that the $1 that's been assigned to Gwyneth Paltrow is the counterclaim.
still don't get how this got to trial, but not on Gwyneth's side, on this guy's side.
Your Honor, it doesn't necessarily mean that if Terry's fault is 50% or more, that the defendant's doesn't have 50% or more either. Or, stuff happens, inherent risk of skiing, accidents happen. The jury could deny awarding the $1 to Ms. Paltrow. So
Well, if they put 50-50 on the comparative fault questions,
Yeah, then it would
then
work,
there
but,
would be no recovery for either side, right?
right, but there's the possibility of, I guess they'd have to do that exactly, but if there's this other, is that what we're thinking, co-counsel? Pete?
In other words, I guess what I'm saying is I think there's enough information in these answers to help us to create a judgment based on any scenario that they come up with.
I think that's acceptable, Your Honor. I think that would change.
It seems like that to me, Your Honor, as well, but I just want to make sure that one of
Sometimes
the,
a flow chart's helpful.
yeah, that's true. It'd be nice if one of the questions, or it's important, obviously, that one of the questions allows them to connect Terry Sanderson's fault to the, say that it caused Ms. Paltrow's damages. And do you see that as covered by comparative fault questions? Because number 4 just asks whether his fault is a cause of his own harm, not of Ms. Paltrow's harm. So you just want to make sure that causation
Oh, I see that.
question
I see
is
that.
addressed.
Should 4 read just like 2, counsel?
That was my thought, and then the comparative fault questions address whether Terry Sanderson's fault caused his own harm or to what extent.
In other words, if a party's fault caused the other party's harm, is that sufficient? Or do we need another question, or does that question need to be modified to say, was a party's fault the cause of their own and the other person's harm? The other party's harm? How would you like that to read?
Number 4?
I'm fine with it, just, with us redrafting 4 to read like question 2.
Right, and then any self-harm is captured by the comparative fault questions. That seems reasonable.
That seems reasonable to us too, Your Honor.
Okay. So the question 4 will read now, was Terry Sanderson's fault a cause of Gwyneth Paltrow's harm?
I hope they're going to dumb it down for the jury because some of the wording in legal speak is just too much.
Your Honor, the title of these sections, Gwyneth Paltrow questions, that should it be like defendant Gwyneth Paltrow questions, or should we eliminate that at all? I'm just posing that as a question because it seems kind of she's not asking that, we're asking that, and the vice versa.
Questions on Gwyneth Paltrow?
Yeah, above number 1, the title underlined in bold says Gwyneth Paltrow questions.
Just take the word questions out.
I just, it makes it sound like they're asking it, but in reality, we're asking was Gwyneth Paltrow at fault, not Gwyneth Paltrow.
So how about if we just label it Gwyneth Paltrow?
Right, or does it need a title?
I think it helps direct their attention that we're talking about her actions.
Right, I see that.
Just eliminate the word questions on each of the headings.
Yeah.
Let's do that.
Because it implies that she's asking that, and
I can also delete it under comparative fault, and we'll just call it comparative fault.
yeah, I think that makes more sense.
May I go to 8 and 9 just for one moment?
Yes.
We're nitpicking, but Judge Tom Green used to say, if we don't get this right, we get nothing right. So number 8, what if we said, what amount fairly compensates Terry Sanders for non-economic damages? There's a bullet point that I don't understand.
Yeah, I took this off of the plaintiff's form. That's the way the standard Muji does it, but it does it when there are more than one category.
True.
So yeah, that could simply be added to
So
it.
that for non.
The only thing I
economic
thought about
damages-
was that it clearly says non-economic damages, and there is a jury instruction that is entitled that, as well as the number 9 clearly says economic damage, and there is a jury instruction entitled economic damage.
And for the economic damages jury instruction, perhaps it should just say Gwyneth Paltrow seeks $1. I don't think they need to even need this big instruction on economic damages.
What do the plaintiffs want on economic damage?
Well, I think as the court pointed out, I think we already have the instruction. We've been working on the instructions for a while. We like to have it in there, and I think it clearly is indicated here on the special verdict.
What I like about it, Mr. Owens, is that it distinguishes the non-economic damage.
Okay. And then number 9, I would just say what amount fairly compensates Gwyneth Paltrow for economic damages?
Hey guys,
Uh,
today we are talking
Delete
about
the bullet point and the ...
Okay. Is the plaintiff okay with deleting bullet points and the ...
and the empty space to the right, the blank.
This is on number 9.
On 8, I think it's just.
This is
supposed to
on-
align to
This
fill
is
out,
on
right?
9.
8 and 9, just take out the bullet point and the dots.
And just include it as part of the sentence.
Yeah. And then what's this business of a blank space?
Under where there, I think at number 8, there's a missing line to fill out that line for damages for Terry Sanderson.
I'm not following you.
You want a blank after the $sign?
No,
What?
no, there's line underneath to fill out.
On question 9?
No, it doesn't matter.
Agreed. That line shouldn't be there.
Just sort of a green line.
I'll do my best.
They're complicated, Your Honor. When I was doing our version last night, their tables are part of it.
They're tables. All right, so why don't we take just a short restroom break? Mr. Sykes is now here. Good morning, and then we'll bring the jury in.
Your Honor, can I mention one thing?
Sure.
We filed a pretrial motion on rebuttal witnesses, number 12, defense pretrial 12. It was granted. It sought to give you a little bit of a bench brief on the narrow scope of rebuttal witnesses. In short, they are not to just restate anything that could have been stated in their case in chief. I even had a judge in Logan literally say you can ask like 8 questions and he can say yes or no with one sentence. I mean, and I was on and off in about 3 minutes because those were the only brand new issues that they couldn't have predicted. And so we asked that this rebuttal witness be strictly limited. It's not used as an opportunity for the plaintiff to just restate and sort of get the last word on things that.
So we talked about this when the motion came up, and the court agreed that these are rebuttal witnesses. They're not to strike off into new territory. They're not to clarify. They're to respond
Correct. They're just.
to issues that came up in the defendant's case. And then, of course, on the counterclaim. All right.
Brand new
That's
issues.
all. Basically 3 questions, Your Honor.
And who's the next witness?
It's Richard Bain. We're just waiting for him to get on the Zoom.
Okay. While you do that, then we'll take a short recess. Thank you.
Hey, so
As long,
What did he do?
unless it takes longer to get him on the Zoom. Let the bailiff know as soon as you get him on the Zoom.
we're nearly there. They've not confirmed how many witnesses yet. Well, they've got a rebuttal, but the first one's on Zoom. We should, last night the judge said we should have a jury in place deliberating from about 12 o'clock. So I think it's going to be one break, probably after rebuttal witnesses, and probably break between the closing, remarks, and then done. It's going to be strange having this one finished now. I'm glad it's finishing, but I'll obviously do a watch party. Just, I don't know, you have to go to bed like 1:30, 2 o'clock in the morning, get too old for this crap. Let's sort that. Oh, Rumble's quiet. Strange. Hmm. Sorry, Rosie, I know. I feel myself at this time of day always nodding. Rosie, I'm so tired today. I felt myself drifting off just now. And it's like, so I'm relying on the chat to be busy, you know. We've got 5 people here. We still got 25, 30, 40, 50 sometimes. What's wrong? We got the loyal ones here though. We got the best ones, so it's all good. Rumble, I've only got 2 watching. Twitter 1. Oh, I love a power nap. Liz. It normally turns into more than a nap sometimes. So, but this morning I had one. Got a few hours breakfast, went for a walk, shower, sat down, drifted off for like 20 minutes. I woke up. Stacey's gone to watch the movie. It's her birthday today. She's 61. She might be back later on. Every time I speak, I mean, genuinely, we drop numbers. We've gone from like 11 down to 4 earlier on. I start speaking. Discrimination is called. Discrimination against the Welsh. Not fair. I'm trying not to shout today as well. She's awesome, isn't she? I need to get a better picture so my double chin's not in there. Giovanna. Giovanna, you've become a regular now. You're in the clan now. You're full time now. After this trial, there's nothing now till 10th. Ooh. Oh, get down. My instructor cancelled my training this morning. You know, when you're ready, you're pumped up for it, like, let's go, psych yourself up, you're ready to go, and then it's cancelled. It's like, normally I'm like, yeah, I don't know. Yeah, she's always on Twitter, that's that. Always on Twitter, she is. Never working, always tweeting. Oh, oh no, I'm so bad for me going in, yeah. The this is well, I mean, tomorrow, if they don't come back today with a result, which they should, if we come back with a murder verdict in less than 3 hours, I'm sure we can get this verdict in less than 3 hours. Um, if we don't get one though, tomorrow I'll stream tomorrow. Yeah, they did. They did. Well, I don't fight. They were let go, but it could be a case of them. One's an actress. I'm not sure where she was working as well, and one was like a working in high school or something as an advisor. Somebody came in yesterday, says Anderson's Zachary Anderson's brother is speaking today on some stream. So if I find it or you find it, send me a link and we'll stream it because we go all afternoon if you hang around. I'm eating yawns here. I'll put some Peter Trigo stuff on. He's done some analysis on this case. I'll put him on. There's a couple of Brian Kohlberger stuff we could put on. Um, Never mind, thank you. Oh, no worries. Melissa joined yours. Well, she's not joining mine, Melissa, if you're out there. Oh, you're joking. It's a pleasure. Hope you enjoyed it and it went well. Who's he having? Is he having the sisters or the brother? Yeah, no, Melissa always just pops in and says hello. But she told me last night she was fed up of this trial. So I was like, cool. They're just on break now because they've just basically done the jury instructions and now they're just trying to set up Zoom for the rebuttal witness, the doctor. Oh, good, thanks, Erin. Oh, okay, okay. I said my stream it, but there's no point us me streaming it. You just might as well watch it. Okay, keep an eye out on that then. Legal Vices. Legal Vices, all right, yeah. Okay. To be fair, I had difficulty finding it as well. I had to go in and filter it and go to channel. That's how I got it. Yeah, if you filter it, you can find it. Not channel. I had the same. I typed it in, crime spies with a space and everything. Wouldn't show up. I had to put channel, and it
Hey,
came up.
Dr. Mann, can you hear me?
I'm not instructing you.
So they are back. Jury will be called now. I think it will come though. I think mine's probably the same. Some people say they can't find mine, so don't worry about it. I think it depends what time of day and stuff it is. I'm excited. Today's potentially last day. It's been a slog, but we've done it together. Ooh, spy video, secret spies. Ooh, Giovanna. Um, okay. So they're on mute at the minute. They are there. And once they start speaking, I will go into my small little box. Oh, and what I might do is get a coffee. And also, Shannon, Rumble's crap today. What do you got? Oh, I got 5 watching now. 6, sorry. No, 5. I normally have 20 or 30 on Rumble. Also, remember those of you that are here, say something in chat and you automatically entered into the competition to win $25, giving away 10, $25. I've had 190 subscribers join in the last 24 hours, but none of them entered the competition so far anyway, which makes me worry that I've got all bots. You know, you get some bots out there that see the competition and they join it. So I'm a bit worried about it's them. So once the competition's done, they'll just leave. That piss me off. But they're not going to win any money because I don't know who they are. But everybody in this chat, um, well, numbers will go up once I get the guys rolling. Well, yeah, I mean, Shannon, look at mine. I've been doing that for 3 weeks. I've got 7 here at the minute. I sometimes only have 4. But the other, a week ago we had 60. So you just don't know. That's why I've always said from the start, it's not about rushing to get stuff for me. It's about building community. So you've got solid base, regular people. You do stuff. That's why everyone here now are regular people. So as in they've been here from the start. And I'm gonna do, what do you call it? I hope you guys win the prizes. I'd rather give you guys the money than give some other fucker that's not supported from the start, but especially if they're bots. There we are, well done, Shana. I had music at my intro today as well, so I'm slowly getting there. I'm just gonna change my layout as well in a bit. Probably by next week. Big Mike didn't show up. Big Mike's gone. He's gone. Some of the streamers got him now. Won't give him back to us. It's a shame. And Chrissy, I think she's had enough of this trial, so she's not here as often either now. And we've missed a few people as well that were here at the start. They've not come back, so but then we gained a lot of other people, so drips and drabs, as they say, drips and drabs. I mean, yeah, like if I can figure out, you can figure out. It does come. I think it just comes with practice and with trial and error. I'm still doing trial and error. Do you know what I mean? So it'll come, Shannon. It'll come. Also, what you feel comfortable with as well. So I think they're coming back here now. I don't have too many chords. Or you've gone more technical than I have. I haven't got no sound bar or anything. Sorry, I mean, you see, this is what I mean. Not every stream gets this straight away. Straight away, enough that's on it. Do you know what I mean? Enough of that is on it. And I'm guessing everyone here subscribes. Only 8 of us, so I'm guessing everyone subscribed. So how many? Oh, I need to go launch that one then. 5 likes, 6 now, because I've liked it as well. 6 likes. Whoa. And there's 8 people here. Come on, people. Yeah, I mean, price-wise, you like stuff before it even fucking starts. Here we are, right. Yeah, exactly. Yeah, exactly. That's why hopefully we get more and stop starting and fine. Like the day we had 60 odd in here, that just came overnight, as in straight, and I think that was because of the likes and stuff. Yeah, don't worry. It's my stream, and I need a reminder as well. So I only just liked it as well, Erin. So don't worry. That's why we got enough that she's like military precision. 7 here now. But if you think about it, we're still missing like Mel. She's normally in and about. She didn't come yesterday. Don't think she's coming now till next week. Stacey's not here. Christy's not here. All that. I mean, that's a dream, isn't it? But I think we're so far away from that one. You know what I mean? I think I can manage 7 people just, but yeah, I'd love to have mods and people involved in it. And that's what, again, people think I take the piss when I say it's a community. It genuinely is. Like, you know, if people enjoy it and want to contribute, then happy days. You know? So, yes. Politics, yes. Well, I remember you. Of course, I fucking remember you because you won't leave me alone. So I won't have a choice. Can you imagine? I have to block you. No, I'm a loyal person. I remember stuff. I remember people who helped me out, and I've had people out in the past, and it's what you do. You pass on. I took a risk to start the channel because it's like I don't make any, I've had any money on anything, so try to make a career of it. But I need loyalty back, and you guys are
May be
loyal.
seated.
So,
Are we ready
fucking hell.
to bring the jury in?
No, Your Honor, I'm grabbing some.
Okay, all right.
Right, I'm turning that to Gwyn. Looking sexy. So, yeah, I remember you. I'm going to do some membership groups and stuff like that, like, for people. I'll sort something out, but I need to get regular stuff first. But I am going to try and do membership groups and stuff. I don't know what I'm going to do, to be quite honest with you. I'm not sure. I'm not the type of person who likes to ask for things. Like I put the coffee thing in the link. I hate doing that. I don't like it. And thanks to those that have, you know who you are, and I'm really grateful of it. But I hate it. I've never had to ask anybody for anything ever. I've always worked for everything. I'm working for this, but sometimes you need a little push, and that's why, essentially, that's why I try to give everything I get, I give back as much as I can. That's why I want you guys to win some of this money, we're getting close. We've got 439 subscribers now. It is bonkers. I'm worried because a couple of weeks ago, it's a load of work. I work like 16, 17-hour days, 7 days a week. I'm not even kidding. But I love it. And I do it because of you guys. I'm not saying, oh, I do it for you guys. I love you. It's more, but if you weren't here, I've got nobody to do it for. So,
how do you guys?
Ready for the jury?
That. You'll be a mod, don't worry.
Test.
That's why it's loud. It's on Zoom.
Okay.
I hear you guys. So how do you read?
How's that for everyone else?
Looks like the video's a little slow, but we'll have your audio, so.
We'll check you once he starts now.
Thank you.
Roger that.
I agree. I did that same. Just watch TV and just thought, you know what? I've got nothing, like, I've got no career at the minute, so let's give it a fucking go. I've always wanted to do a YouTube channel, but never been brave enough to do it. Because, like, ultimately, people mock you for it, judge you for it. I don't care about strangers, but your family and friends. Like, it can be an embarrassment, like, you know. But my nieces, I thought I'd embarrass them. They love it. I'm cool again, so it's worth doing it. So anyone that wants to start a channel and stuff, do it. Or not even channel, but anything you want to do, guys, just do it. It took me years to do this one, and
Say, would
taking a
council approach the bench?
I'm taking a big risk doing it. But
I need to show you.
yeah, you just got to risk it. There's a guy that, not to get down here, but there's a guy in my village who committed suicide last week, just to end it all. It's like, and he's, what was he, 20, 28? He's got a child on the way in 2 months, and I'm not trying to put this into, oh, I shouldn't have said that word, should I? But anyway, puts things into perspective. Just got to go for life. He did enjoy his life. Just got to go with it. Take risks. Like I say, I've got no job. This is my full-time job now. So I've always worked for other people, worked my heart out, and I was like, let's work for myself for once. So I think it puts things in perspective. Go for stuff. Risk it for a biscuit. Do you know what I mean? This is my inspiring speech. But that was an eye-opener when I heard that, you know, he died and stuff. It's like, oh, horrible to hear stuff like that. So that's why we're all gonna end up like that one day, as in 6 feet under or in the clouds. So who cares if you embarrass yourself a little bit? Put yourself out there and give it. And if this fails, it fails. Like, I'm not afraid to fail, but I don't suppose you guys will let me fail. So, you know, sorry for bringing the stream down now a little bit. Oh, thanks, Eric. Yeah, you see, this is what I mean. There's the same supporters I go all the time, you know. So, thank you guys. So Shannon, when you said I'd forget you guys, I'll never forget you guys, ever, ever. You know, you coming with me because I totally believe in loyalty, totally believe in stuff like that, and support. Because I don't care who you are, unless you've got support. So that's my aim to always. Okay, I'm giving out a little bit too much in this competition. That's my own mistake, but I always look to do competitions for people in the community, you know, and that support me. I want to give back all the time. I understand that this doesn't make much money, but the more followers you have, hopefully, you know, the ads and stuff come in, and I don't know, it'd just be nice, and to give that back as well, you know. I just want to live a comfortable life. I don't want to live a lavish life. Thank fuck. Otherwise, I wouldn't be doing this. But thank you, Erin. Thank you, everybody, for your support. With that, you don't need to listen to my nonsense. The trial is about to start. Half day left. This is
Good morning,
the
members of the
now.
jury. Sorry
Can you
for
get
the
the list?
delay. Just be assured that we've been working very hard, and I think the rest of the morning, as a result, is going to go much smoother and much faster. So, thank you.
You've got a slow clap of you Vikings.
Mr. Bueller?
Plaintiff Terry Sanderson calls Dr. Richard Bain on rebuttal.
Mr. Boehm, I'm not sure if you can see me. This is Judge Holmberg speaking. If you could please raise your right hand to be sworn in as a witness.
Hi, Spider Girl.
Governor, I do not see you. I just see my.
Do you
Scared the
swear
shit
that the
out of me.
testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, reporter.
Once again, Dr. Boehm, if you could state your full name and spell it, please.
It's Richard Bain, spelled B-O.
I think that's Boehme. Can you hear me, Dr. Bain?
That's affirmed. I can hear you loud and clear.
Okay. Thank you. I understand you're on vacation and we appreciate your time. Dr. Bain,
Yes, I am.
Dr. Bain, in trial testimony this week, the defendant's expert, Dr. Irving Scher, disputed your findings regarding the ski collision between Terry Sanderson and Gwyneth Paltrow on February 26, 2016. Have you had a chance to read his trial testimony? Did you say something?
Yes, I have. I read his.
Okay.
Doc, we're losing a few of the words there.
Yes. So maybe Dr. Boehm, if you would start off your speech with something that will then kick in the audio so it here.
Yes.
So here's my answer, something like that before you answer.
Roger that.
Okay. Dr. Scher suggests that you made an error in your calculations. How would you respond to his suggestion?
Here is my answer. Dr. Scher mischaracterized my analysis, which led to his analysis being misleading and incorrect.
Okay. Could you explain that in more detail, what the analysis is that you want to correct?
Sure. Well, Dr. Scher first wrote up the impact force formulas, and he labeled one of them wrong and one of them correct. And both of them are wrong. And why? First of all, the equation F equals 1/2 mv squared over d, where he substituted 1/2 AT squared or 1/2 AT and then AT in the parentheses for velocity. You can't do that without solving for time or t first. Basically what you have from a mathematical standpoint, you have force and time, which you don't know. So you have two unknowns in one equation. So basically the equation is unsolvable. So you have to first solve for time. And you guys have there. So if you go over to the first one where you have x equals x0 plus b0t plus 1/2 AT squared, you have to know the height at which Mr. Sanderson fell to the ground.
Dr. Bain, could you share your screen and show us your calculation? Let's see if I-
This is really bad, though. Be right back, guys.
I don't here, and I'm trying to have it. Let's pull it up over here. Do you have it?
Not yet. We'll try to share it here. No.
See that?
Just give us a second.
Unblur our screen.
Just a
I'm
second.
going to show it to you. All right.
Okay.
All right. I'm just had to unblur my screen, show it to you, but for my exhibit, 0 plus d f AT squared for time. So the height at which Sanderson found, which is X over T, and you can see that less than a 0.46. Okay. The second, are you substitute time in for to determine the who are falling downward. We know what it is because it's Earth.
Dr. Bay?
Everywhere on this gravity is constant. Oh, if you
Dr. Bain, we're having trouble hearing you. If you could avoid the pauses, it might work better.
do that. So you see the 1/2 with it there.
Your
Now,
Honor, we're getting about
been
a fourth
working
of
out.
what he's saying, so this either needs to
Dr.
be
Bain?
fixed or stopped is our motion.
Yeah, Your Honor, let me just try one last thing.
Okay.
Dr. Bain, could you stop your video and then just talk once you've shown the formulas? That way the
Yes.
signal might be clearer.
Right, IT guy will.
You got to stick out, go, no, my dick is bigger than the other
No.
doctor's dick. That's all it is. Dick measuring. And Terry's in the middle. Got to measure his as well.
Sorry, counsel, but it
All
doesn't sound
floppy.
like it's going to work.
Why don't you call him on the phone?
Phone would work?
Yeah. Dr. Bain? Dr. Bain,
Sir,
can you hear me?
yes, here.
Can we call you on your phone? And because we're having technical difficulties with the video and the,
Roger that.
okay, should I call your cell number?
On the iPad, if that gives you,
I don't see that. I've got other numbers for you. Can you?
I mean, this is pathetic. The thing is, the jury won't understand any of it. They're just going to go,
Can I call your cell number? Well, I guess he's.
okay.
genuinely, we've seen what we call in the UK dick measuring contest. I'm not sure if you call it the same in the US, but that's what it is. A doctor has had his nose put out and gone, no, the other doctor doesn't know what he's talking about. I don't think it changes the results one bit. Don't film Gwyneth now, guys. I thought that they were going to give it live. I thought, oh my God, mute, mute, mute.
I'd like it removed from the jury's view until it's discussed.
We're in court. We're trying to talk to him on the phone. During the trial. What number should I call you? 801-699.
Well, this is a disaster. And this is all counted towards the end time as well. So I think they've got plenty of time, though, to be fair, but still. I mean, the judge is like, well, we can't go to recess because we just had a break. What's his name? The judge what? Because I like him. I can't make out. My eyesight's too bad. I like this judge. Judge. Oh, court. And again.
Can we put a time frame on this?
whole.
And they know what their time is that they have left, so.
Okay.
Exactly.
me to FaceTime or what?
No, we're just going to do it by audio.
Oh, no.
Yeah, just you're live in court. That the jury can hear you.
Roger that. And so do you have my equations up?
Are those the equations?
You can stand it, guys. Just leave it.
There they are. Okay, Dr. Bain,
Sure.
we've got your equations up.
Okay. So do you have the sheet where it starts off with x equals x0 plus v0t and so on?
Yes.
Okay, perfect. All right. So as I was saying, should I continue, sir?
Yes, please.
Roger that. So in order to make the equation work, you have to solve for time, which is t.
Oh my God. Come on. You can't be serious right now. I mean, I see it, but I don't understand it.
Would it make sense to take your next witness while someone is outside trying to reestablish?
This is our only witness.
Okay.
And Your Honor, may we approach for one moment? I'm seeing a potential problem. I guess I could just bring it out while they're calling. I was prepared in cross to maybe show Dr. Bames some documents or even draw some things. I wasn't sure whether I'd get into that, but depending on what I hear, I was going to do that. I know I don't have a ton of time and maybe I decide not to, but this obviously makes it so I can't do that, which is a problem. I decided that I
both
wanted
parties
to.
are going to be hamstrung on this. So why don't we take it as it comes?
This judge is so good. He's so calm. Nothing phases him.
We do. We lost you. We lost you there.
Just look at the phone to see if we're still connected. But in any event, once you get the time, 0.466 seconds, that's the time it takes to free fall from a specific height, X, which is measured on Mr. Sanderson, which is 3.5 feet to his ribs. And then you substitute T into the equation velocity equals 1/2 AT squared. In this case, typically for free fall equation, it's V equals AT. Now, the reason I put the 1/2 in there with the asterisk, and keep in mind, I've been on this case for 2 years, and up until this point, no one has ever asked me why that asterisk is there with the 1/2. Well, keep in mind that those equations are for free fall events. So if you're suspended in the air by X, 3.5 feet, and you are dropped to the ground, that's the velocity that you would get. However, we know that Mr. Sanderson is not suspended in the air when he collides or when he makes contact with Ms. Paltrow. So he's actually standing on his skis, so he's standing upright. So when he falls to the ground, it's not a free falling event. And you can appreciate that because when he falls over, the speed of his feet that hit the ground is 0, whereas the velocity of his head is certainly much greater than the velocity at his feet. So you have to know, which I took his measurement in the office, how high the point of interest is, which is his ribs, because that's what he fractured in the collision.
So once you do that, you substitute the 1/2 AT squared asterisk into and that turns out to be 2.29 meters per second. And you put that into the impact formula, and then you obtain what the impact force is. So the equation should be written Fi, impact force, equals 1/2 in parentheses V sub T asterisk all squared, and then over D, the distance through which the energy is transferred from the ground to his ribs, which I measured in the office. So you have to know those quantities and understand that this is not a free falling event. So that's the big difference here. And once you have the 2.29 meters per second and you substitute that in, and you just use Mr. Sanderson's weight as the mass in that equation, you realize that there is not enough impact force to fracture those ribs. So there has to be a mitigating circumstance, i.e., something fell on top of him in addition to him falling to the ground to cause those ribs to fracture in an otherwise healthy male. And so when you do the calculation, the object, and typically to fracture ribs on the lateral side, which is where he fractured his ribs, takes about 4,000 newtons, thereabouts, plus or minus 400 newtons, 4,000 newtons plus or minus 400 newtons to fracture those ribs. And when you work backwards, the mass required to do that indicates that the object that fell on Mr. Sanderson had to weigh at least 100 pounds. So based on what I know about this case, any
That's how we all
human
feel.
that weighs greater than 100 pounds falling on Mr. Sanderson onto his right side, fracturing those ribs, would qualify as a traumatic event from an impact force calculation standpoint. Now, so once you understand that, then you start to consider other possible scenarios as to, is there any other way he could have fractured those ribs? The only other way he could have, if you consider him striking Miss Paltrow from behind, is that if he were to do that, he would have to generate a rotational force on him and Miss Paltrow, resulting in him falling on the ground and Miss Paltrow falling on top of him. Okay? Now, keep in mind, as I already calculated, you look up there, it took less than half a second to fall to the ground. And so for him to ski into Miss Paltrow and then rotate 180 degrees to the ground in less than a half a second requires a rotation rate of greater than 400 degrees per second. Now, Olympic divers, that is, when they do their twisted and turnings on their competition dives, don't generate any greater than 400 degrees per second on their dives. And then when you take into consideration Newton's first and third laws,
yes,
you know, Miss Paltrow is certainly not twisting and turning if she's struck from behind. So in order for her to rotate around with Mr. Sanderson has to, according to Newton's first and third laws, grab her and then take her to the ground in a twisting fashion where she lands on top of him. Now, Olympic swimmers, if they were to grab 100 pound weight or more and try to do those rotations, that's just not going to happen because the center of gravity is too far away from the moment or the initial point for rotation. So that's probably not going to happen. But let's hypothesize that this did in fact happen, which is highly unlikely. If Miss Paltrow landed on Mr. Sanderson and he landed on on his back. That means she landed on his chest. And if that were to happen, the ribs would not fracture on the lateral aspect of his chest, as we see in the medical records. So we know, based on that and the low probability of the rotational or the angular velocity, that did not happen. So that only leaves one possible scenario to satisfy Newtonian physics, the Mr. Sanderson's measurements, and his medical records, and that means that he was struck from behind, went down onto his right side, made contact with the ground with his elbow. The energy was transferred into his ribs that fractured the ribs. Now, I would like to add that had the rib fractures not occurred, no one would be able to do this analysis, period. And that's all I got to say about it.
Thank you. That's all for me. Defense counsel, question you next.
Roger that.
Yeah. He's trying to put a timeline on it, but you're right.
Mr.
We'll see
Egan?
what the clock's going to
Thanks,
say.
Your Honor. Am I to talk through this? Can you hear me, Dr. Boehm?
Barely. Is this Mr. Egan?
Yes, it's Mr. Egan.
Hi, good morning, Mr. Egan.
Good morning. Given the limitations we have, I'm not going to ask you some things I prepared. I can't show you a number of things. So this may take a second, less than we'd planned here. But let me start this way. Dr. Scher, you watched Dr. Scher's or read Dr. Scher's trial testimony, right?
Yes, I read it. I did not watch it.
And so you didn't see him writing up the equations on the board for the jury and discussing those for them?
I did get a text picture of his equations.
Okay. But did you get a text picture of the drawings that he drew for the jury?
Yes, I did.
And Dr. Scher has significant experience applying the principles of biomechanics to skiing, correct?
To my knowledge, he does. I don't know him personally or professionally.
And you do not have that kind of experience, correct?
With regards to what, sir?
Applying the principles of biomechanics to skiing?
I have not worked on skiing problems, if you will.
Okay.
Certainly.
And Dr. Scher has studied the physics of skiing and ski equipment, correct?
Oh,
Ow.
yeah, that's my understanding of primarily bindings with skis.
Yeah, I think it goes beyond that, but that's right. And you have not done such studies, correct?
No, not on ski bindings, sir.
And did you learn anything from Dr. Scher's testimony, given his experience with applying biomechanics to skiing and your lack of it? Did you learn anything from him?
Did I learn anything? I mean, all I learned was that he assumed a free fall event, and it's not a free fall event. That's what I learned primarily, and that's why that basic assumption flaw is analysis.
And that's the only thing you learned.
I'm sorry, I didn't hear that.
And that's the only thing you learned.
Talking to the
Yes, that was basically that's why I'm here today.
Do you know, is this
Oh,
better?
I hear you much.
Can you hear me better if I do this?
Absolutely,
Okay.
absolutely.
I'm just, leaning in front of the jury here.
No, I appreciate that. I can hear you really good now. 5 by 5.
Thanks. Yeah, it's a first. Okay. So, do you know anything about DIN settings? Those are the settings that dictate when ski bindings release.
No, I do not
Okay,
know
so-
anything about that.
So
I haven't skied in 40 years.
Right. Okay. And that means you wouldn't know how much force it would have taken to release Mr. Sanderson's boots from his skis, correct?
I did not calculate
not just that you didn't calculate it, you don't even know what force it would require. Is that right?
No, that is correct. It's not required for my analysis.
Okay. Did you catch in Dr. Scher's testimony that he's read the voluminous literature on rib fractures and the biomechanics of rib fractures?
I'm sure he has, but we did experiments in the lab in the military doing that. So
Okay, but my question was just, did you see that part of or read that part of his testimony?
That's what
No.
he portrays.
Okay, and it sounds like you dispute his reading of that literature.
No, I don't. I mean, he portrays that he knows a lot about biomechanics. I don't know. I've never been in a discussion with him to familiarize myself with his level of knowledge in that field.
You said earlier that part of Dr. Scher's mistake in your mind is that he didn't acknowledge that he didn't solve for T. Is that what you said?
Well, that's one of them.
Okay, so that we're just going to stay on that one for a second. Did you?
Objection. Let the witness finish his answer, counsel.
He answered my question. I was just going.
Mr. Boehm, did you have anything else that you needed to say to respond to the previous answer?
No, we can move on, Your Honor.
Okay, thanks, Dr. Boehm. I don't mean to interrupt. I'm just trying to be quick because I don't have much time.
I understand, Mr. Egan.
So
I'm in a hurry too. I'm trying to make a luncheon.
I got it. Yeah. Well, we appreciate you making time during your vacation. So, did you miss in Dr. Scher's testimony where he pointed to the pages in your equations where you solved for T and he just assumed what you had done?
Right. I mean, basically, he did an analysis or a critique, I might add, on my analysis. I don't see where he calculated it himself.
Right. He was just working off yours, just assuming what you had done and then doing his own calculations.
Right. That is correct.
Okay. Thanks. That's all the questions I have. Thanks.
Thank you, Mr. Egan. Appreciate it.
Mr. Bueller?
Dr. Boehm?
Yes, sir.
Okay. So you did see the calculations from Dr. Scher.
Well, I saw what he did, which was critique my analysis, and that was it. I don't know if he did any calculations based on what I saw in his testimony.
If you could quickly focus in on what is the error that you think Dr. Scher made?
Well, the biggest one, well, there's two of them. First of all, with the rotational aspect, he did not consider Newton's first and third laws, so that's a violation of classical physics. And then second of all, he assumed a free fall, and we know that Mr. Sanderson did not free fall to the ground because he was standing up and he fell over, and the velocity when you hit the ground, when you fall over, is much less than a free fall. And we did those studies at the Naval Undersea Research Laboratory because we were interested in that research for our military personnel. So knowing because you can appreciate standing up, when you fall over, the speed of your feet is 0, whereas the speed of your head is something else. And it's much different than a free fall event.
Okay. Thank you. That's all I have. Counsel?
Thank you. And am I allowed to leave? Over?
Just have one question, if that's okay, Your Honor.
James Egan has one more question.
Oh, okay. Mr. Egan.
Yeah. Oh, thanks. Yep. Thank you, Lawrence. I'm back, Dr. Boehm.
That's great.
One last question. You're talking about free fall. Do you recall the testimony from Mr. Sanderson that he went airborne during the accident?
I don't recall that.
Okay, thank you.
Anything else?
Just one question. Is it possible for for Terry Sanderson to have gone airborne when his skis were on the snow?
No, that's not going to happen because the skier would have to go, that hit him from behind would have to be going in excess of 50 or 60 miles an hour, which I think is highly unlikely unless we're dealing with an Olympic downhill skier here.
Okay. That's all I have. Thank you, Dr. Bain. No more questions.
Thank you. And Your Honor, am I excused?
Yes, you are. Thank you, Mr. Bain.
Thank you.
Thank you,
There you
Your
go.
Honor.
Good.
Thank you, guys. You guys have a great day out there in Utah.
Thank you. That's all we have. No more witnesses, Your Honor.
So you rest your rebuttal case?
We rest our rebuttal case, yes.
Okay. So you've now received all of the evidence.
We were thinking of calling somebody, but we decided not to.
Okay. So you've now received all of the evidence. I just need to ask the lawyers a couple questions and then we'll proceed. So could you approach the bench, please?
Okay, so whoever in chat can explain all of that for us and put in chat, very grateful. We'll just wait for someone to explain it all for us because that's like good job. Yes, I mean, so Christ Spice, you said something. This is what she's always said. There's a rotation, and he fell on her. Sorry, she fell on him. So yeah, I'm sticking with that. Also, when they were saying he's got no ski experience, and like it is a big deal if you don't understand skiing or how it works and stuff. You know, that's huge because it's a fine line. It's minute stuff, but they're important stuff. So, oh look at he's back. Craig's back. I mean, look, he was just obviously a little bit upset. So and they have to do. Yeah, they cancel each other out, Eric, but I also think the defense ones were better. And made more sense to a certain extent, especially the guy that you liked, the guy with the stroke and stuff, and even this guy. Yeah, the defense version of this guy, I didn't stand there, but he spoke very confidently. So good luck, Crow Spies. See you later. Come back after you finished. Yeah, he was great. And also, I'm not just saying, but I think the women on the witness side as well were great. They were so calm, collected, didn't get phased. And made the plaintiff lawyers lose their temper all the time. Fine wasn't quiet. Yeah, I just got that. So overall, I don't think there's much of a decision here. I think you go in, get your free lunch, and just go right.
Okay, members of the jury, you have been handed the closing jury instructions. There's one more document you'll get before the parties argue, but we're gonna give that to you right after the break. I'm gonna read through these and then we'll take a short break. So these are jury instructions 18 and 22 through 42. If you turn to page 2, and you can make notes on these if you'd like. So page 2 is jury instruction number 18, which has already been read to you, most of it, as modified, because I did modify it during the trial, and I read it to you during the trial as it stated right here. So now you've got the complete 18, the modified 18. Turning then to jury instruction 22, which was also read to you during the trial on limited purpose evidence. Turning then to 23, a closing roadmap. Members of the jury, you have now received all of the evidence. 3 things remain to be done. First, I will give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. The plaintiff will go first, then the defendant, then the plaintiff may give a rebuttal. Finally, you will go to the jury room to decide the case. In the jury room, you will have 2 main duties as jurors. First, you will decide from the evidence what the facts are. You may draw all reasonable inferences from that evidence. Second, you will take the law I give you in the instructions, apply it to the facts, and reach a verdict. Instruction 24, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Counsel, could you remove that easel? It's kind of blocking my view of the jury. Number 25. You can just shove it over next to the screen. Legal rulings. During the trial, I have made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. 26, fault defined. Your goal as jurors is to decide whether Terry Sanderson was harmed, and if so, whether anyone is at fault for that harm. You must also decide whether Gwyneth Paltrow was harmed, and if so, whether anyone is at fault for that harm. If you decide that more than one person is at fault, you must then allocate fault among them. Fault means any wrongful act or failure to act. The wrongful act or failure to act alleged in this case is negligence. Your answers to the questions on the verdict form will determine whether anyone is at fault. We will review the verdict form in a few minutes after your break. Instruction 27, negligence defined. You must decide whether Gwyneth Paltrow or Terry Sanderson was negligent, or whether they were both negligent. Negligence means that a person did not use reasonable care. We all have a duty to use reasonable care to avoid injuring others. Reasonable care is simply what a reasonably careful person would do in a similar situation. A person may be negligent in acting or in failing to act. The amount of care that is reasonable depends on the situation. Ordinary circumstances do not require extraordinary caution. But some situations require more care because a reasonably careful person would understand that more danger is involved. To establish negligence, Terry Sanderson has the burden of proving that 1, Gwyneth Paltrow was negligent, and 2, this negligence was a cause of Terry Sanders' harm. If you find that Gwyneth Paltrow was negligent, then you must determine whether that negligence was a cause of Terry Sanderson's harm and whether Terry Sanderson sustained damages. Gwyneth Paltrow claims that Terry Sanderson was negligent in causing his own harm, and that should read, and in causing her harm. To establish Terry Sanderson's negligence, Gwyneth Paltrow has the burden of proving Gwyneth Paltrow has the burden of proving that 1, Terry Sanderson was negligent, and 2, that this negligence was a cause of Terry Sanders' harm and her own harm. I'll send in a corrected instruction 27. If you find that Terry Sanderson was negligent, then you must determine whether his negligence was a cause of his own harm and her own and Ms. Paltrow's harm, and whether Paltrow sustained damages. Instruction 28, allocation of fault. If you decide that more than one person is at fault, you must decide each person's percentage of fault that caused the harm you determine was suffered in this case. This allocation must total 100%. Mr. Sanderson's total recovery will be reduced by the percentage of fault that you attribute to him. If you decide that this percentage is 50% or greater, he will recover nothing. The same is true of Ms. Paltrow's recovery. When you answer the question on damages, do not reduce the award by Mr. Sanderson's or Ms. Paltrow's percentages. I will calculate that later. Instruction 29, violation of a safety law. Violation of a safety law is evidence of negligence. Terry Sanderson claims that Gwyneth Paltrow violated parts A and B of the following safety law, and Gwyneth Paltrow claims that Terry Sanderson violated part A of the following safety law. This is Summit County Ordinance Section 523, reckless skiing. A, reckless skiing prohibited. No person shall ski in a reckless or negligent manner so as to endanger the life, limb, or property of any person. B, skier's duty to injured party in the event of collision. Any skier involved in a collision resulting in injury to any person shall immediately stop at the scene of such collision and render to such person injured in such collision reasonable assistance, including the caring or the making of arrangements for the caring of such person by a physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that such treatment is necessary, or if such caring is requested by the injured party. If you decide that Mr. Sanderson and or Ms. Paltrow violated the safety law, you may consider the violation as evidence of negligence. If you decide that Mr. Sanderson and or Ms. Paltrow did not violate the safety law, you must disregard the violation, disregard the safety law, and decide whether they acted with reasonable care under the circumstances. Jury instruction 30, I've already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Jury instruction 31, spoliation. Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. If you find that 1, a GoPro video of the collision likely existed, and 2, that any such GoPro video was in the possession or control of Sanderson, and 3, that the plaintiff intentionally or negligently disposed of or lost the GoPro video of the collision, or otherwise failed to offer a reasonable excuse for failing to preserve the GoPro video of the collision before a defendant had an opportunity to review and evaluate it. Then you may, but are not required to, conclude that the evidence would have been unfavorable to Sanderson. Instruction 32, introduction to tort damages, economic and non-economic damages introduced. I will now instruct you about damages. My instructions are given as a guide for calculating what damages should be if you find that either Terry Sanderson or Gwyneth Paltrow is entitled to them. However, if you decide no one is entitled to recover damages, then you must disregard these instructions. If you decide that Ms. Paltrow's fault caused Mr. Sanderson's harm, you must decide how much money will fairly and compensate him for that harm. If you decide that Mr. Sanderson's fault caused Ms. Paltrow's harm, then you may award Ms. Paltrow $1, which is the maximum amount she seeks. There are 2 kinds of damages, economic and non-economic. I would explain the difference between them. 33, proof of damages. To be entitled to damages, a party must prove 2 points. First, that damages occurred. There must be a reasonable probability, not just speculation, that a party suffered damages from the other party's fault. Second, the amount of damages. The level of evidence required to prove the amount of damages is not as high as what is required to prove the occurrence of damages. There must still be evidence, not just speculation, that gives a reasonable estimate of the amount of damages, but the law does not require a mathematical certainty. In other words, if a party has proved that they have been damaged and they have established a reasonable estimate of those damages, the other party may not escape liability because of some uncertainty in the amount of damages. 34, economic damages defined. Economic damages are the amount of money that will fairly and adequately compensate a party for measurable losses of money or property caused by another party's fault. Mr. Sanderson is not claiming any economic damages. Therefore, you should not award Mr. Sanderson any economic damages. Ms. Paltrow is seeking $1 in economic damages. 35, non-economic damages defined. Mr. Sanderson is seeking non-economic damages. Non-economic damages are the amount of money that will fairly and adequately compensate Mr. Sanderson for losses other than economic losses. Non-economic damages are not capable of being exactly measured, and there is no fixed rule, standard, or formula for them. Non-economic damage may still be awarded even though they may be difficult to compute. It is your duty to make this determination with calm and reasonable judgment. The law does not require the testimony of any witness to establish the amount of non-economic damages. In awarding non-economic damages, among the things that you may consider are 1, the nature and extent of injuries, 2, the pain and suffering, both mental and physical, 3, the extent to which Mr. Sanderson has been prevented from pursuing his ordinary affairs, 4, the degree and character of any disfigurement, 5, the extent to which Mr. Sanderson has been limited in the enjoyment of life, and 6, whether the consequences of these injuries are likely to continue and for how long. While you may not award damages based on speculation, the law requires only that the evidence provide a reasonable basis for assessing the damages, but does not require a mathematical certainty. I will now instruct you on particular items of economic and non-economic damages presented in this case. Instruction 36, pre-existing conditions. Terry Sanderson is alleged to have had physical, emotional, or mental conditions before the time of the ski collision. He is not entitled to recover damages for those conditions. However, he is entitled to recover damages for any aggravation of the conditions caused by Gwyneth Paltrow's fault, even if those conditions made him more vulnerable to physical or emotional harm than the average person. This is true even if another person may not have suffered any harm from the event at all. Gwyneth Paltrow has the burden to prove what portion of the alleged harm is the result of pre-existing conditions. If you are unable to make such an apportionment, then you must conclude that all damages, if any, you find were suffered by Mr. Sanderson were caused by Ms. Paltrow. 37, mitigation of damages. Each party had a duty to exercise reasonable diligence and ordinary care to minimize the damages caused by the other's fault. Any damages award should not include those that could have been avoided by taking reasonable steps. Terry Sanderson has the burden to prove that Gwyneth Paltrow could have minimized her damages but failed to do so. Gwyneth Paltrow has the burden to prove that Terry Sanderson could have minimized his damages but failed to do so. If a party made reasonable efforts to minimize damages, then your award to that party should include the amounts that he or she reasonably incurred to minimize them.
Your Honor, my memory is that jury instruction 38 was stricken by both parties yesterday.
Okay. It wasn't.
It was not.
It was not stricken.
I apologize. Please proceed.
Okay, 38, collateral source payments. You shall award damages in an amount that fully compensates Terry Sanderson. Do not speculate on or consider any other possible sources of benefit Terry Sanderson may have received. After you have received your verdict, I will make whatever adjustments may be appropriate. 39, four-person selection and duties and jury deliberations. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach an agreement on a verdict. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. I recommend that you not commit yourself to a particular verdict before discussing all the evidence. Try to reach an agreement, but only if you can do so honestly and in good conscience. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. In reaching your verdict, you may not use methods of chance, such as drawing straws or flipping a coin. The verdict must reflect your individual, careful, and conscientious judgment. Instruction 40, do not resort to chance. When you deliberate, do not flip a coin, draw straws, choose opinions at random, or use other methods of chance. Instead, you must weigh the evidence carefully and come to a decision that is supported by the evidence. If you decide that a party is entitled to recover damages, you must then agree upon the amount of money to award that party. Each of you should state your own independent judgment on what the amount should be. You must thoughtfully consider the amounts suggested, evaluate them according to these instructions and the evidence, and reach an agreement on the amount. You must not agree in advance to average the estimates. Instruction 41, agreement on special verdict. After the break, I'm going to give you a form called the special verdict that contains several questions and instructions. You must answer the questions based on the instructions and the evidence that you have seen and heard during this trial. Because this is not a criminal case, your verdict does not have to be unanimous. At least 6 jurors must agree on the answer to each question, but they do not have to be the same 6 jurors on each question. As soon as 6 or more of you agree on the answer to all of the required questions, the foreperson should sign and date the verdict form and tell the bailiff that you have finished. The bailiff will escort you back to this courtroom. You should bring the completed special verdict form with you. And then jury instruction 42, I'll read to you at the end of the trial. So that completes these instructions. I wonder if you could write your names on the top of that, because as you noticed, I did make some changes to a few of the instructions as we went along, and I'll have the bailiff insert the new and take out the old, if you could do that, the new instructions before they're given back to you. Yes. Pardon me?
Names and numbers, or just names?
On the verdict form, the foreperson will write their number and their name on when they sign it. And there's only be one signature on it, which would be the foreperson. And when I select the two jurors that will unfortunately have to leave us before deliberations, I'll just tell you your juror number. I won't say your name, and I'll give you further instructions about those two individuals. So I'll do that in a few minutes after all the arguments are completed. So at this time, we'll take a recess, and thank you.
All rise to the jury.
Closing arguments. Defense think they can take an hour, and the plaintiff think they can take about an hour and 10 minutes. Just to give you, so it's maybe like 2.25 hours after we come back. Because there might be a 5-minute break in between. Mics are off. There we go.
Defendants?
No, I would like to get a hard copy of the special verdict form just so I can read it one more time.
We've got some issues with the verdict form. I wonder if you could come into chambers and we can kind of go through that.
Thank you. And then can Peter Jensen have the defense binder index, and certainly one of the plaintiff's lawyers
No, they're
is
not,
welcome
Joe.
to be present to do the final swap
It's
out
five.
with the new index. He's
Sure.
not adding one thing. He's
And is
deducting.
that something we need to do before closings?
No. He could do it at the moment. They're discharged to deliberate.
Normally,
Sure.
well, if you want to get those into evidence,
Nice.
I suggest you try as soon as possible.
Well, I do move to admit the new index, all those documents on the new index, which they have. Any objection?
Are there any objections to the index of defendants' trial
Plaintiff's
exhibits? All of the exhibits being received?
So that's
Okay.
on the new index. And now he just needs to make the changes, including blacking out Mr. Sanderson's
Contact information?
contact information.
Social Security, birth date?
Address is the one that's
Address.
most common.
Okay. All right, so take a quick break and then have the bailiff bring you back to my chambers on the special verdict form.
Thank you.
Welcome back, Rosie. So yeah, Joe, this isn't lunch. This is a quick break. Well, I say quick break, probably 5-10 minutes, and then another 2.25 hours. So I estimate we should be done about 1 o'clock, which is 8 o'clock here, which means I've got to wait till 8 for food. Just in time for the break. Yes. Hello. What timing have you got? It's all good. He's got one more thing to read out to the jury. He's got to dismiss 2 of the jurors, and then we're through. Rosie, right, I'll cut you up straight away. You missed fuck all. It was just a complete disaster, to be quite honest with you. All that's happened is that the doctor, oh shit, my ear. The doctor, well, I don't remember his name now, sorry, was doing a rebuttal about testimony. Oh, after that, fine. After that, Rosie, that's what Joe said. Went over to jury instructions, that's it. So you've missed nothing. Because there was 42 things that need to read out. 41, sorry. You got one more thing to read out, which they're going to discuss in chambers. And that's it. So you missed fuck all. It'd be interesting to see how they close. Yeah, how many are on the jury? How many are actually on the jury? In the morning, nothing. It was just going through the jury instructions up until Dr. Bohm or whatever, Bohm or whatever his name is. It was just going through jury instructions. That's what they were in for Corpus State for. Is to finalize stuff, what could go in, what can't go in, and stuff like that. And they were discussing about when once we decided if Gwyneth gets her money back. And that's about it, really. Yeah, she saw that one, Joe. She's seen that one. She's seen the Doctor. Boom. Um, they need 6 to agree on every count, but I don't know how many is on the jury. Is it 8? Is it 10? Is it 12? I don't know. So these once 6 have agreed on each point, then there's no arguments. It's like carry on next. So, but I think we missed the jury selection, so I don't remember. I do know there was one person that didn't know who Gwyneth Paltrow was. The rest of them did. But and I know they're going to dismiss 2 of the jurors now. But again, I don't know how many there are in the final. I don't think it's 12. Can't be 12 because it's 50%. So I think it's either 8 to 10. So yeah, we'll see. Um, I had a guy on Rumble called me Tronny. I was like, you fucking mute, you prick. Hello, Rumble. Sorry, if that guy. I've muted him, kicked him out. I was going to say CUNT. See you next Tuesday. Oh, we're doing all right. We've got a few here. We've got 20 odd in Rumble. Couple in that on Twitter. I hope it doesn't take too long now. I just want to, in a way, I just want it to end now. After lunch or whatever, I'm gonna play the Peter Tragos, his thoughts of yesterday's stuff. So I'll stream that just if anyone wants to be around to listen to that. And there's a couple of Brian Kohlberger stuff I want to play, but because I'll have this screen on, in the sense of I'm gonna wait for the result today and tomorrow. Hopefully, it comes today or tomorrow. So yeah. Ooh. And you can chat about stuff if you want. Yankees are on today, are they? Yankees, they always blow it though, don't they? Always blow it, Joe. So I keep messing this up. I think it's the underscore alternate underscore corner, but I'm also using a name called DAVISH12. That's DAVISH12, which I could type in if you want. So apparently my stream is playing on my Davish12 account instead of the alternate corner account. I don't know how I did the same yesterday. I clicked the alternate corner. I thought I did anyway. So yeah, just still check it. So currently, that's what it is. Oh, 8. Class, Rosie, class. Good work, Detective Rosie. Where's this gone? The only thing Spider Girl is a rumble. No one talks. Hardly anybody talks there. So I never really go in the chat there. Might be. Oh, I'm just the alternate corner on that one. Uber Eats. Oh, thank you. Thank you very much. Well, hey, but we all use Google. We all diagnose ourselves on Google, don't we? The Google. I always tell my doctor, well, Dr. Google tells me this is wrong with me. And he normally goes, shut up. Yeah, so yeah, it makes sense. I thought it'd be 8 to 10, and 8 makes absolute sense there. Stop trashing. Look, I follow a bit of Barstool Sports, right, Joe? And half their office support the New York Yankees, and there's a few like Frank the Tank and KFC who are big Mets fans. So that's all I know about baseball. I don't know much other than that, to be quite honest with you. 3 New York Yankees baseball caps. Oh, have you? Are you a fan there, or just do you like the look of it or something? Terry loves Dr. Google. Yes, Terry thinks he is Dr. Google, Rosie. That's a problem. Oh, we got Erin. You're into it as well, are you, Erin? Baseball? Ah, are you into just baseball? Are you into like American football? So into football and ice hockey and all that. Like, I was intrigued. I can't say I'm into baseball, but I'm into football. Blue Jays. Oh shit, what's that? Oh, TikTok. Is that baseball? Blue Jays? Not heard of that before. Ah, okay, yeah, fair. Yeah, that's fair. I can get that. Their caps are quite cool. Baseball, Dodgers. Yeah, I've heard about LA Dodgers. So do you follow the LA Rams or LA Chargers? Because LA Chargers are right next to you, aren't they? Toronto Blue Jays. Ah, yeah, you see. Well, you got 3 mummy boys then, like, so amazing. You got 3 protectors. Amazing. No, you don't. I don't blame you. The Rams won the Super Bowl. They were crap. Rosie, oh my God, that's another thing that you and me got in common. I want to as well. I want to. I honestly, I would love to, but need to get visas. Never heard of that. Never heard of it. Weird, isn't it? LA. I know what a couple of British players have played for them, but I've never heard of that. I know Chris Rodshaw went out there to play for some team in LA for rugby. Oh, yes, Rosie. Are you half American or something? Could you get a visa to get out there? Or are you just full British like me? Oh, that's what you mean. Oh, I thought it was a team. That's that you talk about. I've never been to Canada. I don't know what Canada's like. Does it rain and snow all the time in Canada? I want to move there because everything seems to be better except for the judicial stuff where you find people guilty before they're innocent. Obviously, not you guys. I'm joking. I think like I'm intrigued by America. Everything seems to be bigger. Um, the culture and a lot of, I mean, but not everywhere in America, mind. There's obviously we're talking limited spots. I'd love to be in America. Um, uh, weather for one. There's a lot of things that I don't like about America as well, obviously, but that we're not used to, like your healthcare system's crap and stuff like that. So we're lucky here for that. I like American women. That's one. I'm into American sports now, so that's two. I like the culture, I like the cuisine. Um, I don't know, been to some rural places, which was nice, the history and stuff like that. I just something intrigues me about America. I got a sort of friend who lives out there now, got married out there, not spoken to for 20 years, but he apparently loves it out there. He just seemed to have a lot more stuff than we do, and obviously I'd miss Wales, certain things, but I don't know, maybe it's just the American women I love. I don't know, see the cheerleaders and stuff. Jesus. Uh, yeah, okay, but that's the same everywhere though. But Americans should be dominating rugby. You're the nation that should be dominating every sport. Same here, Rosie. Same here. You and me in the same boat. We can't marry each other then. We've got to find separate partners, Rosie. We can't even help each other out here. In Canada, okay. I thought, okay. I'll give you that one. I didn't know that. I've had some family move out there, but okay. Agreed. I'll offend you here. Rosie. I hate London. Don't know what it is, but I hate London. So that's why I don't think I'd want to move to New York, maybe. It's just too busy. I don't know, Giovanna. I don't know. I mean, foreign. Yeah, I probably do. I probably do. I'm not that fussy. Do you know what I mean? Yeah, I think so as well. From what we see, everything looks like green pastures, as in until you get used to it. But all my friends, another friend of mine, and his brother's out there, and he loves it. He works for Nike, so he started off in New York and then went over to for another company. Then went to Oregon, is it? And now he's moving back halfway somewhere. He loves it. He's got now, not is it green card he's got now? He's lucky. I don't know what part you're laughing at, but um, yeah, England does and Wales does as well. London sucks. Yeah, I hate it. My best friend lives there on the outskirts now, near Watford now, but he used to live in London. Hate it. So hate it. Big cities here really gone far. Yeah, fair. I mean, yeah, I'm sure it has. Like, I'm sure me and Rosie looking at this as um, rose-tinted glasses as well. To me, but I've loved every holiday I've had there. Everyone's so friendly. Um, and I say the women. Ooh, ooh. Not saying everyone, but I mean some of the ones I've seen. She is enough that she is. Hang on, no, she's not. Oh, geez, I don't know. I'm confused now. Which one of you is Canadian? It's where they would be disgusted. Well, okay, fine, okay. That's true for LA, right? Trash urine, all that. But the French, they got nothing to say. I'm not a big fan of France. I've lived with a French person, and he was disgusting, messy, and yeah, no hygiene. So you would have gone to the good parts of Paris. Yeah, I mean, you just explained London. You just you just explained the life of Rosie in London. Yeah. 100%. Even places like Cardiff, which used to be really good reputation. On a Saturday night, you go down Chippy Alley. Chippy Alley used to be amazing. Now it's just full of shit everywhere. People passed out. Yeah, I think it's just it's all around the world, Erin. We're experiencing exactly the same. Even when they Glasgow and Dublin and everything, it's the same. You know, it's a shame. I'm not sure where I would want Rosie. Do you know where you want to live in America? I'm not sure. I haven't picked a spot yet. I've not picked a spot. Oh, right, yeah. But you used to live there, didn't you? So, yeah, same as my mate. Pittsburgh. The Iron, is it the Iron City, is it? That's the Mike Tomlin, the Pittsburgh Steelers. I didn't know that's where you're from, Spider Girl. Rock hard toughness, Steel City. Is it Steel City or is it Iron City? I don't know. Oh, Steel, because Steelers, isn't it? Duh. I think it's a worldwide problem, guys. I think it's very unfortunate. So you want to move from one city with all the shit and piss and everything to another one, LA then. Yeah, but I suppose it depends where you live, innit? The only thing that puts me off California is the taxes and the traffic. The lifestyle is probably great, but oh, you can't get anywhere. Same here. And right now I do, but you miss out on stuff though when you're in a small town. That's the only thing. So it's benefits to it, but it's also can be quite boring. Um, yeah, I know you are. But yeah, you just mentioned it in the other one. Taxes, cost of living. I I hear it. I hear it, and I'm just like, I can't do it. Here we go, Steelers. Here we go. Boom, boom. Here we go, Steelers. Here we go. Boom, boom. I watched Pat McAfee, Spider Girl. I'm not sure if you heard of Pat McAfee, but obviously he's from Pittsburgh. So he talked about Plum, and he went to Plum High School and stuff like that. So I've had some insight there. Um, he likes Steelers and Penguins, but I think he hates the Pirates or something. Yeah, you're there. Hey, no, it's hey, you're a lifer. You, Erin, I know, you don't like change. Once you're set, once your heart's set, once you're settled in somewhere, change and Erin do not go hand in hand. That's why you're solid, you're dependable down the line. Nothing wrong with that. My mother's exactly the same, and I love my mother to bits. And we need more of those kind of people. Feel like taking a visit to soccer. Do you know what? I thought about it as well. Can you imagine? Yeah, that's a good shout. Oops, Connecticut. That's Boston, isn't it? That's Boston way. I think we all do. I mean, especially now. I have fantasies, not fantasies. That's wrong. Um, Images of Hampton, and because it looked lovely, it looked like a really nice town. Then you can go meet Mandy and Liz for podcast stuff. Yeah, I'm saying. Who do you like then? If you don't like the Steelers, who do you like then, Spider Girl? Steelers. Kenny Pickett now as QB. Oh, yeah, cool. So yeah, that's okay. So Connecticut, I think it's below that, isn't it? It's between New York and Boston somewhere. Full discretion. That's fine. That's fine. I'm just trying to find football fans because that's the only thing I know about sport in America. And a bit about. I've been watching the college basketball, the NCAA. Charleston, Charleston sounds like also Charlotte as well. I'd love to. Just all that Rock Hill, Charlotte, because that's where Buster is now, and then obviously not what he was, sorry, and Hilton Head just down as well. And they're nice places. I love all sports. Do you? Who do you support in the NFL then? Enough of that. Because I'm a bit more of a Indianapolis Colts. I'm not really a massive fan, but I am Colts, I would say. I still love soccer, or as you guys would say it, but I got off it recently anyway. So you are. So you're a Mike Tomlin girl. Fair. Jerome Bettis and all that. Ben Roethlisberger, or whatever his called name. You're Kenny Pickett now, so I like Kenny Pickett. People underestimate him, but I think he's good. See how you do with the draft this year, innit? I love the NFL draft. I'll be watching that as well. I love it. It's just nice to see people's dreams come true, like, you know. Oh, so we found out then, and well, I hope this is not lunch break, but they said break. Oh yeah, Terry Bradshaw, yeah. Oh, you've been around for a while then. So we found out you're a Steelers fan. We found out me and Rosie want to move to America, but we can't marry each other for it. So we have to find a man for Rosie and a woman for me. Or that guy said I was a tranny, so maybe I can get a visa that way. A few of us want to visit South Carolina. Everyone likes baseball, so does Joe. Giovanna's from Canada, who's visited Connecticut. Oh, I'm sorry, I missed that. You guys plan a trip, not gonna be for at least a year anyway. But yeah, no, definitely. I'd love to come back out there, South Carolina area. It's gonna be a bit because it's breaks and judges. Yeah, fair. But it's only one thing to change, isn't it? So I'm hoping it's not gonna be that long because the judge wants to be done ASAP. He said he doesn't want to go much past 12. So do you know what? That's one place that's never appealed to me is Hawaii. Only because every time I watch something from Hawaii, everyone says about how the salt ruins them. You'd hate to live there. I suppose you want to visit, I suppose, yeah, but I don't know, never appealed to me, Hawaii. I've no idea why. When I was younger, I used to like it, but no, not now. I wouldn't want to go there, to be quite honestly. I think it's a fair distance to fly as well, so yeah, weird. Oh, what else have we got going on? Right, let's have a look at. I avoid my Rumble stuff. I don't. Oh, I spy the girl. I'm never on Rumble, guys. I literally, there's 14 watching now. I never pay attention to the chat because no one ever talks except for Shannon. But Rumble's interesting. There's loads of programs on Rumble, guys. If you go over there, you can see. I've not looked at too much in there. Um, I've streamed for like 4 days there, and I've made something like 38 cents so far. Oh, where's that? Tell us more. Where is that? What is that? And where is it? Yeah, but it's break time in the sense of, like Spider-Girl said, they got to go into chambers after break to fix some stuff. But so it could be half an hour, it could be 10 minutes. I have no idea. Yeah, break time, Joe. Where's this then? Oh, I could just Google it, can I? Oh, why am I asking you when I can just Google it? Little halls. Oh, right, okay. I've not Googled it yet, and you keep Johnny Depp's Island. Okay, fine. Inside joke. I don't get him. Um, I think I spoke to Spider Girl yesterday. Said I might stream the Johnny Depp trial around Christmas time when there's not much on because I've never watched it. So I might do that if anyone's interested. Ooh, never been. Yeah, yeah. I've heard it's nice. Yeah, that's a good shout. Yeah, I've heard it's really nice as well. Bit expensive. I keep saying my mate. There's a guy I know, my best friend, my cousin. He used to live in Washington, D.C. He worked for DeMatha High School. Is it DeMatha High School? He was like the head football coach and stuff there, the head soccer coach there. He's now back here working for Wales football, and his American wife came back with him, so they got 2 kids here now. Yeah, I gathered. I do. Yeah, over my head. Hi Shannon, how was your stream? Was it okay? Good. I need to go. I think I do need to go. Ah, okay. Oh, it was you then. It's probably you, me, and Crime Spies who speaking about it. I'm just going to do it when it's quiet time, Rosie, probably over Christmas because we skipped the breaks and stuff. Do you know what I mean? So, Gion, Giovanna, you meant. Be back to hear something. Oh, oh, what a crap time that would be.
Ready for the
Oh, that's
jury?
cool. That's cool though.
Yes. Yes.
Right, here we go. Plaintiff first for an hour. Not Chrissy. Shannon, you missed some good chats here. No, they've not. The closing arguments are now. Closing arguments are now. Me and Rosie are going to move to America. Don't know when though. Might be 20 years, but everyone's answered you. Yeah. I hate that audio in the background. Just mute it, guys. Oh, wait for the jury, fine. he's
Okay, you should have on your chair a document, 3 pages, called Special Verdict Form. I'm going to go through that right now. Members of the jury, please answer the following questions in the order that they are presented. If you find that the issue has been proved by a preponderance of the evidence, answer yes. If not, no. At least 6 jurors must agree on the answer to all of the required questions, but they need not be the same 6 on each question. When 6 or more of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. Gwyneth Paltrow, question 1. Was Gwyneth Paltrow at fault? Yes or no? If you answer yes, go to question 2. If you answer no, go to question 3 below. Question number 2, was Gwyneth Paltrow's fault a cause of Terry Sanderson's harm? Yes or no? Regardless of your answer, go to question 3. Terry Sanderson, question 3. Was Terry Sanderson at fault? If you answer yes or no. If you answer yes, go to question 4. If you answer no, go to question 5 below. 4, was Terry Sanderson's fault a cause of Gwyneth Paltrow's harm? Yes or no? Regardless of your answer, go to number 5 below. Number 5, if your answers to question 1 and 3 are both no, you should not proceed further except to date and sign this verdict form and return it to the courtroom. Otherwise, continue to question 6. Comparative fault, question 6, Gwyneth Paltrow. What percentage of the fault do you assign to Gwyneth Paltrow? If your answer to either questions 1 or 2 is no, then enter 0%. And there's a blank and a place for you to put your number in. Proceed to question 7. Question 7, Terry Sanderson. What percentage of the fault do you assign to Terry Sanderson? And there's a blank and a place for you to put your percentage in. If your answer to either questions 3 or 4 is no, then enter 0. The total must equal 100%. If Terry Sanderson's fault is less than 50%, answer question 8. Do not deduct from the damages any percentage of fault that you have assessed to Terry Sanderson. The judge will make any necessary deductions later. If Terry Sanderson's fault is 50% or more, do not answer question 8 and proceed to question 9. Damages Terry Sanderson, question 8. What amount fairly compensates Terry Sanderson for non-economic damages, $blank. Damages Gwyneth Paltrow, number 9. What amount fairly compensates Gwyneth Paltrow for economic damages? This cannot exceed $1, $blank. When 6 or more of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. So we'll now hear from the lawyers with their closing arguments. Plaintiff will go first. We'll check with the expert here.
Hello, hello?
Sounds good. Can you actually do it again?
Hello, hello?
Yes.
Ladies and gentlemen of the jury, thank you for your attentiveness during these 2 weeks. It's been a hard, long case. I've tried a lot of cases in my lifetime. This has been a hard, long case. By the way, it's about an hour each way going to Salt Lake with traffic, so that adds to it. But you've been very attentive. I've seen you taking notes and paying attention. No one nodded off. So thank you again. Now, turn on my, Lawrence and I are going to split this. Let's see, nope. By the way, I apologize for my cold. You can't really choose when those come. I've got asthma and it makes it worse, but I've done everything I can
to try to resolve it. Took all the tests. I'm negative for COVID, et cetera, but it still has plagued me. So I apologize for the coffee. Maybe a little bit more of that. Okay. There are really three issues in the case. Number one, who hit whom? Okay. Number two, did it cause any damage? Number three, what are the damages? What are the damages? Now, Gwyneth Paltrow, in this case, is not a liar. Terry Sanderson is not a liar. Okay? Gwyneth is a good person. Okay? She's a good mother, and she loves her children, and she's passionate about many things. Now, we don't usually say good things about other people in our closing, but I think that's an accurate statement. Okay? I think that she believes, and I believe Gwyneth Paltrow when she says she believes. She says, Terry hit me in the back. And she believes it. It's a sincere belief. She's not a liar because of it. Pardon me. But the problem is, a sincere belief doesn't make it so. Now, excuse me. Some of you are skiers and some of you aren't. Okay. Pardon me. When you're involved in a ski crash, it can be very confusing. I don't care who hit whom. It can be very confusing. So I think she sincerely believes that she got hit in the back. The problem is, you have to make a decision based on the evidence that you've heard here. Okay, on the evidence. Now, let me tell you, to illustrate this, about something that happened to me about 1.5 years ago. Okay. We live in downtown Salt Lake, and we use that Costco or shop at that Costco on 17th South and 3rd West. Some of you have probably been there. It's the largest one in the world. Okay.
We are having a hard time hearing this.
Yeah, Mr. Six, where's the microphone for that? Is it on your chest?
Maybe it's not turned on.
Oh,
I'm picking it up, but it is just so faint in the room.
Says on.
I know, I mean, I'm picking it up just fine on for the record, but no one else can hear you.
Well, maybe put it higher on your laptop.
My eardrums have now burst with this coughing. Because everything goes through here.
Oh, here. Is it on?
Testing?
Sorry about that, folks. I just got gas at Costco. It was about July of 2022. No, 2021. And I was at intersection. It's a pretty busy intersection. There are 2 lanes, north and south, 2 lanes, east and west, 2 each. And there's a left-hand turn lane. I had a red light. And I was the first one at the intersection. Got a good look at it. I looked in my rear view mirror on my left side, and there's a green arrow for each direction going east and west, turning south and turning north. You understand that? So I'm waiting because I have a red light. And there's a lady across the way from me, car heading west but turning south. She had a green arrow, like I saw one her heading north. I look in my mirror, and here comes a guy at about 40, 45 miles an hour on the inside lane of 17 South. I said, my goodness, he's going to hit that woman. He's making that turn. And sure enough, smacked her and smacked her hard. Okay? Didn't slow down at all. Well, I had a good view of it, and the car spun around, but I was able to get by. There's a Maverick on the southeast corner of the intersection. Okay? I pulled in there, ran to her car, and asked her, "Are you okay?" Like everybody does. She said, "Yeah, I think so." I didn't think she was, looking at her, but she said she was okay. Okay. So I ran over to the other guy. I was the first one there. Some people were beginning to stop. And the guy that ran the red light said, "Are you okay?" He said, "Yeah, I think so." I said, "Well, why'd you run the red light?" You know what his answer was? "I didn't. It was green." Well, I wasn't going to sit there and argue with a guy like that
Yeah, it is
in
true.
those circumstances, but he said it was green. So when the police came a couple minutes later, and you got to be careful as an attorney, I gave them my card, not to get the case. You know, you can't do that, be unethical, but let people know who I was so they could call me. Get a card, and I gave each of the persons a card. And about several months later, I started getting calls from insurance adjusters wanting me to tell what happened. And I tell you that story because so often people that are in these types of events have a totally different viewpoint. So we don't hold anything against Gwyneth for her viewpoint. It's sincerely expressed, but she's wrong based on the evidence. Okay? And Terry's correct. Now, what's the evidence that Gwyneth hit Terry? Okay. Number one, and there's no particular order on this, but Terry's a strong skier, advanced intermediate. Mr. Christensen said he saw him going down the hill doing wide radius turns. That's side to side, all the way, back and forth. Now, on a beginner's run,
It's them. It's them.
that's highly unlikely for an advanced skier. You don't do that. You don't do that. There's too many people. And so that doesn't make sense. Number two, I'll call it the scream heard around the world. Okay. This is being broadcast everywhere, by the way. It's on court TV. I'm getting emails every day from Canada, Great Britain. There's a loud scream. Terry heard it. Loud scream. Craig Ramone heard it and looked over. Several other people heard it. Carrie Oakes said she heard it. Peter Christensen heard it, so caused him to look over. It's before the impact. And you don't, if you're the downhill skier, like Gwyneth claimed she was, you don't scream at something you can't see. You don't. It's the uphill skier that's going to make that scream. And that was Gwyneth Paltrow. Distraction. Everybody here probably been a parent. Most of you, not some of you maybe. But I've had my kids up there, and they want me to watch them ski. And mommy wants to ski. Now, Carrie Oakes said that, and that the deposition segment that you read said that 3 times. Okay, 3 times. And that's important. Can we show Gwyneth's deposition up here?
Your Honor, what are we talking about here?
Mr. Sykes, is this deposition testimony that was read into court?
Yes. Exactly.
And is it only deposition testimony that was read? Okay.
Deposition, meaning trial testimony?
Well, it was read into court.
May we approach, Your Honor?
Sure.
So you have to turn it down a bit. It's the volume, as in it's there in court. That with the echo. This will be interesting. Gwyneth is not a liar. Ba-da-ba-ba. Yeah. I'm not sure how long they got left each side. I think, well, it's not normal, no, but at the same time, it's not normal to read depositions in as part of your closing arguments. But also, this is civil, so it probably is very normal. Here we go. I mean,
You can
I
make the screen only show the part that was
I'm
actually
trying to
read
do
in
that.
court.
Is that okay, Judge, like that?
That looks good.
Okay.
it's fine, King. I think we're on the
Now,
opposite
Mr.
side of you.
Paltrow, isn't it true? Isn't it true? I'm just a country lawyer here. Okay. Isn't it true? Let's see if I can move it over a little bit. Okay. That your kids wanted to watch you ski.
6, yeah.
Or pardon me, that the kids wanted you to watch them ski. Isn't that true? Vegas at time. I can still watch my children ski and be skied directly into my back by someone. Okay? Which is what happened. Now I'm going to omit Mr. Owen's statement and my own. And here's how it reads. Isn't it true that your kids want to watch you ski? Or pardon me, that the kids want you to watch them ski. I can still watch my children ski and be skied directly into my back by someone, which is what happened. Now,
Yeah, there is 6 out of 8 for every single part.
here's my witness. And Craig Ramon. We thought about having him testify again today about those drawings, but we decided not to do it. But he saw the whole thing. He saw the impact. And he's the only one that saw it. That's a key piece of evidence. Now, who is Craig Ramon?
You did not see it.
He's
You
an
liar.
acquaintance of Terry. He's part of a meetup group.
You heard it.
He's not close to Terry. They went to get garlic burgers twice. Okay. He has no dog in the fight, ladies and gentlemen. No dog in the fight. He's independently wealthy. You can tell that by what he does.
Your Honor, that's assumes facts not in evidence.
Well, it's
Just a minute. Objection overruled. The jury will have to recall what the evidence was. And
the evidence was he sold his business, I don't know, 10 years ago, and all he does now is ski and travel and scuba dive. Okay. He has no reason, no motive to falsify this. Okay.
Yeah, that's
confirmation
money.
of those meetup emails that you saw. There was one of the last evidence, I think it was 44, was it? I won't go over it with you. But we printed that out, I think, Saturday or Monday. It gives you the number of days since it was entered. And you add those up, you go right back to February 26, 27, 28, around there. Strong evidence. Terry has repeatedly said to his medical providers that he was hit in the back over a period of years. And that he has problems, medical problems from it. The broken ribs, that's one of the strongest pieces of evidence you have. That Terry was the guy that was hit. He was the downhill skier. Okay. 4 broken ribs, 2 of them separated like that, weren't together. And that's very serious. It's very painful. But the pattern of those broken ribs, 2 MDs, one from Utah and Dr. Bain. So that pattern of broken ribs supports the fact that he was hit from behind. Now, I'm not going to go into all the details of that. That's what he said. And Dr. Bain, who just testified again today, said that Dr. Schur was simply wrong in his philosophy, or his formula. He assumed it was a free fall, and it wasn't a free fall. Broken ribs. How do you get that without a significant impact? Now, the flaky Deer Valley investigation, I think, suggests a cover-up. Eric Christensen, I think, was unbelievable and inconsistent. And there were a number of things. I'm not going to go over each one of them, but I will talk about one. The claim that Terry said he was okay. Now, some of you have probably had broken ribs or loved ones that have had them, you know. Even Steve Grant up here said it's extremely painful. Now, this whole process took place between 11:55, which is the time of Grant's incident report, and 12:02, when Ramon flagged down the ski patrol, and 12:04 when Whitney Smith arrived. So we're talking about 7 to 9 minutes, okay? And they would have you believe that a man with 4 broken ribs, 4, 2 separated, told not only Eric Christensen that he was okay, but 2 other unnamed, unidentified ski patrollers that never logged it in. He told them he was okay. Now that's just unbelievable that would happen to a person with 4 broken ribs, not just 1, but 4. Ski between the legs. I don't know how many of you are skiers. I don't remember. You said it in your interviews 3 weeks ago, but to have someone ski between your legs, she thought it was a sexual assault. Okay? But to have someone with both skis, to someone that's moving and shooshing back and forth, it's just another unbelievable claim. That can't happen. Now, and then Gwyneth skis away to lunch. The only way that Terry Sanderson knew that this is Gwyneth Paltrow is Christensen got angry and said, "Your buddy just took out Gwyneth Paltrow," which is an odd comment to make. Like, just took out a person, you know, but he had to put in Gwyneth Paltrow. That's the only way we know that. That's why you're here. Now, causation. This event caused an injury. Well, I've already mentioned this. The impact was significant enough to break 4 ribs. You know, the impact in the fall, that is a significant impact. The location, the right front, is where you would expect it under the circumstances. Loss of consciousness. It was only a few minutes, maybe 2, maybe 3. But there was a loss of consciousness widely reported in the medical records and that day. Widely reported. I mentioned the okay. I want to mention that again. So it was significant enough at the time. The very first thing that anybody noticed was that Terry forgot how to ski. He was snow plowing down the hill, an advanced intermediate snow plowing down the hill. Think about that for a minute, you know? And Craig Ramon says, "Hey, Terry, you forgot how to ski." And that's when Craig Ramon said, "I got to flag someone down." So he did. And he told that person, he's got a head injury. That's the words he used, a head injury. Now, it took him 5 seconds, and Craig acted it out up here, 5 seconds to be able to tell him his name. He didn't know where he was at first. That's a significant impact. That's a concussion. Now, ski patrol flagged down at 12:02. Whitney Smith arrives. What a sweet person. And Terry's taken off the hill in a toboggan. Now, you know, that's no fun, but it shows you something happened. she writes disoriented, rib pain, loss of consciousness. By the way, Alina Fong, who treats thousands and thousands and thousands of TBI victims, said loss of consciousness is not required. Okay, not required. Headache, and that day, I think at the clinic in Park City, dullness in the front of the head. And Whitney Smith said, go to the ER. And Dr. McMahon said, go to the ER. So the next several months, you have numerous symptoms of TBI that show up in the VA records. Cognitive, personality, social, and emotional. I could go through and show them to you, but you all saw them. But then, one of the most significant pieces of evidence here is a sudden and precipitous change in Terry Sanderson. Sudden and precipitous, okay? Now, I'm not talking about when he came home and Carlene, said he didn't want to be touched. He's got 4 broken ribs. But Carlene, who loved him, said it was a love relationship. She wanted to marry him. They've been together 300 days a year up here and then down there in St. George for about a year and a half. It's a long time to look at someone. She loved him. She traveled with him. She wanted to marry him. And you saw how she choked up when she explained how the relationship ended, that he changed. His personality changed. Polly Gresham, Shay Hareth, same thing. Big changes. They didn't see him as often. So that sudden and precipitous change is a sign of brain injury. Diagnosis of concussion. The VA diagnosed it. Multiple physicians diagnosed it. All the defense experts admitted it. Every one of them admitted it. They minimized the extent of it, but they all admitted he had a concussion. Every one of them. Every one of them. Dr. Gibby, Dr. Fong, Dr. Goldstein, Dr. Bain. The only question was severity and permanency. But every one of them, they didn't want to admit it, but they gave different numbers between 5 and 20% of people that get a concussion. It's permanent. They have permanent problems. 5 and 20% between that. Dr. Fong thinks it's higher than that even. Now, the physics. Dr. Bain explained the physics, I think, second day of trial, and a little bit today. But he's a neurologist, but he's also a biomedical engineer. That's different than Dr. Scher. He's a biomechanical engineer. But Dr. Bain specializes in how force affects the body. Very highly respected in that field. That's very rare, not very many of them. Terry talked about the loss of friendships. Mark Horath, good example. They were good buddies when skiing and didn't like him anymore. He talked about excuse me, the woman that he was going to Europe with. Don't remember her name, you remember it, but she changed her mind at the last minute and had an empty seat. That's how Jenny got to go. The experience of his granddaughter carried into her for how to tie a knot. Big changes. Greg Ramon said, Terry, after the accident, seemed like he could talk to the wall for an hour and have a good conversation. Faking. Every witness you heard from the defense, admitted that Terry was not faking, malingering, exaggerating, or magnifying his symptoms. And Dr. Goldstein said there are tests embedded in his tests to find that. No evidence of that at all. And by the way, the VA records continue up until the present day. And they didn't show you any single VA record where that was ever suggested of this man. NPH, they suggested, that could just the normative, what is it called again?
Normal pressure hydrocephalus.
Normal pressure hydrocephalus. He's got it, but no symptoms. And it didn't change over about a 13-year period. 2009 to 2021. Dementia, they kind of implied that maybe he's got that, but when we cornered them on cross-examination, not a one of them said he had dementia. And there's no reference in these thousands of pages of records that he diagnosis. Degradation of imaging, okay? We have imaging, I think, from 2009 to 2021, and all the defense experts, plus our own, said there's no degradation on these imaging. He's got white matter abnormalities, probably half of us do. Nothing showed in there. No problems. No increase. You heard that just as recently as yesterday. Now, I'm going to say just a few more things here in terms of time over to my colleague, Lawrence Bueller. This is actually his case. He asked me to help. That day when Terry left his home to go skiing at Deer Valley, that meetup group, February 26, 2016, he anticipated, like many, many other days in his life, a fun day of skiing. Okay? And he never returned home that night as the same Terry. He never came home, figuratively speaking. Terry has tried to get off that mountain, but he's really still there. Part of Terry will forever be on the Bandana Run, figuratively. People who are just after money, and that was suggested. He's just after money and fame. Somehow going through all of this and spending all the money he spent on experts, you know, he's doing it for fame. Give me a break. But he spent hours and hours trying to get better. If you heard anything about him, he is almost, what's a good word? Extreme in trying to get better. He does everything he can to get better. Anyway, we hope that you will help bring Terry home off that mountain with a fair verdict today. Now, before I turn it over to Lawrence, I want to say one more thing about executive function. Okay. I had an experience up here that taught me about that. 40 years ago, I was in the legislature with a guy named Glenn Brown. I think he's still alive. He's in Colville, has a dairy farm, or did. And I used to kid him about milking cows, you know. So he invited me up to his farm. Young lawyer, going to show me how to milk cows. Never done it. Got up there, and he showed me around his barn. It was really sophisticated. 40 years ago. I mean, it's probably better now. But when you think about why Terry never came home, think about this story and executive function. Because he put a little stool out there for me, and I sat down in my jeans and tried to milk a cow by hand. It's very hard to do for a country boy like me. I grew up in the city. But I was able to squeeze out a little bit of milk, you know. He gave me some, take home. Glenn Brown's a great guy. But I asked him about this situation. I said, how do you do all this? He showed me this very sophisticated situation that milks cows automatically. Does it automatically. He says, without this, Bob, I could never make it. Couldn't do it. Can't get enough people to come help me do it by hand, like my grandpa did. That's executive function. That's what it does for us. We're able to do a lot of things in life. And that milking mechanism was executive function for Glenn Brown's farm to produce milk. Now, this is one of Terry's saddest problems is loss of executive function. Okay. He cannot organize and manipulate his life to do things like he used to do. It's the saddest thing. And that's why part of him is still up there on that mountain. Thank you. Lawrence? That's my signal to sit down. I may have a few more comments for you when he's done.
Fuck knows. Oh, you don't wish it. I'd fallen asleep here. Oh,
Still, good morning. Good morning, everyone.
Mr. Kira, I don't know if we're picking you up yet.
Okay. Can I try this? See if it works on me? Sure.
Just do a testing.
Oh, wait. No. I have it on. Testing.
I'm actually just hearing it from you right there.
Testing.
Do you check the other mic by chance? Let's change the batteries.
Been my lucky day in technology.
I have sound problems. Jesus.
This case is simple. You've heard the first two parts of this. Who hit whom? And what are the damage that were caused to Terry? And then the next question is, how much are those damages? That's the part of the case I'll deal with. This case is about answering the simple questions the law asks us to put on the form that we call the verdict form, which you'll get in a few minutes, or maybe this afternoon. Verdict, that's an interesting word. It comes from Latin. It's actually two words. It means verus, truth, or dicta, or to tell, or told. So combined, it means truth told. And that's what you're here for, is the truth told. So what does the law want us to tell the truth about? Well, let's look at what the verdict form says. The first question is, was Gwyneth Paltrow at fault? As my colleague Bob Sykes said, the evidence is clear. There were 4 broken ribs, an eyewitness. There's lots of other evidence too, circumstantial evidence that Miss Paltrow hit Terry Sanderson on February 26, 2016. The stories have been consistent for 7 years. So the first question, we answer yes. Now, earlier, it was in jury instruction number 27, the judge defined what negligence is. And judges around the country have a hard time defining what it is. It's very abstract, very abstract. And what it means, basically, is they knew it was dangerous to ski while distracted. They knew that someone could get hurt if they continue to do that. And they did it anyway. Did they know the damage would be this serious? Well, we've all heard about collisions. Collisions happen on the football field. Collisions happen even on sidewalks sometimes. People get concussions. And Terry, there's no doubt, suffered a concussion. But Terry's damage is not just a concussion that goes away in a few minutes or a few days or a couple weeks. We know that Terry's damages, or his concussion, persisted for more than a year and a half. And that's been verified by Dr. Fong, Dr. Gibby, Dr. Goldstein, and Dr. Bain. Even the defense's experts admit that he had a concussion. They quibble on how long it's lasted. But none of those defense witnesses actually examined Terry. And as Bob pointed out, none of them really acknowledged that Terry had problems. One of them refused to acknowledge the before and after witnesses. His two daughters, actually three, but two daughters that testified in this trial, Shay and Polly, his friend Mark Harath, finally, or the first witness after Craig Ramon was Carlene Davidson, his ex-girlfriend. They'd known each other for 18 months before the crash, 6 months after the crash. She testified that the damage continued, thus making it a permanent, this is a tongue twister, persistent concussive symptom. And that permanent persistent concussive syndrome is the long-term brain damage that we're talking about. So what it means is every waking hour that Terry has, he's got this brain injury that causes so many problems for him, from executive function to just, being able to deal with people. And as those witnesses showed, Terry has a problem. He looks fine. It's an invisible injury. People know, that's what they say about brain injury. It's an invisible injury. You see someone with a brain injury and they look fine. What's wrong with them? If he has a brain injury, why isn't he in bed and moping around and not doing anything? Well, that's the opposite of Terry. The crash took much of what he had and left it on the mountain. Terry still has that drive to get better. Even though persistent concussive symptoms are permanent, they last a lifetime. They last forever. So 16 hours a day, Terry is dealing with this injury, such that, as Bob mentioned, when people get to know him, after a while, they don't want to deal with him anymore. I'm sorry I have to say this, but I've known Terry now 6 years. This is just argument, but it's real. Now, the 4 broken ribs, those were painful for maybe 3 months or so. But the brain injury has persisted to this day and will last until he dies. The executive function, the social abilities, the mental problems, driving to the store, not knowing where you are and having to use GPS just to get home. These are real injuries that Harry, who was a very bright person. You would not know it just talking to him for 10 minutes. But once you get to know him better, you realize he's got these problems that just change everything. So as I talked to someone left me a message, and every time I hear this voice message, it just makes me cry. Just because it's so just kind of flat, but he says, you know, this person suffered a similar injury 30 years ago, a persistent concussive syndrome or injury, permanent brain injury. And she said, it's permanent. Your personality change is permanent. And you lose everybody who knows you. You lose everybody. Yeah, your family, they'll put up with you, and maybe the lawyers, but really they're just putting up with you. So let's go to the next question. Well, I'm going to go through, because this is a complicated case, Ms. Paltrow is suing for $1. We're going to go through these next questions. Was Terry Sanderson at fault? Terry was hit from behind. Greg Ramon saw it. The rib injuries show it. Now, Dr. Scher, for the defense, who's not a medical doctor, he's a mechanical engineer, deals with ski bindings mostly. He says that Terry Sanderson likely skirted under Gwyneth Paltrow and somehow twisted around and broke his ribs. As Dr. Bain confirmed again today, that's impossible. It defies the law of physics. So I think you have to answer no. I mean, it's a clear no. Was Terry Sanderson at fault? Number 3, no. So then you go to 5 below. And since 1 is yes, this is like a puzzle.
No, it's funny, mark it. Mark it.
Here, I got a pen. I've got one. So was Terry Sanderson at fault? I'll go back to the first page. Was Gwyneth Paltrow at fault? Yes. Oh, I forgot to do number 2, and you have to go in order. Was Miss Paltrow's fault the cause of Terry Sanderson's harm? It clearly is. Terry Sanderson was hit from behind. There was a scream, and he was hit from behind. So the answer is yes. So then we go to 3. And because we answer number 0, and to be honest with you, this is the first time I've seen the form because it was just finalized just before we started the, so I have to think about this one a little bit, but let's think about it together. What % of fault do you assign to Gwyneth Paltrow? If your answer to either 1 or 2 is no, then enter 0. Well, both are yes. So we have to, because Terry Sanderson did not cause this crash. You can't cause a crash when you're hit from behind. What % of fault do you assign to Terry Sanderson? Well, it has to add up to 100, so you have to put in 0 there. If Terry Sanderson's fault is less than 50%, answer question 8. Well, it is, so we skipped 8. What amount fairly compensates Terry Sanderson for non-economic damages? Non-economic damages. Our time on Earth is the most valuable time we have, that we know of, at least in this existence. Our time on Earth is one of the most valuable things there are. There are paintings on a wall that are worth $50, $100 million. There are houses in these mountainsides that are worth 5, 10, 20, much more millions of dollars. There's even racehorses that are worth tens of millions of dollars. Well, Terry's none of those. Terry's in the last days of his life. He probably has at least 10 years left, according to what a lot of people think. He guards his health. He doesn't smoke. He's trying to pursue a healthy lifestyle every single day. Yeah, he goes to the doctor, but since the crash, it's been 7 years, and let's say another 10 years. Every single day, he's got a 16 hours of dealing with this brain injury, this persistent concussive symptom that causes all these problems. So how do we calculate that? As the instruction says, for non-economic damages, jury instruction 35, which you all have, it gives a detailed instruction about that. Pain, suffering, loss of enjoyment of life, and a retired person, well-to-do person like Terry, who worked all his life, these are the golden years. These are the most valuable years when you can enjoy your retirement and actually do things like travel. But now he has to travel with other people or he gets lost. Dr. Fong and his other therapists, most of his therapists have said, what's the best way to deal with, your brain injury? Well, do the things that make you happy. Be active. He could sit around and mope around and be an obvious brain injury victim, but no, Terry doesn't want to be brain injured. He wants to live life to its fullest. So 16 hours a day, he's got this issue that where a big part of him was left up on that bandana ski run. So you have the power here. This is, before we were just arguing and presenting evidence and the judge was ruling on it, but now the judge is going to pass the case to you. And this is where you decide what happens next. So I'm going to suggest, I'm not going to ask, this is not Terry asked me several years ago when I first learned of his case, well, what do you think it's worth? I said, well, Terry, if you could turn the earth backwards like Superman, go back in time, and how much would Terry take to not have what he has now? And he says, I'd rather go back in time and never have this. So how do we calculate this? Well, I'm going to suggest a number. And this is just a suggestion that we do it with 16 hours a day. About the formulas, Dr. Bain and Dr. Scher gave you a lot of formulas, but hopefully these will be simpler than all those. So that's 16 hours a day. Times 365 days a year. Then the next question is the years. Well, it's been 7 years since the crash. Terry's likely to live another 10 years. Probably, we hope longer, much longer. He wants to live at 130. But, at least 10 years. So 7 years since the crash, 10 years, that's 17 years. So we're going to times the next number, 17. Then the question is, how much is not the price, there's no price that you can give for Terry's time, but what is the value that's been taken away from Terry? What is the value? I mean, they're lawyers and they're experts and lots of people here that are making low wages, but a lot of people are making $300, $400, $500 an hour. Well, I'm just suggesting a number. You can put in whatever number you want. This is for the non-economic damages that Terry deals with every day. So that's the next number. 16 times 365 times 17. I'm going to suggest a number. You put in the number you think is fair for Terry. The full value of the harms and losses that he's dealing with every day. I'm going to say $33. $33. And I've done the math because I told you in the opening, you know, except for the small change at the end, you know, a couple $100. This equation is $3,276,000 for the 17 years that Terry has to deal with this permanent brain injury. Yeah, you could say, well, you know, it's priceless, but you know, an old shoe that's priceless. No, this is the most valuable time of his life, and so that's the amount that I suggest you consider. So, what is this case not about? It's not about celebrity. It's not about that. Yeah, there are lots of indications of that, but this is about a man's life. What does the defense want to make this case about? They want to make it about Terry's multiple issues. The 69-year-old Terry that was on that hill, oh yeah, he had all sorts of medical problems, but the defense wants to make it about that. But that didn't mean, I mean, he was skiing on that hill at Deer Valley. I can't think of any place I'd rather be skiing than Deer Valley. Maybe, you know, backcountry Powder, but the point is he was healthy enough to ski, and now he doesn't ski. Now I'm going to tell you a quick story about the legend of King Morgan.
Oh, fuck me.
King Morgan was the real king back in England about 1,000 years ago. Back then, the kings were the law. Someone had a dispute, a farmer knocked an eye out of his neighbor. It was eye for an eye justice. They'd take the eye out of the guy who did it. And what did the victim get? Nothing. Well, King Morgan one day said, you know what, I'm going to invite 12 of my nobles, you know, the guys that have the littler castles. And I'm going to have them come in and I'm going to have them listen to a case. And he heard the nobles heard the case, and then they said, well, we think it should be decided this way. And the king said, yeah, you're right. And that's good. So they did it a few more times. And finally the king said, you guys decide the cases. I'm going to go off and do what kings do and hunt and fish and fight battles. Well, that's the same system that was adopted in the Magna Carta almost 1,000 years or 800 years ago. And it's the same system that was brought over by the pilgrims that we celebrate Thanksgiving for. And it's the same system in our country. And we're the only country that still has the jury system where people like you decide the cases. Winston Churchill, the Prime Minister of England during World War II, he said, America is a great country. And one of the reasons it's so great is its jury system. And no other country has it. And if you want to weaken America, take away its jury system. Thank you.
Hey, it wouldn't be a bad thing to get rid of the jury system.
We'll take a short recess before we continue. Maybe about 15 minutes.
Yeah, we have 15 minutes, then another hour, and another quarter of an hour. So about an hour and a half till close. Oof. You're about 55 minutes there.
Minute break.
Didn't you say 15?
Right. Yeah, he should not be scuba diving. And yes, social media has corrupted a lot of people. Once I come back, I might just go quickly get a quick sandwich and just eat it off screen because I'm starving. It's gone 7 p.m. here. I've not had anything since lunch. It's not a bad thing. How did you block the show? No, Joe, it's not lunch. Quarter of an hour break, then another hour and a half, and then lunch. So lunch will be my time by half 8, which is at your time about half 3. But I'm gonna have lunch, like literally. I got a sandwich made, so I'm just gonna eat it off screen whilst I listen behind the wall behind this. Oh, it's all making me sleepy as well, which is not great. Yeah, it's not great here either. New York is nice, so um, it's getting dark, because it's literally now it's 7:05, so I've got to get my sandwich to re-energize myself. It's quite hard. Also, he was lying in his closing as well, which made it even harder because it's frustrating to listen to. The whole at thing doesn't work, does it? When you at Joe, does that work? Because it doesn't work when I do it. Bum, 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 bum. Your body, yeah. Oh, hang on. Does this work? I can try this because it doesn't matter if you guys Did you guys hear that? Low music. Hmm. Hang on, let me just see. What about now? If you can, how high is it? I put it down at like 24, 25, like, so it shouldn't be loud. Jam in, Joe, jam in. Top's coming off. Fuck. Oh, it's background. Yeah, it's supposed to be background. Just something. I can put it louder if you guys want to. I'll just try. Because for me, it's not quite right because the earphones. But yeah. I just thought about like Joe when he's smoking weed. I thought he might enjoy a little bit of music, like. So Joe, the defense are on next, and then the rebuttal afterwards by the plaintiff. So the defense have an hour next, and then the plaintiff said they got another 10 minutes, quarter of an hour after that. So yeah, they finished with one, but still an hour and a quarter-ish to go. He might be, but depends who's doing the final speech for them. So I'm not sure. Oh, sorry, I'm not putting stuff on, am I? He might be. I don't know who's actually closing. And he's 6 of 8 for every single argument. So it's, what was it? How many? 42 did we say? You need to get 6. No unanimous or anything, just 6. The 6 people go in there and go, yeah. Doesn't matter what the other 2 say. And it doesn't have to be the same 6, it's any 6. So look at this now. Ooh. It's been a slow day. That's 21 in Rumble. 20, sorry. Yes. So up to 458 subscribers. I don't think any of them have fucking entered the competition. If we don't have results back today, I will be back tomorrow. To do some, if I am here, I'll try and put some stuff on. I know I want to watch Peter Trigo, so he's got 2 videos I want to watch. They should be about 2-3 hours. That'll be this afternoon. If people want to watch that, happy days. If you don't, that's fine, mute it, but keep yourselves here so I get some watch hours. This week's been so slow to get watch hours. Watch hours are how many people are actually on stream, as in watching. Yeah, Joe, we fucking are now. We've given our heart and soul to this. I mean, I hope you all are invested in it, because... Do you know what I mean? We've been through the pain barrier. Oh. Erin, if you're here, thanks for tagging Sarah as you know what I mean, Sarah. She did comment. Do you see her comment? She didn't comment on your one, but you're the reason, because I think your comment prompted her to have a look at the video. Right, I pause the music. I'm going to pull the curtains in a bit and put the lights on and get my sandwich. These California times, they're wrecking my body clock. Wrecking it. That's funny. The father those bots on Twitter. Fair play, that. Oh, Yankees are up. They're not playing the Mets, are they? Because they normally lose to the Mets, don't they? I know nothing about it, so I don't know who your rivals are or anything. I know you've got that one guy, did you? He had loads of home runs last season. That's all I know. Who won? Who are you supporting? And who's the twins? I can find out who the twins are. I can Google it, but who won? Isn't there one team that's cursed or something? They're a good team, but then when they get to the series final, they always lose. Is that someone from Chicago or Boston or New York or something? Or am I making that up? I'm not sure. Oh, oh, so what? Yankees lost, Joe. Ah, okay, yeah. Because the two of you were talking, I was like, oh, which one? Because you said Minnesota won, winning that game, and you said they lost the series. So I was like, the Twins? No. Cool. I I think not basketball, baseball's like a day event, isn't it? You can just sit there, stroll, um, but you can't really, I don't know, just watch. I watched some of the college ones, but that's about it. I watched Ole Miss win an NCAA this year. This was, oh, sorry about that. Oh no, next day. I thought it was next year. No, that's crap, isn't it? Well, I mean, I'm sure he loved the fact that he spent the day with you. Do you know what I mean? I know he would have appreciated that. That's for sure. Oh, well, great memory for him. Oh, I bet you loved that. Yeah. Right, they should be back now, but for whatever reason they're not. There's about an hour and 20, well, I say an hour and a half left before the jury go. We are running late. We're running much later than the judge wanted to. He wanted to be done by 12 today, half 12 maximum. But nothing we can do about it. I'll play some music as well. That's a cool story. One. And he's on my bed crawling. Right, here we go.
Thank you. Are we ready for the jury? We are? Okay. We're ready for the jury.
Eleven, wow. Well, you got 4 of you.
Can we be clear on time? I think they took a full hour. And do they?
7 minutes less.
All right, thank you. Mr. Owens, you ready to proceed?
Thank you, yes. Just to be clear, because James is going to share the time with me.
Sure.
And is the plaintiff reserve any time for rebuttal?
They reserved 10 minutes, which I granted them.
And so do they have an hour and 10 minutes? And do we have an hour and 10 minutes?
They reserved 10 minutes, so you can proceed.
So we have 1 hour.
You can take 1 hour, and if it happens to go over because you're finishing a topic or something, that's fine.
Thank you so much. Well, folks, we didn't even know each other 2 weeks ago, and here we are. Thank you. It's a beautiful thing, I think, that we resolve disputes in our country in this way, just like Lawrence mentioned. You're plucked and really against your will, even if you had to fight it. In theory, one of these bailiffs could go arrest you and come and make you come here. So we don't do that with anything else, but why do we do it? Because it's such an important thing to resolve disputes in our country in a peaceful manner. So, thank you. I'm Miss Paltrow's, and I'm going to just call her Gwyneth. I'm Gwyneth's lawyer. I'm her spokesman this week. So she sat there for 2 weeks and been a punching bag. We've blown through a lot of these cute little Post-it notes where she's sending me stuff. But I take it very seriously because she's comfortable in a lot of worlds I'm not comfortable in. But she is not comfortable in this world. It is not a nice thing for someone to throw a press conference and say, like King Kong, you knocked him out and walked away, skied away. That is not what happened. And the court has actually dismissed the idea, and that's one of your jury instructions, that this was a hit and run. That took no small amount of work, by the way. But that is what she was faced with. It takes a lot of courage, does it not, for her to sit there for 2 weeks and be pounded like a punching bag. What did she lose? Did she lose? Oh, that's too bad. You had to come in early and have a massage. No, this is what she lost. She was in love with Brad Falchuk. Dated for 2 years. They both had, very interesting, I think, 9-year-old sons and 11-year-old daughters. It's kind of cool. And they said, how are we going to get these guys together in a loving, fun time? They're very busy, where we can kind of all be together for a couple days and see if this will work, if we can blend our families together. We're going to make it relaxed. We're going to put a lot of planning. She put a lot of planning into that trip. And so here they are. It's a little delicate because anyone who's been through like trying to blend families, it's a delicate thing. So what happened? They got there. They're organized. First day of skiing. They have ski instructors. By the way, I thought it was cool. I don't know if you did. Her dad taught her to ski at Alta. And she has tender feelings about that. She's been tearful with me in describing those ski trips with her dad, because her dad died in his 50s. In fact, it was so painful, she didn't ski for a long time after that because she would miss her dad. But when her kids were of this age, and we're talking with Brad, Brad was a big skier. We didn't get to hear from him, unfortunately, lack of time. But they were going to come, okay, let's get our kids together. So what did they lose? They lost a half day of bonding, and even more, because now everyone's stressed. That was the day
when they bond up going up the ski lift, they bond having hot chocolate mid-afternoon, they bond relaxed laughing around the fire. At night. They lost a deep cost to my client. I told you when we first met, I wanted to concentrate on a couple things about Lady Justice here. By the way, if I didn't make it clear, you are Lady Justice. All right. Blindfold eyes. Because she's blind? No. She's smart, but she's not going to be distracted by chaos around her. Chaos like media, chaos like sympathy. Oh, don't we all feel bad for him? I would have liked, by the way, at least a discount on the camel ride on your request for damages, but that's another issue. The idea is, okay, we're going to focus. We're going to focus, and we've tried, and the judge has given you all these warnings. Don't be talking to people. Don't even talk to yourselves yet, because we want you focused, and that's Lady Justice. Now, I talked to you earlier about the scales of justice. This is a civil claim, meaning the preponderance of the evidence. The plaintiffs brought the lawsuit. That's why we're all here. His daughters say, isn't it terrible? These two daughters that he's brought here, his life is laid open. It's because of him. He hit her. He hurt her, and he wants $3 million for it. That's not fair. The easy thing for my client would have been to write a check and be done with it. But what does that tell her kids? It's cost of business. No, it's wrong. It's actually wrong that he hurt her and he wants money from her. And that's why we're here. All right. So back to the scales here on Lady Justice. He has the burden to tilt. Okay? Tie goes to her. Now she has a $1 counterclaim. My wife said, don't waive the dollar, and I'm not waiving the dollar. But a dead even tie means neither get anything. And I'll walk you through that in just a minute. But let me suggest it's not even close. Let me suggest it's like this, the evidence here versus here. And let me talk to you about that. Let me mention a couple other jury instructions. So I talked to you about no sympathy, passion, or prejudice. We don't want you making decisions on that basis. I talked to you about the burden of proof. That is theirs. And then from today, let me talk to you about a few things. By the way, the burden of proof was evident because they get the last word. Because they have to tilt the things, you may have noticed this morning they could call a witness, and after I'm done, they can speak for a few more minutes. And that's what we do to the people who have a burden of proof. Instruction 30 that you were read today. Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Press conference 4 years ago. King Kong came out of the jungle, left me unconscious, and brushed off and went away. Utterly BS, and it's been discounted. It's not even before you. The judge took that away from you because it was so obviously false. 31 deals with spoliation. That's the GoPro issue. Spoliation is probably a word you've never heard before. It's a legal term. But the idea is if they destroy evidence, you can assume that it was bad for them. All right, so Terry, in fact, I should say Mr. Sanderson, in fact, owned a GoPro. All right.
He talked to his daughter that night, 6 p.m., so about 6 hours after the collision. She got off the phone with the understanding that he had a GoPro video of the incident and typed to him, "I am so glad that there's a GoPro and that you're okay." All right. No one has the GoPro, but I'm telling you this, if you find that there was a GoPro and that he said, that will not help my case, delete. If that happened, you can conclude that it was against him, that it helped us. And wouldn't it have been nice if it had been around? Do you remember when we talked 8-9 days ago? I said, you're going to hear so much stuff about damages, so much stuff. But if you find that he hit her, you can ignore it. So we heard like a week of testimony about Mr. Sanderson's brain and how he thinks. He does like to be the center of attention. He likes to be in the spotlight. His own daughter said he would be dishonest for money or notoriety. Does that make you like uncomfortable? It makes me really uncomfortable. When Dr. Gibby was up there, he said, oh, he has a great relationship with his daughters. It's like, who? He says, two daughters. There are 3 daughters. You can't just pretend this stuff away. 3 daughters. It's pretty important, isn't it, for a witness to know that he's not in the least good relationship. And why? Because she said he was abusive, and a lot of other adjectives that I'm not actually will defer to you to remember. So Miss Paltrow is asking for her dollar, but it's not about the dollar. It's not about. I mean, think of what her time is worth sitting here for 2 weeks. It's not about the money. It's about kind of ruining a very delicate time in a relationship where they're trying to get their kids together. That's what Terry Sanderson caused her. Pre-existing conditions. Oh my gosh. How do we not talk about what was going on right before and what versus what's happened after? He's 76. I mean, my parents, I'm not being flippant. They were dead by then. They certainly weren't taking 10 trips around the world. So we have to look at that. Those are the jury instructions. I do want to tell you the special verdict form that was appropriate. Can you bring that up? Lawrence walked you through it, and I don't think there's any harm in me telling you what I want. Is there? I'm going to ask you to fill this out. This is what you go to the delivery when you deliberate. These 3 pages. The last page really is nothing. So it's essentially 9 questions. And I want to show you how I want you to fill it out. I'm not trying to be subtle. All right, so was Gwyneth Paltrow at fault? No. If you answer no, go to question 3. So next page. Then you have to, that means Terry Sanderson's not going to take any money away from today. If you write no, so no on 1, you are done kind of in terms of his claim. Then you go to paragraph 3, which is our claim. Was Terry Sanderson at fault? Yes. We want you to say yes. Was his fault a cause of her harm? Again, we're asserting $1, but it was so much more. It made everyone nervous all afternoon. Was Terry Sanderson's fault a cause? Yes. And then, James, if you answer, regardless of your answer, go to 5. If your answers to question, so this is like a tax form where you have to like read it 4 times, sorry. If your answers to questions 1 and 3 are both no, 1 was, is Gwyneth at fault, you should not proceed any further.
and you go to the end and sign it. And this is because you're trying to figure out, was she at fault? Yes or no. Was he at fault? Yes or no. Did it cause any damage? You can actually find today that neither were at fault. Skiing is an interesting thing. We strap sticks on our legs at the top of a very high hill and go down for fun. It's breathtaking. I've done it. I love it. But it has inherent risks. So the back of every ski pass you've ever seen.
Judge, objection, you've excluded this inherent risk of skiing.
We referenced this, Your Honor. You said I could argue.
It applies to resorts and not to people.
No, the argument is improper, so overruled.
So inherent risks, you've seen it on the back of every ski pass, and even your own common sense says, hey, if I don't go down this hill right, I could actually kill myself. So skiing is different. It's even different than driving. I mean, we don't drive cars down hills, right? Down icy hills, but we do ski down icy hills. The Deer Valley guy would say, we're never icy at Deer Valley. But nevertheless, it's kind of a dangerous thing. And so you can actually say, no, don't get me wrong. I want Gwyneth paid for the hardship Mr. Sanderson caused her. He hit her, he hurt her, and he's not entitled to sue her. I'm sorry, he's entitled to be here today, but he's not entitled to be rewarded for hurting her. That's not how this country works. All right, James, let's see. Then if we go, if your answers to 1 and 3 are both no, you should not proceed further. So if you found not at fault, you're done. You go to the end and your foreperson signs it. But if you keep going, otherwise continue to 6, James. I couldn't do this without James, if you can't tell. What % of the fault to you assigned to Gwyneth Paltrow? So then you have to figure out a percentage. It's possible that both people are at fault. And how this works is you take 100% pie and you find out, okay, Gwyneth's 10% at fault, Terry's 90% at fault. So a lot of things aren't just so obvious, like gray and white, black and white. We would, obviously, if you get this far, we'd want you to put 0 apportionment to her, Terry, 100%. I guess you could find that Gwyneth's entitled to 75 cents and not $1, believe it or not. Okay, then we keep going. James, whatever you can find here. What amount compensates Terry Sanders? And we just want you to go to 9 and give us our $1. There was a little issue raised about whether her attorney's fees could be added to that. The judge has said, I'm going to deal with that. That's not in front of you. All right, so your topic is this $1. Believability of witnesses. This was one of your earlier instructions. How do I figure out who's telling the truth here? And I'm going to put Craig Ramon. First of all, Terry doesn't remember much. There was one just blatant misstatement in their closing, which was Terry could talk to a wall for 2 hours and have a pretty good conversation. That was before the incident. That was misrepresented as being after the incident. Every time that issue came up, I said, before? Yes, before. All right. Let's go to talking about evaluating witnesses. I'm telling you, if we were in law school and we had a class about eyewitness, how an claimed eyewitness actually sees what he thinks he sees, Craig Ramon would be the definition of a bad witness. And I'm going to give you some objective statements about that. He's at the end of the court. He says, I'm skiing. And there at the end, I'm colorblind. I have imperfect vision. I don't know what they're wearing. I'm looking at other things. I'm not focused on them. He said he hears and turns. Well, guess what? Eric Christensen, the ski instructor, who they accused of a cover-up, which was dismissed, heard and turned. They're the same. They heard and turned. Craig describes himself as an eyewitness. Eric said, I didn't see the collision. I just heard and turned. They saw the same things. Interestingly, Eric came right over, and now's appropriate time to watch our little fun video. I don't know if you like these animations, but we kind of put them together so that you guys can kind of envision all this information coming at you. So Eric Christensen, did you like the guy? The guy is like, oh my gosh, I love this guy. He's been doing it for 40 years. He teaches art on the side. He's been a lifelong resident. He's married to someone whose whole life is skiing. And he is not a liar. He is not someone who covers up. He is not someone who falsifies reports. All of those allegations were thrown out. So we're not dealing with Deer Valley. Interestingly, it's not just Ramon versus Christensen, because all the Deer Valley people, do you remember the cool Whitney who took the toboggan woman? I mean, she's an amazing witness. She's up there, oh, I'm assessing things all left and right, you know, nothing, but that's a little different. So we're gonna play this, and I think Moses is in orange. And there's Terry. So Eric Christensen says he sees Terry out of the corner of his eye. Well, he looks and sees, because he's in charge of sort of protecting these kids. So he says he's always looking up the mountain, and then he hears and turns, and then the next view, the next one. By the way, no one but Craig has the guy spread eagle with his head down the hill. There's no facial damage to his face. His skis stayed on. You've heard from these structural bioengineering people. If he came and got hit like Craig described, his skis would have popped right off. You don't keep your skis when you get blown. Sanderson says he was airborne, that he was flying. First of all, I'm not going to get into the weight, have him sit on scales, but twice, by the way, not once, twice Mr. Sanderson said, I'm 3 inches shorter and 15 pounds lighter. We're not talking about today, we're talking about then. Then he was 3 inches. I don't know if he shrunk 3 inches since then, but he described himself as pudgy. He's coming downhill at a faster pace. I mean, anyway, the structural engineering people, which is kind of interesting, not structural, biomedical engineering people. I don't know if you got bored in that part or was interested, but I'm telling you, the science does not work for Craig's theory. Okay, so we're gonna play this. Mr. Christensen, am I in your way, Judge?
No.
There's Moses, Carrie Oaks, Apple. It's a little hard to absorb, but here's Gwyneth, and there's Sanderson. Now, let me tell you what Sanderson said, and he said it just at the end of the day yesterday. I said, tell me what's going on right before the incident. He said there was a lady on his left that was kind of tentative. So I deliberately, I think I said, passing on the right. Pretty sure I did. So there's the woman he describes in green. And he's trying to he's watching her. He is blind in his right eye. He said, I use that term loosely. He's an optometrist, for heaven's sakes.
He's blind in that eye from a stroke. He is helped him contribute to his retirement. Okay, so he's watching, and imagine this. I'm blind in my right eye, and I'm really mindful of not hitting this woman to the left of me. And then he said, nobody could have passed on my left except the gal I just passed. So that gal I was real conscious of because I still worried about her. And so as I went past her, I went inches per second past her. I just remember it took forever for me to get past her, and there were skis. And then that's when the collision happened. All right, so maybe run it one last time, James. So he's looking to his left with a blind right eye to make sure he doesn't hit the woman. He's looking to his left, and what happens? Gwyneth described, and praise to the judge for not letting this be reenacted with Gwyneth and being assaulted in front of us all. She is skiing, and two skis come in between her, and this is not a big hill. By the way, I mean, these are kind of photographs. This isn't just claymation here. And comes in, and she's like, what is happening? They're not going that fast, but Terry's going faster because his skis are coming in between her. It's because he's looking with his one, by the way, he has like half an eye because he has a cataract in the left eye, hearing's shot, and he says, I'm getting too old. I can't do everything I can. Well, I stopped playing church basketball after my knee injury. I'm like, I love it, but I can't do it anymore. Okay, so sometimes we have to give things up, especially when we're 76 years old. I'm sorry. I mean, that's life. But he comes in between her legs. She's going, what is going on here? It's not like a ski collision hit, you're out. And he's grunting, his body's against her. She's thinking, am I being assaulted? Because this isn't really a ski collision. And then they go for a little while. She said spooning. And whatever the next next animation would be, James. And then they go to their right. Now, I don't know, you've heard the ribs issue. By the way, if you're 76 with osteoporosis, you can break your ribs. You may see, and this record's in your documents, these weren't dramatic breaks. I mean, two were not even distended, dislocated. What's the right word? Displaced. Thank you. Two were not displaced, and two were just very minor displaced. Did they hurt? I'm sure they hurt them. I'm sure they did. All right, so she is on top. Eric Christensen said she was on top, and their skis are intertwined. And what is she doing? She's like, okay, I see I'm not being assaulted. And he may well have hit his head. He does have a helmet on. So does she, by the way. Craig Ramon is like, no helmet. He tried to change his testimony on the stand, but I had questioned him like 5 years earlier. No, she didn't have, I was really surprised. No helmet, no mask. Give me a break. For anonymity purposes as well as safety, this is a person skiing with her kids. She's pretty focused on safety. Let me just tell you that. All right. So what's the first thing does? Eric Christensen, is this the last one? Is this the last of the
There were only
animations?
3 admitted, Judge.
Pardon me?
Only 3 were admitted.
I think there were 5.
3 full ones.
3.
Whatever you can take us to next.
Well, but you've already shown 3.
There were 3 videos that were
Eric
that were entered in their total, and then there were 2 only partial. Is that right?
Correct.
Okay.
So whatever you can give
2
me.
partials that didn't show the actual impact.
Only Craig has their heads downhill. Moses who you'd love him if he's a cute little 16-year-old now. But we only got to hear him. He skis over because he doesn't hear anything, but his instructor comes over. He comes over and he sees his mom on the ground. Now downhill because she's gotten away from this guy. Okay, I'm safe. The idea of an assault just entered her mind. She said for a couple seconds because she's going, "What's going on?" This is the overhead view and run it as you can. Here's Miss Paltrow. Apple, Moses. Here's Miss Paltrow. Here's the beginning skier woman. Here's Sanderson. And she's making these small turns on the right. He's making big turns. He's a lot faster. He's a lot more advanced skier, I should say. All right. Here's Christensen. You remember we placed him. Carrie Oakes went on ahead with Apple. Apple told me she heard a commotion, but she was hangry for French fries, and she just wanted to get down the hill. Moses is here. And so there we go. Okay, any other animations? Looking uphill. Paltrow in black. Sanderson. Beginning skier in green. Woman. Watch Sanderson. And then we're done. So it's probably that third one, that two back, that's probably the most powerful of them in terms of showing you the layout. All right, how am I doing on time, folks? I want to leave James 10 or 15 minutes.
30 minutes so far.
Thanks. So I'm going to 10 after. Thanks, Judge. After they've separated, Brad Falchuk comes up, she skis down, but there's then this period of time. So here's Eric Christensen. Eric Christensen said, I came over to find out what had happened. They say he came over to bully him. Deer Valley employees who bully their guests get fired. He's been there 40 years. You could see if his grandfatherly demeanor makes sense under Craig Ramon's story. It doesn't. It doesn't. Eric comes over and he says, first thing I'm doing, I'm taking off skis. Remember, under all stories, no skis came off. That tells you something about the manner of the collision, doesn't it? It wasn't like Ramon describes, flat out straight. By the way, Ramon, oh my gosh, he says he's out cold for 2 or more minutes. Do you know what did you do about it? Nothing. Nothing. Could you imagine looking at an unconscious person, splayed out, head down, skis on, for over 2 minutes? Could you imagine? I'm like, did you call 911? Did you check for breathing? No. None of that. I mean, good grief. Give me a break. All right. Eric Christensen comes over and says, okay, let's take skis off. Remember, he had some personal knowledge because he knew kind of where Gwyneth was, and he kind of knew where Eric Christensen was. He knew where they were, downhill versus uphill, and he knew their skill level. He could tell, he said he could tell because Mr. Sanderson was an advanced skier because he didn't slide. I didn't really know this, but if you do kind of, you skiers will maybe know. If you can work your edges and you don't slide, apparently that means you're a more advanced skier. Okay, so he comes over, he's trying to figure out what's going on, but he actually knows some things. Gwyneth is pissed off. If you hit someone, do you yell at the person you just hit? No. The hittee, and I've been hit skiing, is usually the unhappy one. But she recognizes these things happen until he says, "Did you hit me?" And she's mad because not only has he hurt her and hit her, but now he's saying, "No, I don't think, I think you caused this." And then she's like, "Are you kidding me? You just ran in my effing back." And Moses heard it. Moses heard it. All right. So then Christensen, who I think is just a fabulous witness. I think everything he said is just utterly true. It's consistent with everything. He took off skis. I said, was Sanderson ever out cold? No. If he was, it was like, it would have been like that. Gwyneth, was he out cold for 2 minutes? No, he wasn't out cold at all. Don't you think people would be going like crazy if there was a man splayed out on Deer Valley, head down, out cold for minutes? That's not a believable story. Eric Christensen now is engaging people. Gwyneth's mad, but she's okay in the sense that she doesn't need help. She can still ski, but she said her knee, which she'd already had surgery on, hurt, and she has sustained a blow. I mean, I don't know if you've ever been hit, even if you're in a football game and you're all padded up. She had sustained a blow. She was upset. And then this idea of him not sort of, she says, you know, you just did this. And then what did he say? I'm sorry. Does the person who got hit say they're sorry? No. The hitter says, I'm sorry. And he said it. I'm sorry. I'm sorry. Okay, now she's okay. Okay. He's not denying the stupid thing he just did. But okay, now we got to sit around and kind of we'll sort things out. Then Christensen goes to Sanderson. Tell me what you want to say. And he said, she appeared right in front of me. That's what he said in his report. She appeared right in front of me. That's consistent with Gwyneth being mad and saying, you just skied into my effing back. And it's consistent with Christensen seeing kind of what was going on. He was the uphill skier. He knew that. And there you go. That's, if everything's consistent. Now, if he'd said, I didn't do it, she hit me. Okay, whoa. Now we got to investigate. And then you recall, so okay, it's clear who did what. Christensen says to Ramon, your buddy just took out Gwyneth Paltrow. I think this was just after she skied away. And what did Ramon say? Did you correct him? No. That's the time to say, no, I saw it, and she hit him. That was the time. Ramon didn't say a word. He just sat there. He's not helping his unconscious friend, and he's not denying, under his story, what the ski Deer Valley representative has just determined. Your buddy took out her. All right. So that's the time to do it, not later. Remember, one of the things I said in opening is rely on the evidence before there's thoughts of lawsuits, because then you can kind of rely. People aren't thinking, okay, 10 minutes later, oh my gosh, Gwyneth Paltrow. Wow, that's something else. We were just in a collision with Gwyneth Paltrow. Now people are thinking, okay, wow, I'm famous. They're not thinking that yet. In real time, he's saying, I'm sorry. And then, are you okay? Everyone always asked this question, are you okay? And he said, I'm okay. Now he tried to change it a little bit and we had to go to his transcript, but he agreed. He said, I'm okay. And then ski patrollers come by. So, I mean, there would have to be a pretty vast conspiracy against Deer Valley for this to be a cover-up. And remember, they were already dismissed. Ski patrollers come by. They see some stuff going on. Everyone all right over there? Eric Christensen did not answer that question because this is a contact now between injured skier and ski patrol. Eric's a ski instructor. And so what happened, Eric? He said they talked. So this isn't, we're not in there like trying to bully someone. Craig spoke to Terry privately. He said, Eric said, I couldn't hear it. And then, which obviously Terry at some point said he remembers Terry saying, are you okay? Are you okay? So there's a connection. And then what did they say? We're okay. And the ski patrollers left. All right, so that's what's happening in real time. Now we go to the paperwork. Why don't we fill out a big deal, get everyone's statements and everything? Because if this happens all the time on ski resorts, if everyone's okay, I mean, we don't have a scene about it. But they go down a little longer. They now know that Miss Paltrow was part of the collision. And then Terry, and you can believe him, but they now know I'm not skiing too well. I don't feel that well. All right, fair enough. It did come 10 minutes after they found out who they had been involved with. All right, bring in Whitney. Whitney's an awesome, geez, I thought she was a fabulous witness. She pulls up and she's all business, like, okay, I'm gonna assess for unconsciousness. No, what happened? She says, what happened to Terry? He didn't say, I got hit. He says, I don't remember, I don't know. Did Craig immediately go in on that? I'll have to defer to her report. That was a legitimate question of mine. I'm trying to remember. James, when are you up?
5 minutes.
Are you up in 5? I can do that. That gives you 5 or 10?
Gives me 15.
Thanks. I'm gonna be done in 5 minutes, folks. Okay. So Whitney's delightful, loads them up, takes them down, says, hey, before, I want you to remember 5 things. And this isn't like man, woman, dog. This is like, I got my degree in Michigan. I was Deer Valley Grand Slalom person, whatever. All these really detailed. I like horses, my horse's name, all this stuff. Remember it. Terry says, I remember. I knew I was now having a cognition memory test performed upon me. He goes down and she then says, do you remember? And oh my gosh, he remembered. In fact, he remembered so well, he decided this is a good opportunity for me to text and post a picture of Whitney smiling and just talk about how wonderful she is. Whitney, meanwhile, is sitting there trying to figure out, okay, are any problems here? Are you seeing any signs of concussion? No, I'm not. Do you remember Dr. Edgley? I don't know if you thought that was cool, that a guy who heads up the U's acquired brain injury clinic has had an acquired brain injury. I thought it was kind of cool. Anyway, he goes, what do you look at? You look at a period of unconsciousness. We have Craig versus all these people saying he wasn't unconscious. They even imply like Christensen didn't even care about us. He's yelling at us, he's bullying us, and then he's abandoning us on the conscious, drooling on the mountain. Give me a break. Is that what you know Deer Valley to be? So then, okay, he checks out at the main clinic. Then he's down to the Instacare. What is that Instacare PA looking? He's looking for, no, I don't see any signs of symptoms of unconsciousness or concussion. Because they're looking at memories, they're looking at periods of unconsciousness, and they're looking at, what's the third? Do you recall? Memory.
Ataxia.
That means inability to speech. I don't think that is what they were looking for. In any case, they're looking for any signs and the symptoms of concussion. No. Now that doesn't mean he didn't have a concussion, but it does mean this isn't anything severe at all. I mean, okay, next day he goes to the VA. These are the people he knows. CT, guess what? They're like all the same abnormalities as you had in your brain before. The problem is, and by the way, he then goes for 3 neuro assessments, and they all say normal, normal to above normal, in some ways, really above normal. So no assessments, those are all his treating providers. Why would we have our experts go do neuro assessments when 3 separate treating providers that he knows and trusts and that no one's paying say above normal? Why would we do that? But the problem is he then goes to Gibby and Fong and he just self-reports. Everything was normal beforehand. Wrong. And now everything's terrible. Wrong. Doesn't tell him he's flying all over the world, that he's biking, that he's the poster boy for fitness at age 75. He's posting every darn thing. I mean, this isn't like me sending out a private investigator and trying to find pictures. All I have to do is put Terry Sanderson. Oh my gosh, the guy's Mr. Activity. Heaven help me if I can be as active as he is at 75. All right, I have 1 more minute. I'm going to go back to Lady Liberty. So we talked about the blindfold, Lady Justice, excuse me. We talked about the blindfold and we talked about the scale. The sword. The sword, we want you to use the sword. This sounds harsh because we're not beheading anyone. The sword is to defend a meritless claim. This is a meritless claim. You don't throw a $3 million bombshell in the courtroom, call her King Kong, and walk away. You shouldn't reward that. And Gwyneth, who could have just paid it out, paid the ransom. No, I'm not doing that. I'm not going to have someone hurt me and then ask me for a lot of money. I'm not going to do it. I'm going to sit here. I said, you're going to have to sit here for 2 weeks in Park City, and you can't even look at your phone. And she said, I'm going to do it. I'm not paying that. We asked you for the dollar, not because she had to go in and get an early massage, but it screwed up a very carefully planned, important time in her life. Thank heavens the family melded well together. But we want our dollar. Thank you for your time.
Judge, can we approach briefly?
Sure.
Mr. Egan, you may proceed.
All right, thank you, Your Honor. Are you guys hearing this? Okay. Okay, so it's my job to talk about Mr. Sanderson's claim that he's not living the life that he used to live, and it's Ms. Paltrow's fault. Hope I can be helpful to you as we walk through some of this. I wanted to start by just pointing to this document. This, you remember, Whitney Smith was the ski patroller that arrived and wrote this report that day. A little bit later, Mr. Owens could not recall an important fact. This is the witness section at the bottom is not filled out. Mr. Ramon did not come forward and say, this is what happened, let me tell you about it. Whitney Smith would have written that in there if he did. She also pointed to, we also pointed to the fact that she did not write an X at that concussion and head boxes where she could have noted possible injury. She's, to use one of Mr. Sykes' phrases, she has no dog in this fight. She would have put X's there if she was concerned about that. She didn't. You also heard her talk about mild disorientation in her report, and that shows up here. And I think you've seen that the point, gosh, I'm sorry, this thing can be finicky. You've seen it, I'll just move forward for the sake of time. There's those mild disorientation notes, right? And she explained that she didn't see that as indication of concussion. She just saw it as being kind of rattled from a ski collision. And that's relevant to damages because Mr. Sanderson is claiming that he had a concussion and all of the symptoms that have come from the collision relate back to that concussion. I think there's considerable doubt that he even had one. He may have, and you could certainly find that, but you might find that he didn't have a concussion. I think, though, that I want to kind of frame this with a certain theme. Maybe you've seen a pattern over the course of these last couple weeks, or the last 2 weeks. On the one hand, you have real events, and then on the other hand, you have embellishments. On the one hand, you have objective tests, and on the other hand, you have subjective reports. On the one hand, you have what happened in the past, and then on the other hand, you have perception of what happened in the past. The realities of life, sometimes difficult realities, and on the other hand, you have anxious exaggerations. I think Mr. Ramon took the reality of the collision and spun it into an attention-grabbing story for friends about dramatic injuries and celebrity. He was talking a lot about that. Ms. Smith overheard it as she was caring for Mr. Sanderson. And then there were those comments that we found in the middle of trial where he talked about it, and you heard him explain that he'd been talking about it with friends. He knew a lot about Ms. Paltrow. He was very interested in this. I think he took that reality of the collision and embellished that what happened, what he saw. And Mr. Sanderson's taken the reality of his aging body and he's turned it into a profound injustice perpetrated by Ms. Paltrow. It isn't that. The facts show that his health challenges started long before the collision and they've progressed in a predictable way. I think you heard Dr. Hesh yesterday say, if you look at his medical records, you look through the history, you take the collision out of that timeline, it reads coherently. The prior stuff would predict the next stuff. You don't need the collision to explain what happens afterwards. It's not to say that he didn't have injuries in the collision. Nobody disputes the broken ribs. And those were certainly painful. They did heal. And then the concussion, if he had one, was very brief, as you heard multiple experts say yesterday, and had very mild symptoms that may have even resolved within that day. So even if you find that Ms. Paltrow caused the accident, I think you only have sufficient evidence to find damages that relate to those broken ribs and the concussion that resolved very quickly. The slow degeneration of bodies is hard to accept, and mental health challenges are hard to face. It's obviously human to want a concrete explanation for these difficulties. But as the court has instructed you, Mr. Sanderson should not receive the money he asked for if you find that his perceptions do not match reality. The law requires that he convince you that more likely than not, he has suffered real harm, that Ms. Paltrow is and that Ms. Paltrow is the cause of that harm, and he has not done that. Through the course of the trial, you've seen that Mr. Sanderson does have genuine problems, and I don't want to minimize that. Experts from both sides have talked about his anxiety and depression and the trouble he's had with family and relationships before and after the accident. You've seen brain scans. Dr. Black came in here, and he was the only expert, I believe, that took you through all of them and explained how they, were back in 2009, look very similar to what you've seen going forward. They're connected to abnormalities related to aging and other conditions that might explain his problems. But Mr. Sanderson's argued that you should believe his experts because they evaluated him personally. The problem, I think, with that argument is that, as you've learned these past 2 weeks, these experts didn't carefully review his medical history, and they relied heavily on his unreliable reports about it. They also want you to believe what they've been calling the before and after witnesses, the family and the daughters, the friend, and then the girlfriend. And I think that you've learned these past 2 weeks that they didn't know Mr. Sanderson's health as well as they thought they did. And he was actually, they had, I think, acknowledged that he's good at hiding some of those issues, maybe totally understandably, and reluctant to share his troubles. So you have objective facts and then subjective reports. And the law requires you to find evidence, reality, not just the perception of problems. From our experts, you've heard a consistent, compelling account that Mr. Sanderson had these problems before that the concussion occurred, potentially, again, very briefly, if at all, and that those conditions that he's experienced afterward that he attributes to Ms. Paltrow are the predictable consequence of that prior history. You heard them all yesterday. I guess you had Dr. Edgley the night before, but you heard them all, and it's a coherent, consistent story. I think you got a sense that they've read the records carefully, the objective records of treaters who have, again, no dog in this fight, just reporting what is going on for many, many years before and after the collision. Your Honor, I have till 25?
Yes.
Okay, 5 more minutes. I got a lot. I'm not going to get to all of it, but again, I'll try to get to the helpful stuff. Mr. Owens went through the various evidence about loss of consciousness and the different witnesses that have, I hope, persuaded you that Mr. Sanderson did not get knocked out for multiple minutes. But Dr. Eastful gave you some interesting testimony yesterday. She said that the medical records after the accident are actually inconsistent with serious concussion injury. There was the cognitive assessments she pointed to that were normal. There was the balance assessment that was normal. You wouldn't expect it to be normal. And then there was the alcohol intake that actually increased, even though a concussion would reduce your tolerance for alcohol. Again, careful looking at the events in question, which I don't think you heard plaintiffs' experts do. Mr. Sanderson's perception is different, obviously. He not only thinks he was knocked out for minutes, but he said he had a profound cognitive trouble during this time with Ms. Smith, who said he was cognitively intact, could speak to him. He was writing articulate posts about her, could carry on conversation for hours. So you got careful evaluation on the one hand, and then you have extreme exaggeration on the other. And the law requires you to be careful in your evaluation. Mr. Sanderson sees the time immediately following the collision as a grim period that began a spiral, began spiraling his life out of control. I think he described the bright side before and then the dark side afterward. And I think it's important to recognize that, as we've probably told you too many times, a few weeks just prior to this collision, he was reporting some of the symptoms and the concerns he's saying connect to the collision, right? He's said he was getting old all of a sudden, he couldn't do things that he used to do, get preoccupied with paperwork and other little things. And that's difficult. And I don't mean to make light of that kind of reality that aging brings upon all of us. But it's important that at that time, there was no litigation. He's just reporting. And you heard from experts that point to that as a telltale sign of the kinds of things you would expect after the collision that he's attributing to Ms. Paltrow. Mr. Sanderson's told you that the collision forced him to be a recluse. And if we had time, I would pull up those pictures. We went through a lot of them, and I hope that wasn't overboard. You got a sense of just how much he has done since the collision, traveled more than some people have traveled in their whole lives. And I think it's that this $3 million, I don't know where the board is, $3 million claim, I think doesn't acknowledge that reality. Mr. Sanderson is better than he realizes that he is. And it's not that he doesn't have problems, it's just that he is better than he realizes he is. And it's hard for him to accept some of the decline that he's experienced. And he's, again, grabbed onto this collision as an explanation for it. You've heard from Dr. Hesh and Dr. Edgley about how litigation contributes to problems like he's had, and you heard even from his own expert, Dr. Goldstein, that he's obsessed with this case, and it's not good for him, that moving on would be helpful for him. And I think that we all want resolution to this case. Mr. Sanderson's asking to be compensated for a ski injury that the evidence shows that he himself caused. And the evidence also shows that his life is not the mess he perceives it to be. Ms. Paltrow wants him off the mountain too, but she should not be responsible for the cost of that. And so we leave you with that argument. Hope that you can, of course, hope you're persuaded, and thank you for listening.
Thank you, Mr. Egan. Mr. Sorensen?
Thank you. Thank you for being here.
Oh, Pete, I have this. Sorry.
Thank you for that. We appreciate the time and attention that you've spent with us the last couple weeks going on kind of this journey. There's been a lot of fanfare, a lot of hubbub about this. You've seen a lot of technology. Some has failed, as we've seen today, but some has worked. And through all of that, I want to remind you of jury instruction number 24. Okay, and it says, when the lawyers are giving their closing arguments, keep in mind that they are advocating their views of the case. What they say during closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Now, you've heard some pretty amazing narratives, a spin on the facts, and you could probably say it cuts both ways, both sides. But I want you to remember about this case that there are two stories here. One is Gwyneth Paltrow, and you've heard her defense attorneys lay out her case. You've heard her side of the story. But there's also another side, and that is Terry Sanderson. They've done a really good job of telling you about what Craig Ramon says about how he describes this whole thing happening, and what Gwyneth Paltrow says, or what Eric Christensen says. But the two stories that are important to remember are Terry Sanderson's and Gwyneth Paltrow's. Terry remembers skiing down the mountain, hearing a scream directly behind him, and then bam, as he put it, lights out. Okay? He's knocked unconscious. He's left on the mountain figuratively, as we've talked about, trying to figure out what's going on. When he comes to, it's chaos. He doesn't really understand what's going on. On the other hand, we have Gwyneth Paltrow, who says that she's skiing along and all of a sudden she gets hit from behind. It's up to you now to weigh that evidence, to see what you remember, what you recall, not the way that the attorneys characterize the evidence, but what you see in the record. And I will tell you that what you see in the record corroborates the story of Terry Sanderson. Terry Sanderson, I just walked you through his tale of what happened, okay? His versions of facts that happened. When he's hit from behind, he has to rely on the one person, remember that, the one person that says that they saw the actual collision and saw what happened. He has to rely on that. But it doesn't mean that it's not part of his story. It means that he's relying on an eyewitness that corroborates what he said. Also, we have the meetup group post that's been talked a lot about and the comments to that post. That's contemporaneous evidence the day of that corroborates the story that these two have shared with you. It says, and in Craig Ramon's own words, says, it scared the hell out of me. It scared him. Scared what he was scared. So that might be an account that you weigh as to why he didn't step in to try to give life-saving or life-supporting measures to his friend. He's scared. He doesn't know what's happening, and the person that he's relying on to take charge of the situation comes over and starts screaming at him. It's also important to remember that Brad Falchuk, who we didn't get a chance to hear from, and Kerry Oakes both contradict in major ways
So, Your Honor,
his
he
story, his
cannot
testimony.
reference the testimony of Brad Paltrow.
He admitted, Your Honor, and that was
Just a
stipulation.
minute.
He admitted, Your Honor, that he did not see it.
Your Honor, that testimony is not.
Just a minute. Yeah, that's true. That was a stipulated fact.
That's a stipulated fact. So
Thank you.
Brad Falchuk did not see it. Okay. Eric Christensen, in his own reporting, didn't see the collision. But yet, right afterwards, he injects himself into this chaotic event and, according to him, takes control. He has enough time. Think about this when you're weighing believability of testimony, okay? Eric Christensen has enough time and is all aware about the students that he's being paid to watch and to teach how to ski that are beginner students. Watch what someone's doing on the other side of the run at the same time with, as reported in the fact show, many people skiing on this run. It's a converging run that goes down to the bottom of the run where people can go and have lunch. He has the ability to pay attention to a young child who he's teaching, someone across the way, someone skiing supposedly out of control, and keep track of all this. He hears a scream and looks over and sees, as the animations that you've seen, sees him laying on the ground, or sees these two people laying on the ground. He then has enough time to be the first on the scene, supposedly, after telling Kerry Oakes, take care of the kids, watch them, because I got to go over and take care of this. And he does that all in just fractions of a second. Is that believable? I'll leave that to you to decide. I know the way I feel about it. So this witness, who the defense has said is grandfatherly, who's this perfect witness, is not really that perfect. Again, I'll leave that for you to decide. Now, a lot's been made of what Terry Sanderson was saying or doing after the incident, right? You've heard, and I don't want your eyes to glaze over. That's why I'm not using any of the props. I'm just talking to you. But you've heard a lot about this email, right? The email Terry Sanderson sent later that night, or the first email and then the response back, okay? And I want you to remember this. The GoPro incident, or the GoPro video, I guess, we'll talk about this GoPro email, is a response from his daughter, who sat here and testified 3 weeks before she'd been in her own ski accident. She was laying there with her leg up. She was under, as I think she said, she had pain pills at the time. She was aching an injury. And there might have been kids coming in and out of her room. She didn't remember exactly why she wrote what she wrote. Nonetheless, she admits that she wrote it. And she said here in front of you that it was clearly a misunderstanding to something her dad might have said when he was on the phone with her. That's the shred of evidence that they want you to cling on to try to say that Terry Sanderson did something like destroy a video of this event. That's our only piece of evidence that they put on in front of you to that fact. Now, again, there are many contradictions in this tall tale and the cartoons you've been forced to watch a few times. And I want you to remember, okay, there was testimony that Brad Falchuk was on the mountain, but he's not in their videos. He's not in their animations. Okay, you didn't see it, but there's testimony that he was right up there close. They left him out. They left out Carrie Oakes and her testimony. We had to read it in because she also contradicts the positions of the bodies after the incident. So they've done a really good job of trying to razzle dazzle and trying to get you to look at a lot of other things that are not important, because we told you in the very beginning when Lawrence Bueller stood up here, you'd hear a lot of so what. That's what they're saying about Terry Sanderson's injuries. So what? He was injured before. His injuries carry through. So what? So sorry he's left on the mountain. We'd like him off. So what? That's what you're hearing. Now, we have shown facts that are corroborated by his medical records that show that from the day after this incident happened, there was a very serious decline. The people that knew him best testify under oath in front of all of us as to the changes that they experienced with Terry. His closest family members have seen those relationships affected. Terry's seen it affected. Again, I want you to weigh this evidence in the way that only you can. And I think that you can do it. I've seen all of you be very attentive. I've seen all you pay attention, and we appreciate that because this is a very real situation for two people, the two stories that are at play in this. I also want you to remember there's been a lot of talk about what Jenny Sanderson said, what Jenny Sanderson reports, but she's the one that went on one of those international trips with him. So it can't be too strained of a relationship. You're not getting the full picture when you have excerpts taken out of context from a deposition that are read to you. You're not. He has 3 daughters. They all love him. And they all said that. Unfortunately, we didn't get the chance to hear some of the positives from Jenny. But their relationship is strong. She loves her dad. And he loves her. But she even said she's seen changes. Now, yesterday you heard Terry Sanderson say it's a hard thing to bring a lawsuit against the celebrity. Said they destroy your life. And they turned around and said, it's your fault. It's your fault that this happened.
Your Honor, I object and would like a little conference unless you want me to state my objection right here.
I think just overruled, and you can make a record later, but let's let him finish.
Thank you.
I don't want her lumped in with
Terry
other
Sanderson.
celebrities.
Thank you, Judge.
Thanks. They point the finger at Terry Sanderson saying it's your fault. You did this. You brought this on yourself. Terry Sanderson believes in justice, just like you've seen right here. It's been waved all over. And he wants the weighing of the scales the same way that Miss Paltrow does. But Terry Sanderson believes, and I think we've shown you, that on those scales, someone has facts that are weighing, and someone has a lot of fanfare that when you really pry it, it's a so what. It's nothing. So I charge you, and we thank you again for your time, hearing the evidence, listening to all of us, listening to the coughing, listening to the objections, listening to this, sitting through the sidebars. We thank you, but now it's on you. We invite you now to weigh the evidence, and we empower you and trust that you will weigh this evidence the way you've heard it properly and find on behalf of Terry Sanderson. Thank you.
Thank you, Mr. Sorensen. In a civil case, only 8 jurors are allowed to deliberate and reach a verdict. Because this trial was scheduled to last over this 2-week period, And because jurors may need to be excused because of an emergency or other extraordinary circumstances, 2 alternate jurors were selected in this case. Prior to going back and deliberating, the court is required to excuse the alternate jurors. Some jurors are relieved when they are excused prior to deliberations, but most are disappointed and even frustrated that they've invested their time and energy in the trial, but are not going to be able to deliberate. Those of you who are excused, those 2, thank you for your service on the jury. Remember that you're actually not being released as a juror until the verdict comes in, because there is an outside chance that one of the 8 during deliberations may be called away for an emergency. And so the 2 of you that are allowed to leave, you may be called back to finish the deliberations and to vote on the verdict form with the others. So please do not discuss the case with anyone. Please do not read anything about the case. Just keep the existing restrictions in place until further notice by the court, which will be after the verdict is rendered. Please leave your cell phone number with the bailiff so that they can notify you when the verdict has come in and even give you the results if you'd like. Again, we appreciate your time and attention on this case. So I've got in here all of your names, and I'm just going to look the other way and pick 2 out, or your juror numbers rather. And so the 2 that are excused are number 15 and number 24. Those of you who are not being excused right now, you've been given all of the evidence and instructions on the law regarding this case. Before you retire to deliberate, I need to give you a few final instructions. First, about questions. As you deliberate, you may be tempted to seek more information. If you do have questions, please write a note and give it to the bailiff, and I will review that note and the question that you have that pertain to the case, and I'll review it with the lawyers and decide on how to answer your question if it's appropriate. However, it's quite possible, and in fact, it's probable that we will not be able to answer your question. You should understand that no further evidence can be provided to you, and the instructions given to you contain the law which you need to reach a verdict based on the evidence presented to you. What to take into the jury room? Let me first say that you cannot take your cell phone and you can't have any outside contact during deliberations. So the bailiffs will give you some time before you begin deliberations to text or call anyone and let them know, hey, I'm about to go on be blacked out here while we're deliberating. And then they'll take all of your cell phones and they'll keep them in a safe place back by your deliberation room. You may take the following things in there with you: your notes that you took, the jury instructions and any notes you took on those jury instructions, all of the exhibits admitted into evidence. They are being assembled. The lawyers will agree that, yes, we do have this is the correct exhibits with the clerk, and then they'll be brought back to you in a little bit. You're also the same with the verdict form. I have the original verdict form. It says original on top. This is the one that will be filled out, and the bailiff will bring this back to you as well. When you get to the jury room, please do the following before beginning your deliberations. Read over the instruction on selecting a foreperson and select a foreperson, and then you may begin. At this time, I'd like the clerk to administer the oath to the bailiffs.
Do you swear that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them, nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered? So help you God. Thank you.
You may now take the jury back. Thank you.
If I was an alternate, I would be pissed. Oh, some of you might be relieved, but I'd be pissed. 2 weeks and then go home. Yes, but it's a deliberation, I thought.
May be seated.
Thank you, Judge.
Thank you, counsel. Mr. Owens, did you need to make a record on anything on that last objection?
Yes, thanks. There was just a reference. It's hard to sue a celebrity. I thought that was an unfair statement given it's this person. This is a person here, not a celebrity. And I thought it was unfair to sort of slime her with Hollywood.
And the court anticipated that and noted what I was thinking about was the fact that the plaintiff basically said the same thing on the stand, and I think he was just repeating that. So as far as, well, are there any exceptions that need to be taken on the record otherwise? Okay. I wonder if there's been a motion filed by some members of the press concerning how to handle the reading of the verdict. Mr. Raymond, are you in the courtroom? Mr. Hunt, is that right? Why don't you come up and present your motion?
What the fuck's this about?
If you could first identify yourself, your bar number, and then who it is you're representing.
Oh, this is the
Good afternoon, Your Honor. Jeff Hunt.
Yeah.
My bar number is 5855.
ski
I
resort.
represent Court TV,
Oh, no.
ABC News, CNN, Daily Mail, the Associated Press, and NBC News.
I'm ready to hear your motion.
We did file a motion, Your Honor, to modify the court's electronic media coverage order and decorum order, which previously through the trial has restricted EMC coverage of counsel tables. And as the court knows, this is a case that's attracted substantial national and international attention. I think it's actually been a marvelous opportunity for the public to observe how the court reaches decisions, how cases are litigated, and we all benefit from that transparency, that accountability. That is what the EMC rule that was adopted by the Supreme Court was intended to serve. And as Your Honor knows, under the EMC rule, Rule 4.401, electronic media coverage is presumed within the limitations of the rule. And subsection 6 of the rule, there's several limitations for not showing the jurors, not showing minors, not showing exhibits that haven't been admitted, etc. Counsel's table is not within subsection 6. So as the rule stands, the presumption is that there should be electronic media coverage of counsel's table. And we just simply wanted to clarify for the court that when the jury comes in and announces their verdict, that the videographer and the still photographer for the Associated Press be allowed to show the public, as everybody here in the courtroom would see, counsel's table. I mean, that is the most important part of the trial. This is what we've all been leading up to. Everybody here in the courtroom will be able to observe counsel and the parties when that verdict is announced. And we simply believe that consistent with the rule, unless there is an overwhelming, and the rule says a compelling interest, not to show the parties and the lawyers during the announcement, that it should be allowed, and the court should modify the order to allow still camera photography and the video coverage. We've participated with Court TV in over 30 years of trials, live coverage. We've never had once a situation where the public wasn't allowed to observe the parties and the counsel when the verdict was announced. And that's for good reason. You've had 7 years of litigation, as I understand it. You've had 2 weeks of trial. And the most important people, the people that have the most interest in the outcome of this litigation, is the parties and their counsel. And the public ought to be able to observe them when the verdict is announced. And again, under the rule, Your Honor, the burden is on the party seeking to impose an additional limitation under the EMC rule, to come forward with some explanation for why that would be particularly harmful or prejudicial. And there simply isn't any reason for that. If you look at the reasons, the factors that are in the rule, all those factors weigh in favor of allowing EMC coverage of the verdict announcement.
How do you envision this happening physically?
I'm not sure where Wes would like to be positioned, the still photographer. I imagine
There'd be a still camera right here,
okay.
but without an operator. That is be remote. Is that possible?
I'm not sure if that works for still, but the video would just be as the video would normally work.
Right.
For the still.
Yeah, there was a still camera up here before, Mr. Hunt, but I don't know how much control the photographer had over that camera. And it had a very big, long lens, and it was focused on one individual.
He says he could fire it remotely from that position, the camera.
But can they? I mean, if it's
the aperture.
Well, I'm just wondering if it would be focused on one individual, or be focused on both council tables at once. I mean, how do you foresee that?
Today I don't have
Okay.
We can't hear him.
So at this point, physically, what it would require is a photographer to be standing over here and taking pictures. Is that what I'm hearing?
Yes.
Okay. And I mean, the court TV camera is very unobtrusive. I don't see it. I don't hear it. It can pan and move and
yeah, I agree,
sorts of
Rosie.
things without anyone noticing it. I realize that right now, I mean, this will be the end of the case. So the concern of an interruption of the proceeding is different, but it's still there in terms of decorum. How can we maintain court decorum and still meet the request?
It is there, Your Honor, but we could station the photographer there in a place that's unobtrusive. The jury's here. The focus is going to be here. It's going to be very brief. It's not like we're asking.
And why can't the still photographer take stills off of the court TV feed?
I'm not. The quality's not going to be there.
Rosie, I agree with you.
I'll hear from both sides.
Yeah, there's just different modes of capturing the image. The still photographer is just set up, designed just for that. The images are richer.
And in your experience or your client's experience, how have other courts handled the still photography?
We've usually had the still photographer positioned in a place that's unobtrusive and for limited periods of time and not able to go in and out of the courtroom. It's just there.
Thank you. I'll hear from you again, but I just want to hear from the parties.
Sure.
Mr. Sykes?
Your Honor, on behalf of the plaintiff, we have no objection to this. We think it's reasonable. Right now, there's this tripod over here with the camera on it is covered with a kind of a black robe, like two judicial black robes here. And I think if Mr. Bomber was to stand there, and we'll take the screen down, I think that would be fine for us. We don't think that would be obtrusive or violate decorum. So we're in favor of it.
Mr. Owens?
Yeah.
Thanks, Your Honor. First Amendment's important to us. There's certainly been a public benefit, I think, to having this in the public sphere. We've noted 3 violations of the decorum order. The very first day my client walked into the court, after I assured her there would be no photographers in the lobby, there was one right in her face as she went through security. And suddenly one day another camera appeared, and then a third violation we felt. I don't know if you found a violation, but I have still photos of her being taken just yesterday. So we're all for the First Amendment. The idea that the public should see what we see, the public isn't seated in the well of the court. The public is seated behind Miss Paltrow. The jurors have an interest here. This is stressful for jurors to have a still photographer standing right where that screen is as those folks come in. I think even if their picture isn't taken, I think it's strange. I think it will be stressful. Mr. Sanderson actually has a privacy interest here too. I thought it was insightful of Your Honor to ask about how this would physically change. If nothing would physically change, and if they're looking at the defense counsel in its totality, defense counsel's table, we would have no objection.
Mr. Hunt? So the defense wouldn't have any objection if nothing changes physically in the courtroom from the way it sits right now?
That's fine, but I still think it would be unobtrusive and completely consistent with court decorum to have the still photographer there for the minute or two that it took to announce the verdict. It's not going to, they'll have already determined their verdict. It's not going to add any additional stress. They have known that there's been media coverage throughout the trial. We disagree that there's been any violation of the decorum order. Counsel has not approached me about that. We're not.
You, but I didn't even know you existed in this case until an hour ago.
I've only represented the media in Utah for 30 years.
Yeah. I know you, but I didn't know you were even involved in this case.
So we're not here about that. We're here about my motion. And it sounds like we squared away the court TV, the video. We'd ask Your Honor for the 2 minutes, unobtrusive. Mr. Sykes makes a good suggestion of moving the stand up. And we think that that can be accomplished and the public will be richer for it. We're going to have descriptions about the reaction anyway. The press is going to report that. So why not have the images and the video that actually show what the reaction is so the public can judge for itself what the reaction is. That's the most accurate way to report this to the public. Thank you.
Thank you. Well, given the fact that there is a presumption in the rule and given the First Amendment, the court will grant the request as long as, for the reasons stated, for as long as that that is used to sort of stand between the photographer, the still photographer, and the jury. So we can turn that sideways. The still photographer can stand quietly. And I assume your camera makes no noise? There's no flash? Okay. You can stand next to the existing camera then, and when the verdict is read. All right. Is there anything else before we adjourn at this time?
Can I throw out an issue that will need to be addressed at some point? Your Honor has had a protective order in place in terms of speaking with the press. After the verdict is delivered, is that protective order lifted as to speaking to the press or issuing press releases? I ask because we've received a lot of inquiries. I think the protective order and the decorum order, I think, talk about the evidence, for instance, depositions being held confidential in perpetuity. But the press issue, I think, is appropriately lifted once the verdict is delivered. So there you go.
I don't quite understand your request, your
Sure.
clarification. Are you asking to continue the protective order, or are you asking for confirmation that the protective order will be released?
As to the press,
As to the press,
we want it to be released. We don't want certain, for instance, depositions that were taken that were marked confidential, anything that was not, for instance, I have boxes and boxes of things that didn't come into trial.
right.
I don't want that. I want those held.
Everything that was marked confidential according to this court's confidentiality order remains confidential
Correct.
in perpetuity.
If it's been entered into evidence in this court, it's obviously not
Then it becomes
confidential.
public.
And then we do want we do want to be able to speak to the press after the verdict.
You may. Do you have any objection to that, Mr. Sykes? No. Okay. So once the verdict is read, the informal agreement between the sides that they won't talk to the press until after the case, that's then no longer there, and they can talk to the press. And the press can talk to witnesses. The press can talk to jurors if they so desire, and I'll explain that to the jury. And I'm going to ask the press to please acknowledge and respect the wishes of the witnesses and respect the witnesses or the wishes of the jurors. And if they don't want to speak to them, or if they want to wait or maybe later, please respect that. So I expect that'll happen.
Pete just mentioned. The decorum order prohibits any cameras in the courthouse. I think that should be lifted now. I mean, because it's cold out there and wet out there, and they shouldn't have to be out there, and we shouldn't have to go out there to talk to the press if we want to.
Well, I'll consider that, but it's the reason that there's a standing order that there not be press doing things other than inside the walls of the courthouse, other than through a decorum order, or special orders, is for other reasons. There's security reasons, things like that. So I'll talk with those that have some control over that and get back to you on that. Anything else before we adjourn? Not finally adjourn, but take a recess. Okay, so what I'm going to do is when I'm alerted that there is a verdict, I will let the head of security operations, Chris Palmer, know that that's happened. And he will then let all the press know that in approximately 20 minutes or longer, if we need that, at least we'll wait at least 20 minutes before we bring the jury in and read the verdict. So if the lawyers will please leave a cell phone number contact with Jody, then we'll call you as well if you're not on premise. All right. Thank you. We're in recess.
So, right. Oh, Gwyneth. See you later. Hopefully they have a result today. But I don't see why they don't have a verdict today, but what's the time now? It's 2 o'clock, isn't it? It's 2, 3, 4, 5, 6, 7, 8, 9. Depends what time they get. They're allowed to deliberate till in the ice cream trial. They were only allowed to deliberate to a certain point. I think it was like 5 o'clock or 5:30, and then they had to leave for the day. Oh, was that the other one? No, that might have been actually sorry, that was the Zachariah Anderson one. They are in Wisconsin. They had to leave at 5:30 every day or something. So yeah, it was the Zachariah Anderson one. So they might have rules like that here. So yeah. Oh, sorry, I should just put these up, shouldn't I? Yeah, 2 people. Well, I mean, having lunch are deliberating now, aren't they? So I'm of the opinion that they will have a result today, or they should have it. I'm not sure what they're going to discuss. But in the same way, I thought the Murdoch trial would take a good 2 to 4 days. But they came back after 3 hours, so you just can't judge these things. Depends on them. Did he have the judge mix them? Yeah, no, the Zach Ransom one did, but that's what I'm saying. I don't know if he's going to do that or not. Otherwise, I'm going to miss the results because I'm staying up till 2, 3, 4, 5 a.m. Do you know what I mean? So um, that's going to be impossible for me. Do you know what I mean? So yeah, it depends if there's a cut off hour. I'll probably stay till about 1 a.m. my time, which is 6 p.m. their time. But after that, I'm going to struggle to keep, which I'm going to be pissed about if I miss this result. So in one way, I hope he does cut it off at a certain time, if need be. So I don't know. It's, I don't know. I think it should be today, though. I don't think it's going to take that long. I think it's going to take longer to bloody fill those forms in than anything else. You did movies. Yeah, I think it's just down to the respect level, though, Giovanna, in the sense of I think you're right in the courtroom because she's there, and I don't see anything wrong with them taking a picture of the whole table, but to have it in her face, I don't know. I don't like that. I think the restriction applies because in the courthouse because she's just got cameras straight in her face all the time. So I don't know. I say we all take a nap. I mean, it's 9 o'clock here, so with you, it's 3 o'clock in the afternoon. You'll be all right. Nah, I think you'll be fine. What I'm going to do is I'm going to take probably going to take half an hour just to regroup, um, and then I'll come back on. I'm going to play some Peter Trago stuff. Basically, I'm just gonna watch some stuff, and if people want to watch it, fine. If they don't, fine. It's not an issue. It's just I'm gonna have this on at all times in case there is something that comes back. I don't think anything will come back in half an hour, and then I'll play some Trago's thoughts from yesterday's trial, and if I need to, I got some Brian Kohlberger stuff that he's covered as well, so I'll watch that. Basically, you just get insight into some of the stuff that I watch. I won't put the penny porn on or anything like that. It'll just be legit stuff, so don't have to worry about that. Yeah, so there we are. I'll say I'll leave it for half an hour just to stretch, get some coffee, do whatever you need to do, and then come back about 9:30. I'll probably record a video in between, and then yeah, come back about 9:30, and then watch Strigos. 9:30 my time, so 3:30 your time, 4:30 Eastern time, 2:30 Mountain time, 1:30 Pacific time. Oh, movement? No, it's fine. Oops. There's no lunch, mate. There's no lunch. There's nothing anymore. We are like this now until they come back with a result. So there's no lunch. Literally, it'll just be like this now until they got a question or a result. Yes. And with that, I'll put a banner on to say, um, put this in verdict watch. No, not that one. Oh, verdict watch. Oh, okay. Wrong one. Just gonna put in. So that's 2:30 here. Cool. Yeah, nothing, Joe. So don't worry. You can just chill out or do whatever now, man. Watch your baseball. Right. I'll see you all in a little bit. All right.
Hello,
Kapihara. Kapihara, if you're still there, hello. Hello. Oh, you've been here before, haven't you? Yes, unfortunately, because I don't like the fact I've got so many subscribers. It all came too quickly for my liking. Right, where's this one now? Okay. Right, anyone there? Not. It's fine if you're not there because I've got stuff I need to upload as well. Okay, that's fine there. Oh, I did say Peter Trigos tonight. I will put Peter Trigos on. I'm just literally uploading a video. Uh, that's fine. That's fine. It won't take that long anyway. Right, let's try and find the Trigos for you guys. I need to keep this one open so I can see it. I'll probably play him a quarter to now, just in case somebody else wants to come. Five not watching. No, do you know what? I'm gonna go offline for a second. Need to do this. Oh, okay, if anyone's still around. Hello, Rumble. Right, I am back. I am here. Sorry. Sorry. Okay, I need to put this on then because stop messing about right there. Bear with me. I'm just gonna get Peter Tragos. I just made let's have a quick coffee. Peter Tragos. Just search him now. Okay. If you don't know Peter Tragos, he's really good and he is worth following. Stop that. Stop there. That's fine. No, I don't want that there. I want that there. I need to bring this out. So many things going on. Right, that open. That one there. Rosie, hiya, Rose. 100% agree with you. Sorry, I'm trying. Oh my God, I've just lost something there. No, that's where it is there. I'm trying to post my I got a video that's been posted as we talk, and oh, it's live. Fine. Public done. My biggest problem is right. I don't look at my videos before I put them up. I just put them up, and I come across as a bit sexist sometimes. I don't think I'm off. Wrong one again. This one, yeah. So I just posted a video about this case, but I remember saying to myself, I was like, called Gwyneth Paltrow, say, oh, she's a 50, she's fucking gorgeous, blah blah blah. And I have to look at myself, oh, there's bound to be a handful of people now that will say I'm sexist, right? Because I call a woman a 50. Fucking hell. But I can't be asked editing it. Do you know what I mean? I've literally closed this down, ran to my seat, recorded it, uploaded it, did a thumbnail for it, grabbed a coffee, I'm back now. Do you know what I mean? So it's like, if I edit it, I haven't got time for editing. Do you know what I mean? Right, I will get this one up now. What I'm going to do is wait till 1:45 to actually play it, just in case some people want to come in. Have you seen this one then from last night? Hang on, there we go. Where's my share screen? There we are. And what I'll do is I will do that. Rosie, yes, you're right. But sometimes I say stuff, but I don't mean it. Do you know what I mean? I got 4 nieces, right? So I'm the least. Well, I'm not going to say I'm the least sexist person because if it's an attractive woman, I'll say, "Fucking hell, she's fucking a bit right, is she?" But I got 4 nieces, and I'm always pulling for women and making sure, advocate for women. I don't know. I I just feel like women do that to men, surely. I go, whoa, that's a hot piece of meat. I don't see anything wrong with it, but I've been called a misogynist. Someone called me a misogynist or something. I sort of know what it means, but I couldn't be bothered to Google it. I sort of know it's like sexist, isn't it? Something like that. I was like, okay, can't please everyone. Um, yeah, so you're right. Oh, hey, honestly, I was called misogynist, right, for something well less than that. What did I say? I said, oh, good, because I haven't got a clue what it fucking means. I know it was something to do with something like that, but I have no real idea. I said something. Oh, it was either Lily or Melissa that were posting, and I just went in there and said something about this woman was like giving shit. I was like, who the fuck are you to give them shit for? And she was like, oh, look at you telling women that they couldn't have opinion. I'm like, whoa, whoa, whoa! I didn't say that. I said have an opinion, but don't bash someone else for their opinion because you're a misogynist and everything and this and that. She said something about, oh, you're a misogynist, are you handcuffing me or something? I was like, wait, whatever you do in your own time, kinky bitch, whatever you do is up to you. Use those handcuffs. But then she went off again. So and then she blocked me. I was like, I don't think I said anything bad. I just said kinky sex, basically, with handcuffs, you know? But if you say to me, about handcuffing someone, I'm gonna bring it back, do you know what I mean? So whatever. I got loads of women friends that say I'm not sexist in the least. So that's fine. Oh, yeah, yeah. So, because they were attacking Melissa, I said, oh, yeah, have a vodka, pour a glass, have a vodka. That's what it was. Yes. And that's what she called him, misogynist. And not to handcuff women or betray women or not to have opinions or something. I'm like, yeah, you got a great memory. I don't fucking remember half these things. Oh, amazing that is, because I didn't remember that. I do remember how you said it. I was like, yeah, that's 100% what it is. But that's what I was called, misogynist. But yeah, you don't say stuff like fucking handcuffs and shit like that to me because I will be saying something inappropriate, 100%, but you've opened the door. She was awful. She blocked most people, I think. So fuck her. Anyway, have you watched this episode yet? Have you seen it? She opened the door. She opened the door. I could bring her in then. If she hadn't opened the door, I would never said it, as the Murdoch trial would say. That's fine. I will. I'll play it again then because it's if you don't remember it, that's fine. What I'll do though, I hate doing this, right? Because I'm I don't like watching myself. But what I'm going to do is actually watch my YouTube videos just in case because you're here. You're good there. Not that one. Well, here we are. This is what I want to be. Your channel. I think it's this. No, it's not that one. Where the fuck is it? Videos. Oh, have I not posted it? Erin, how are you doing? Oh, I put on private. That's why, idiot. Why is it on private? No. Oh, how the fuck is it out? Right. What I'm going to do is somehow unprivate something. How the fuck do I unprivate it? Manage videos. There we are. There we are. Public. Oh, look at me. Check me out. Oh, shit. Right. We're going to play this. This is what I recorded just now. Harry, that's you. Oh, all right. Harry. Oh, right. I am unmuted it. Tell me if you can hear it. Can you hear that? You can hear it. What the fuck? Right. Right. I'm glad because now I need to figure this out. I stop sharing. Presents. I'm glad there's no. I'm glad there's only a few of us here. I think this is a fix. I think I fixed it. Have I fixed it? This is going to be a bit of a recap of the Gwyneth Paltrow trial. They've now gone into deliberations. I've been watching throughout. I'm not missing a minute of it. I've had a bit of a trim on the old beard. My hair's a bit of a mess. I'm super tired. Got lights on me. So yeah, this has been an interesting trial. I just fell into it randomly. Complete and utter random. I was covering the Zachariah Anderson trial. And that pause there. Erin, you get a shout out. Erin gets a shout out. Sorry, Rosie, I did shout you out, but Erin gets one. I had got into deliberations and was talking to people in the chat, and Erin, one of the people that posted in the chat, one of the members, mentioned the Gwyneth Paltrow trial. So I blame her for all this. I don't really, Erin, love you to bits. So we went in there, had a watch. Once you start a trial, you've got to see it through. It's been a long 2 weeks. There's days where I regretted starting it, if I'm being honest. And like, I know we haven't got the verdict yet, but just today feels like a win. I throughout, I went into it thinking, my mentality was, why has this Paltrow, Gwyneth Paltrow, not settled this this case? Just settle it. This is so stupid. It's unbelievable. Just give him his 300 grand, whatever it is. You know, you drag this over 6 years or whatever. It's absolutely pointless. But then, and that's my view on the first whole week. I was like, geez, this is absolutely pointless. But then it sort of changed then. Once the defense got on there and once their experts got hold of it, and I saw how the lawyers for the plaintiff were, all they did was attack their credibility as experts. Didn't really bring anything. They was just shouting at them, how much have you cost? And I was like, these guys have got no substance. They've got nothing. That's when I started thinking, I'm team Gwyneth Paltrow. Or Paltrow. Whichever way you say it. I just call her Fitty. Gwyneth a Fitty. She's a very beautiful woman. Very beautiful. I know she had a resting bitch face, but I would as well if I was in court, sit next to Lawyer Owens for 2 weeks. No, I thought she held herself well throughout most of the 2 weeks, but I am biased because I think she's, I'm dazzled by her. Not really, but I think she's fit. But anyway, that's not what we're here to discuss now. But yeah, I just saw a different light. I was like, now I get it. Now I understand why she didn't settle. It's the principle of it. Once I saw the daughters of Terry on there, with their, in my opinion, fake tears, the way they just, bit back at anything they didn't like to hear, I instantly thought, like many people actually, this is a pure cash grab. And the more that it went on, the more I believe that. So, in actual fact, by the time the witnesses came on for Gwyneth and seeing the plaintiff lawyers just attack as they did and not bring any kind of substance to any questioning of relevance, and to see that one doctor, I forget his name now, laughing at the lawyer for the plaintiff, every question he's like, sure, you make up whatever you want to make up, mate. He didn't give a crap, I loved it. And to have the doctor who had a stroke when he was 28 years old, that was impactful. I mean, I'd never heard of him before. You know what, you search it because that's an inspiration for you. Get a stroke at 28, and to get the levels that he's got to, you can't do anything but, applaud him. I mean, fair play to him. Many people would give up, but he didn't. He battled, and fair fucks to him. So I thought he spoke well. He's very insightful. He was a good witness for him to have. So that's where we're at. And then obviously last couple of days, the witnesses I thought have been great. Explained stuff. I'll be honest with you, some of the stuff I didn't get. I didn't understand it. Sounded good. But that's why I think that they were a little bit pointless, really. In the same way that a lot of their witnesses for the plaintiff were pointless, and the daughters and stuff. They just made it worse, if I'm being honest. What intrigued me about the trial, or what got my juices flowing, this might be weird, but it was finding out about that this is all timed. And it wasn't like any of the other trials I'd seen. Obviously, they're all criminal, but this is all timed. So you got a set amount of time here. So you couldn't do a Creating Waters where drag a trial on for a month and talk nonsense over financial stuff for like 2-3 weeks. You can't do that. I love it. I love a time trial. I think this is fantastic. I think it's the way of the future. I think it's something that everyone should do, even for criminal trials. I'm not saying you should have like 2 weeks and you're done, but I think you should look at a trial realistically and go, and judge. This judge, for me, is the best judge I've seen so far. I've only obviously seen like 4 or 5 trials, so it doesn't say much, but the Murdoch trial, Zachariah Anderson, Ice Cream Man trial, and this one basically, so composed. He's got two lawyers who are arseholes, and I think they're quite friendly outside of work, but they're arseholes in work, but very experienced. He's handled them so well, and I think they all respect him as well as a judge. So, yeah, he's held court well, and if you get a judge like that for a criminal case, I think he can judge very well. Right? Do we need to add a few more days here and there? I think he's very fair. So I love the thought of a timed trial. Now I know that's never going to happen for a criminal trial because you've got to have enough time. But the concept of it is somehow of not being able to drag a trial on for a necessary amount of time, or bringing bullshit in and stuff like. Yeah, I like that thought, but because I think it's strategic as well. Then I think there's a bit of a cat and mouse game to it. But overall, the trial was weird, but it was in the end. I'm glad I did it, but I'm not like. I know there's could be other civil cases out there that I probably will cover, but I'm glad it's over. I am glad it's over. For me, as I explained throughout this video, I think it's a cash grab. I don't think there's anything much to deliberate. I don't see anything. I just think I said to my stream, I said, if I was the plaintiff, I'd just get up now and give her $1 and say, I tried, I also think that he should pay for her lawyers, because I as I say, in my belief, if she's found to have done nothing wrong, which I believe she hasn't done anything wrong, believe he should pay for it. He's got enough money. You know, he's a doctor or sort of doctor, eye doctor. I think he should be made to pay it. I mean, he's dragged this on for 6 years. That's my opinion. Obviously, if they find him and say, no, actually, we side with the plaintiff, which I would be absolutely, what the fuck? But, you know, hey, with juries, you never know, you know. So that's my stance on it. I'm Team Gwyn, proud of it. 50 years old she is, 50, still going well. And, you know, I'm obviously saying she's fit. She's a beautiful woman. She kept herself well. She's held herself at high dignity, I felt, throughout this case. And yeah, with that, that's it. I'm just going to be back on stream and wait for results. And with that, let's go. Oh shit, wrong one. See, you didn't say you're one of the first people to watch that now. If you stay to watch it, cancel that. Don't need that anymore. Don't need that anymore. That one. That one. You can see Rosie right at the end. That's where I thought, oh, maybe I've said too much here. Maybe I've said too much here about her being 50. Thank you, Rosie. I mean, that's me being calm. I feel I speak tidy when I'm calm. When I'm excited, no one understands me because I'm high pitched. Get out. So I need to stay calm. I didn't realize I swore so much. So I need to maybe tone down. I don't realize I swear half the time. That's a problem. I'm glad I did it. It's out now. So you get inside what I do in my spare time, just straight away, do videos. Right, we got this one now. Let me get this attached again. Present, share screen. 1, 2, 3, 4, 5. Real lawyer, you know. Okay. So this, for everybody, was yesterday's trial, and Peter is giving his opinions on it. So with that, let's go. And let's wait.
What's up, everybody? We're back at it here Wednesday, second to last day of trial. Judge is keeping this thing on schedule, so we are going to have a short rebuttal tomorrow. We do have some specifics on timing left for each side, and it is just hilarious to me which side actually ran out of time and who was complaining about the delays and people taking so much longer. We'll get to that later. But today was full of a discussion of damages. How much money will be awarded if Terry Sanderson wins this case on liability? So for some of the questions and some of the discussion, we're going to assume that Terry Sanderson wins so that we can really try to think about damages and how we would calculate damages in this case if Terry Sanderson did win liability. Let's say the jury takes a vote, 3/4 say Terry Sanderson wins. Even if you're outside of that 1/4 vote, then you start to discuss damages. We've talked a lot about who did it, how it's difficult to prove, how Terry Sanderson has the burden of proof, and maybe he didn't reach that, which is fine. It's fine. But we're going to kind of put that liability discussion aside today as we talk damages. And we're going to go through all the witnesses and, of course, answer all of your questions. So please take a second, hit that like button, subscribe if you haven't already, and let's get to the first witness of the day, who I've been waiting for since opening statements. Because when we heard the discussion of prior MRIs, that always piques my interest, number one. Then after the plaintiff's neuroradiologist testified, and he had never seen the prior scans, that made me get a little side-eyed, like, what are you guys doing, plaintiff's attorneys? By the way, I was messing around with a custom layout. Do you guys like that any better? I can't really tell. Maybe we'll try this for a second, just for fun. So we are going to get to this testimony and how he would potentially be a more reliable witness because, no, it burns the eyes, somebody said. Okay, then I'll go back. Sorry. All right. So anyways, so he would potentially be a more reliable witness because he did, in fact, see the prior testimony. So let's listen to what he had to say. And I tweeted that I fully expect for him to absolutely shred the permanent brain damage caused by this incident as proven by these MRIs. So here we go. Let's listen to this together here.
Does that work? This study does show imaging that was, or findings that were demonstrated over a decade of imaging, in this case, dating back to 2009. One of them was a mild degree of cortical volume loss or loss of brain volume. The other was in this area here, these are the ventricles, and it showed as disproportionate enlargement of the ventricles relative to the amount of tissue loss in the gray matter and overall brain volume. The findings around the ventricles, these white areas, are very typical of what's called microvascular disease, where brain matter around the ventricles is deprived of oxygen over a long period of time, and that results in gliosis or scarring. This pattern is very typical of what we call microvascular ischemic white matter disease, and that was present in 2009.
And did I hear you correctly earlier? Do you have specialized training in those particular findings beyond what a typical radiologist might have?
My fellowship training and experience in neurology and consistently reading brain MRI gives me expertise in looking at these findings, which we often see on a regular basis.
I see. So this is a post-ski collision image, correct?
This particular sequence is from 2019. My understanding is the accident occurred in 2016.
Yeah, and I think you said 19, but you pointed to 2017.
I'm sorry, 2017. Yes,
right.
Correct.
Yes, and so you said earlier, I believe, that the same findings you're pointing to, again, not just Dr. Gibby's findings with the green arrows, but the other ones you just talked about, they're in the pre-accident images. Is that right?
Yes, my review of the imaging that was done at the Veterans Administration Hospital in 2009 shows these similar findings. And in the reports that were provided by the neuroradiologists who read the imaging at that time, they described these findings.
Right. Okay. So
and we knew as soon as we had those green arrows pointing to certain areas of the brain and Owen's locked in. This is, or it might have been James locked in. This is where you think you can see objective findings on the MRI of the brain injury Terry Sanderson suffered as a result of this accident. And the plaintiff's expert said yes, because he put those green arrows there. Okay. And you can just tell sometimes when lawyers ask certain questions, they know they're going to get you. And I said, if you're going to come with that, you better have the goods. And this guy today was the goods.
let's maybe have you sit down again, and I'll pull up those slides that you made. Thank you. Thanks. So this is Defendant's Exhibit 101A. All right, move to admit this as a demonstration.
Slide is also a what's called a flare sequence, a PG flare sequence.
So just I want to point out real quick, there's a very faint pink arrow pointing to the same spot the green arrow was pointing to. And this is on the prior MRI, showing basically the same findings. You can have experts get up and say whatever you want. You can have, when I say biased, again, everybody takes bias a little bit different way. But when you have family members of a party on both sides in this case, so I think I'm being fair and even-handed, they come into their testimony with bias. They want to help their family member for the most part, okay? So that's what I mean when I say biased. When you have biased witnesses coming in and testifying for their family members, when you have biased experts coming in and testifying for a certain side that paid them some money, sometimes you can toss that out. Sometimes juries take it or leave it. Sometimes they like one expert and not the other. But what do juries always trust? Their own eyes and their own ears. And when you can put two MRI scans, one before the crash and one after it, and they look exactly the same, that is incredibly difficult to get around as a plaintiff. Because the jury is going to say, I can look at this. I can see his brain looks the same. And then it's easier to tack on, well, he dealt with depression. He dealt with anger. He dealt with all these issues before. So this was the most damning evidence for the brain injury, in this case, the long-term brain injury, not the mild concussion lasting 3 months. I think the defense basically locked that in, that it's more likely than not that that was a result of this crash. Not that it was not Terry Sanderson's fault. It's a double negative. But again, regardless of whose fault, that mild traumatic brain injury concussion did occur as a result of this crash and was acute. Most of them have agreed to that.
Sequence done in what's called an axial plane, which just means the orientation, the way the image was acquired to the brain. This image was acquired in March of 2009 at the Veterans Administration Hospital.
So that's before the accident, correct?
Yes.
Yeah, and again, when I say accident, I mean the ski collision in 2016.
Yes.
And it's not terribly easy to see, but I can call it out here. There's a little arrow. Do you recognize that?
I put that arrow there.
So, sorry, I'm just going to pause for a second. I didn't talk about the directed verdict argument. I will get to that after this first witness. So I jumped the gun here to talk about this witness, but I will go back and talk about the DV argument that Owens made and what the judge's decision was.
Yes.
Okay, and what does it point to?
That arrow points to white matter disease, similar to what Dr. Gibby pointed out in the imaging from 2017.
Right. Okay, so in other words, this is a prior finding that's the same as the post-accident finding Dr. Gibby saw.
Yes, about 8 years earlier.
Okay, got it. And what is this finding associated with?
Again, most commonly.
Same finding 8 years earlier, AKA no objective changes. Now, the plaintiff tries to start arguing, that's fine, but the subjective things have changed and the subjective things are important. And I agree with them. Subjective things are important, but they made the argument that the objective findings in the MRI did matter. And I think they were just kind of wrong. And I think their neuroradiologist, their guy that reads MRIs, didn't do a good job of differentiating, because I don't want to blame the plaintiff's lawyers, but usually the plaintiff's lawyers would provide those prior scans to that expert so that he could testify and differentiate and do his job.
We see this with what we term microvascular ischemic white matter disease. There are predisposing risk factors for this, where in some patients it may be accelerated, but it's typically a process that's due to pathology or abnormalities in the very small, some of the smallest blood vessels that supply the brain, particularly around the ventricles.
Then I'll go to the next one, which is 101B, and again, call out a section here at the bottom. There's kind of a faint red arrow. Again, did you put that there? And why did you put that there?
Because it, again, shows the same pattern of white matter disease that was demonstrated on MRI of 2017.
Okay, so again, a finding before the accident that was there also after the accident.
That's correct.
And you get the gist. So they do this basically with Dr. Gibby's entire testimony. And this doctor, Dr. Black, says that Dr. Gibby was basically looking for any objective evidence of brain damage or a brain injury. And why would he do that? Because we've learned throughout this trial, and as we try to teach juries throughout every one of our trials, that clinical correlation is how all this works and what's so important. And how do you do a clinical correlation? You have objective findings on an MRI or an X-ray, something like that, with subjective complaints. They're a very important part of the equation. The plaintiff or the patient telling you what hurts, when it started hurting, what was it like before the crash, what was it like after. Those are subjective complaints. You put those together as a clinician and you determine how the injury occurred and what the injury is. So in order to get that, the plaintiffs were trying to find some objective evidence in this brain MRI, and I think this expert completely shredded it. Completely. And again, Gibby was limited because he didn't have that prior imaging. He also says in his report that there's no acute brain injury. The MRI was taken years later, so even anything you saw here would not necessarily be acute. Then on cross, they make a pretty good argument. The MRI pre-accident was asymptomatic, meaning he didn't come in with some kind of brain injury, and that's why he got the MRI. They did it as part of the workup for the stroke in his eye, which is not indicative of actually a brain injury, even though that's how it's kind of been used by the defense throughout this case. He says there's no, the plaintiff's lawyer asks, so there was no change post-accident? And he's like, correct, there was not. I don't know why he asked that question. And then he locks in that his opinions are only limited to this MRI image. He says yes. And of course, as James often does on redirect, since cross, anything change in your opinions? Expert says no. All right. Before we move on to the next witness, let's talk directed verdict. And then I'm going to also answer the overarching question some people are angry about. that we're going to talk damages tonight. So, first, directed verdict. He starts out, which I like this argument by Owens, by mentioning some of the prior motions he's already won on causes of actions that have been dismissed. And he first tries to throw out the whole case because nobody actually proved or said that Gwyneth Paltrow did anything that was negligent. Pretty good argument, because there wasn't anybody that specifically said it like a lot of the ski instructors said about Terry Sanderson. But Terry Sanderson's own testimony and Mr. Ramon's testimony would at least make it a jury question as to whether or not she used reasonable care while she was skiing. So the judge said denied to that one. But the post-accident delay damages or negligence, I again thought Owens had a pretty good argument that there's no real testimony that she did anything wrong post-accident. And even if she did, what damages did those cause? And based on the judge's questions, I really thought the judge was leaning toward granting this, especially because he asked a certain question to the plaintiffs. How would this even change your case or your arguments or your damages if I did throw out the post-accident negligence? So I was starting to think the judge leaned that way, but then the plaintiffs responded with a good argument. And this is kind of the fun thing about lawyering and reacting and knowing what happens in a case. And the plaintiff's lawyers argued, well, there was emotional distress. He felt like he was abandoned. When he came to, nobody was there. It was hard for him to file the claim and to figure out who did it. And the judge even said, well, she did give Deer Valley her information, so you can't argue that. But that motion is also denied. So he lost both of his directed verdict motions, which is absolutely normal and happens in just about every case. So that was the beginning of the day. So some people are asking, why would we talk about damages? Terry Sanderson is obviously going to lose this case. There's no way he can win. Well, here's what I'll say. If that was the case, then why did the defense talk about damages? Why did they call so many witnesses and pay so many experts to review medical records and discuss damages? Well, they did it because there is a chance they lose. It is a non-zero chance that they find Gwyneth Paltrow is at fault. And while I think she has a better chance of winning this case, if she loses, they had to discuss damages. And they had to try to mitigate and limit those damages. So regardless as to who we think is going to win right now, damages is part of the discussion and was most of the evidence and testimony today. Exactly. Folly Beach Vibes says never say never, especially as a trial lawyer. So because we don't know what they're going to do, I think it's going to be an interesting conversation, and we have a poll. But wait, don't answer the poll yet. I don't know if John's posted it, but we're going to probably wait till about 9:15, 9:20 to post that poll after we've had a second to discuss more of the damages. But regardless of what we think is going to happen, it is important for us to consider if he wins, would he even get anything? Would he get damages? And if he is going to get damages, how much would this chat and this discussion and the people here, how much would they give him? Okay? And we're going to discuss that. Because as we talk through these witnesses, what they say doesn't have a ton to do with whether or not Terry Sanderson caused this crash, but instead, if he wins, the defense still thinks he shouldn't get any money. Dr. Robert Hirsch, I think. I don't know. He mispronounced his name a couple times. Chief medical officer. Used to be a neurologist, and that's why he's here testifying, but now he's a big shot. And after he starts giving his resume, Owen says, nerd. And I was like, all right, that was kind of endearing. I kind of chuckled to myself, actually, the first time he said it. But then when he said it, and actually some people in the courtroom laughed, but then when he said it again, I was like, all right, man, enough. You did something likable. Don't overdo it. And then he continued to say stuff like, then you read 3,000 pages of junk, didn't you? It's like, dude, come on. Keep it together. Keep it together. I actually thought he had a pretty good day overall. But yeah, that was not great. It was kind of awkward, especially when he apologized later for calling him a nerd. And the, in my opinion, much cooler doctor was like, it's all right. We call ourselves nerds. But that was just cringy, which seems to be his specialty. Then we get to his opinions, which, as you guys know, I like to boil down witnesses and especially experts' opinions. What are his opinions? This neurologist, which is the appropriate doctor to talk about brain injuries, says that everything Terry Sanderson is going through now post-accident is and are symptoms of pre-existing conditions, and he does not need any future care as a result of this collision. He may need future care, but it's not because of this crash. Again, going to damages. He said that he did likely have a mild concussion as a result of the accident. And again, as I've said before, if this was my case, and some people ask me on Twitter again if I would take this case, as I sit here right now, I'm not sure I believe in Terry Sanderson's position and how this affected. Like, if he came in here and he told me he got in this accident, he told me he got hurt, okay, I get you. And it was Gwyneth Paltrow's fault. Okay. Like, I believe I could get behind, right? If he came in my office, I could get behind his version of her hitting him, right? But when he started to discuss the damages and some of the stuff that came out today, it would have been a lot harder for me to continue, I'll say. And this witness was another example of that. Likely had a concussion, and he didn't say it, but I believe all the testimony agrees he broke his ribs as a result of this accident. So, because of that, that's what I would have focused on. Not this brain injury changed his life and made everything worse. He could no longer do all the things that he loved because of this brain injury. Misty, in my line of work, so in criminal defense, some people would say, no, you don't have to believe your client, especially if the state screwed something up, but you have to hold the state to their burden. In civil cases, especially on contingency basis, I would never take a case where I don't believe my client. I have to believe my client, or I can't go to bat for them. It's just not in me. Okay. So, the defense tries to get him to talk about dementia, but there's an objection. More on that later. And then I thought this was really interesting. They discuss with every witness that they're going to get up here and criticize you for not meeting with this patient. And I want to listen to what this doctor specifically says about that, because I thought it was kind of an interesting discussion. And it goes to witness preparation. And I wonder if Owens prepared him for this question, because it seems like he didn't.
And after?
Yes.
Does he in fact have that condition?
Be consistent with that condition.
You mentioned earlier that his conditions are not permanent, as plaintiff's experts claim. And I just want to comment, do you believe Dr. Fong to have used unreliable science to make some of her opinions?
So if I sustain objection, just hold on. Thanks.
They're about to get up and criticize you for not seeing this patient. Why didn't you? Why wouldn't you? Why would it be necessary if you needed to?
Yeah, well, I would always be willing, and actually didn't know that was an option. But in this case, and with
that right there, to me, I mean, I would have done it. I would have gone off that if I was a plaintiff's lawyer. They did talk about it, but it was a little more argumentative. I would have been like, you would have, if you would have known it was an option, you would have met with him, right? Because that would be helpful to meet with him. Right? I would have been nice about it, not as angry about it. But it was interesting. He said, I didn't know that was an option.
many patients in my practice, we review tons of records before we see them. Actually, Mr. Sanderson probably had 10 times the amount of records that I have before I see my patients in clinic. You said 3,000 pages and lots of imaging. So I can know with 90% certainty going in based on the before and after imaging, the neuropsych testing over a period of years, his reports over time. I can know with 90% accuracy what's going on. So if I went in there, I'd be trying to figure out, does he have NPH or not? And what can I do to help him with his depression, anxiety, and other memory problems?
Would you be treating him or evaluating the ski injury?
No, I'd be providing counseling, but the ski injury was not part of it.
And that right there was a huge haymaker for the defense. I would be counseling that the ski injury was not the cause of this. I would be counseling him for his mental well-being that this ski accident was not the cause of all of his problems.
Now, you refer people all the time to neuropsychologists. Is that true?
Yes.
And we're about to hear from two. But you did have the benefit of multiple neuropsychologist exams at the VA. Is that true?
Correct.
And do you know them to be good neuropsychologists?
I don't know them.
Okay. Do you know them to be not hired by either side, his normal treating provider?
I'm glad he said he didn't know, because there's a lot of things you can say about a lot of different doctors in a lot of different places. So to comment on doctors you're not sure of, and for him to act like just because they work at the VA, they must be amazing, is not genuine in my opinion. So I liked how this doctor stuck to his guns and just said what he believed.
Providers?
Yes, that's my understanding.
And these were voluminous evaluations, were they not?
Yes.
And
Yeah, because we know that the VA never cuts any corners, and the VA never has any complaints about doctors not taking enough time with vets that treat there. I mean, I'm not saying they're all bad. I'm not saying they're all good, but there have been plenty of complaints from plenty of clients and people I know about how the VA doctors treat some of these veterans. Yeah. Okay. Thank you. I'm glad you said it, Mimi, because I don't want to besmirch the VA, and there are some really good doctors there. Here we go. Perfect. Disney gal. That's all I'm saying, is you can't just say because they work at the VA, they must be amazing. That's all I'm saying. And there you go. My dad loves treating vets and they love him. Exactly. I'm glad we got both sides of this comment here.
And what did they conclude?
They were essentially normal. And they showed that he was performing above average.
And there you have it. That's basically what they concluded from their meetings with Mr. Sanderson. I also liked how this doctor was like, listen, I get it. Having this nationally televised lawsuit makes it more difficult. It makes all this more difficult. And I would counsel against it. And basically, he's like, wouldn't the best thing for him for this lawsuit to be over? I think that's a good line of questioning. And he said, I felt anxious just coming in here, especially with all the national recognition and stuff like that. Oh, Lito, we'll get there. I still disagree with you, but we'll get there. Then he says, Jenny said this lawsuit makes him feel powerful, didn't she? Objection sustained. And here is an issue I don't think a lot of you are going to like, but I'm still going to say it. How many times have we heard Steve Owens read Jenny's depo and use Jenny's depo as a piece of evidence and talk about Jenny's depo and talk about what Jenny thought and felt and how Jenny may come testify and how we're going to read her deposition into evidence? But the defense closed their case in chief today. And you know what we didn't see? Jenny on the stand. You know what we didn't hear? Him reading her deposition into evidence. That's just gamesmanship. And I think it could be a very serious appellate issue. That was basically used as if that was in evidence, and it never came into evidence. I think it's interesting, and we'll see what happens as it continues. They didn't have time, people are saying. They had time for a lot of things. If it was as important, I didn't hear them read Moses's depo to impeach people 50 times. I didn't hear them read Apple's depo to impeach people 50 times. I didn't hear them read 90% of the stuff they presented as much as they talked about Jenny's depo. Just trust me. Trust me. It was interesting. And we'll see what happens. Everybody's saying they ran out of time. No. They used their time. They chose how to use their time. All right. On cross, do you commonly render opinions without an examination? Basically, he says no. But again, he went at it kind of hard as opposed to going a more methodical and friendly way, especially when he gives you a nugget like, oh, I didn't know I was allowed to do that. Insinuating that would have been great if I could have done that. He may not have even read some of the before and after witnesses' depos. Doesn't seem like he even considered the changes in Terry before and after. All of which I think are good points. I think I've caught Bob Sykes's cough because I'm not sleeping. So I'm getting sick again. And then they get into the executive function test that Goldstein wrote the book on, basically. And I thought it was effective how Sykes went through that and talked about how his scores were low. And I thought the answers from the defense doctor were honest. And I think that was actually a positive for Terry Sanderson. Now, how important is it? I'm not so sure, especially when it gets nuked near the end of the case. But I thought this was actually an effective part of cross. No records say he did this for money. Yeah, correct. People said the change was significant and sudden. Thought that was good. And then no one has ever diagnosed him with dementia, correct? And he said yes. And my notes were, it's so annoying that they keep mentioning dementia if nobody has actually ever diagnosed him with that. But then Owens does his job in a very good redirect when he says, and I'm going to play part of it. I think they had to kind of look for it for a minute, but I'm going to play part of it where, guess what? Dementia is in the records.
And James, are you hooked up? Thanks. 33. And we're going to maybe just bring up just number 2, if you would. I don't know if are you able just to clear number 2? Do you remember, this is part of Dr. Fong's document?
Yes.
And do you recall plaintiff's counsel say, show me in those records where it says the word dementia?
Yes.
All right, so let's look at this. The most likely diagnosis for this appearance.
It's not really what he said. He said he wasn't diagnosed with dementia, but still, I thought this was effective.
Is normal pressure hydrocephalus. The differential would include normal aging brain, Alzheimer's, dementia, subcortical arterial sclerotic encephalopathy, and multi-infarct dementia. All right, this is plaintiff's own retained expert, right?
Yep.
And she's talking about, hey, could be some dementia stuff going on here, right?
Correct. Objection. That's a differential diagnosis. It doesn't suggest
That's a speaking objection, Your Honor. It's inappropriate.
It is a speaking objection. It is inappropriate, but that is exactly what you'd call a misleading statement and a misleading argument. But I thought it was effective by Owens, and it does say it in the records. There was actually another mention of it. There was 2 mentions of it, and they brought that out as well. And then they continued redirect, and he talked about how many times clients will exaggerate claims when they have a case like this. They'll malinger for secondary gain. And then again, he says, I'm being told to sit down. There are 2 things that I will not miss when this trial is over. Number 1 is I'm being told to sit down as like a way to endear yourself to the jury. Like, oh, am I being annoying? Sorry, even my team is telling me I'm being annoying. And number 2, also trying to endear themselves to the jury. I'm just a country lawyer. You're going to have to slow it down or dumb it down for me. I'm just a country lawyer. And it's actually hilarious because I think I'm going to have time to play a clip at the end where even the judge and lawyers on his team are like, well, you're just a country lawyer, right, Mr. Sykes? It's like, I'm over that. I'm over that. The jury has to be rolling their eyes at those comments at this point. But I digress. On recross, let's hear how Bob, again, I like this kind of lawyering. I like the back and forth. I like the use of the records because Bob comes back and says, okay, while it may mention dementia in the records, what does that actually mean? And how is it mentioned?
Major signs of dementia.
Okay. He reportedly sought out neuropsychological testing for these symptoms, but also feared that he may be experiencing early dementia symptoms. Okay.
It's smart for him to think that.
It's smart. Mr. Sanderson noted that he felt reassured following the testing, but is still concerned regarding some of the cognitive changes he has experienced, right?
Correct.
You understand that he was tested and told he doesn't have dementia. You understand that?
Yes.
And no diagnosis of dementia, ever. Right?
Correct.
Okay.
Like, that makes me raise my eyebrows. That's frustrating. That's frustrating to me that they just went through and they know that they put dementia in the minds of the jury. And Laura M says, you either have dementia or you don't. It doesn't come and go. And Laura, I agree with you. And he just answered the question. This expert agreed that Terry Sanderson was tested for dementia, did not have it, and has never been diagnosed with it. So why in the world is the judge allowing this kind of argument to come in. And I think that Owens is making the argument that because it's mentioned as a differential diagnosis, that that's some kind of diagnosis, which it's not. Very interesting to me. Very interesting. And I thought Sykes did a really, really good job in bringing that out. I really did. It's tough. It's tough, man. I don't like to see that. I don't like to see word twisting from country lawyers or city lawyers. Okay. Next witness was the neuropsych expert, reviewed a bunch of records. She's one of the independent concussion consultants. I believe she said in the NFL, or she may have said football. That made me like her immediately. I didn't like her so much later, but immediately I liked her because that's kind of a cool thing. Anytime a doctor works for an NFL team, that's cool. They took a little break to talk about time left. And I thought it was hilarious that after all of Owens's whining, he had actually taken about 25 minutes more time than the plaintiff. More on that later as time went on. Only one side is running out of time. The other has plenty of time left. Just thought that was funny. Back to the neuropsych. Opinions. I liked how they set out their opinions. I like that. The streamlining it, give the headings of the opinions. I like that. I felt like it was much easier to follow and much quicker. You should get these expert witnesses up and down quickly, get their opinions on the record so the jury can have a couple bullet points as to what they said and follow it easy. You don't want to bore the jury. I had a couple of you that are from Utah that went to the trial and told me you looked at the jury and the jury looked bored. Guess what? A lot of other people have messaged me and said they're watching online and they're also bored and they're able to do multiple things. Some of you said, I agree 100%, I didn't like her. Some of you said she was my favorite witness of the day. That's what makes this great. And I bet you that's how the jurors are reacting too. Some of them love them, some of them don't like them. Okay. Plaintiff suffered at most a mild concussion. Again, not a huge collision. Exceptional balance, and usually balance is the main issue after a concussion. Increase intake of alcohol shows that it was not a serious concussion because you lose your ability to even drink alcohol or get drunk. You just don't want to do it after you've had a concussion. They reduce your tolerance to alcohol. I thought all that was really good. Then, and here's where I'm going to put Lita's comment up. Now, Lita, maybe I'm misunderstanding your comment, but I told you prior medical records matter with specialists. So we can agree or disagree depending on what you mean. Because I 100% agree that when she said sleep apnea is bad for your brain, insomnia develops dementia, pre-accident imaging of the brain is relevant, chronic migraines are relevant, hypertension, okay, bad for the brain, but okay. Restless leg syndrome is associated with dementia. Obviously, I didn't know that. I told you guys I don't know much about that. I'm fine with all of that. Guess what she didn't mention? Trigger finger, neck pain, back pain, urinary tract infections, impotence, degenerative disc disease, a torn hamstring, a cut on the thigh. She didn't mention any of those records because they're totally irrelevant. I don't have a problem with prior records coming in as long as they are relevant. I said that. Depression, anger, all that stuff should come in if there are records saying it prior. But we shouldn't talk about this guy's erectile dysfunction. And we shouldn't talk about his trigger finger or his injured knee from 10 years ago. Just my opinion. Mental health issues like anxiety. She thinks Goldstein's own data doesn't match his opinions. So I thought it was kind of interesting. Maybe she's not a very experienced expert witness because it was funny to watch her answer the objections. When he would say, objection, that's outside the scope for knowledge. She's like, no, actually, I studied this and it's within my, and the judge was like, hold on a second. So that was funny. She was answering the objections that were coming in. But I think that was kind of the beginning of showing that she was very much pushing to help the defense. And she was, in my opinion, going a little overboard in who she was trying to help. And it was confirmed because guess what? How many experts have we talked about in this trial? I feel like there's been tons of experts and thousands of dollars spent on those experts. So when she says that I don't know how much I've been paid, that's annoying. It's not true. if it is true, I shouldn't say it's not true. Okay. I don't like to call people liars, especially if I don't know. So what I'll say is, if it is true, it's purposeful, because this is readily available to you as an expert, and you better believe you're not just going to stop charging unless you're that, really nice Southern gentleman from the Murdoch case who kind of stopped charging. But I do not like that. That does not make her seem endearing, that she doesn't know how much she got paid. Ma'am, you're paid to be here. You're not this guy's doctor. You're not trying to help Terry Sanderson. But instead of go that route, instead of making her look unlikable, Sykes, unfortunately, yeah, Kristen, I'm with you. Sykes, unfortunately, decided to become even more unlikable with her by saying something like, what did he say? So you just come here to court and you smile and you testify. It was something like that. And I was like, ugh, come on. Come on. And I didn't like it then, Keely. I think every expert should know what they've been paid, at least up until they go to trial. In most jurisdictions, the other side has a right to that information. And as if saying you don't know how much you got paid makes you unbiased is a joke. It doesn't, because you still were paid. All right. You never saw him and you had these opinions. Yes. So this was interesting, and I'm going to play a quick clip from this. Because while I thought the other guy's answer was actually really good and honest about meeting with the client, if she was my expert, I would not have liked her answer to when Sykes started to push about how she hadn't met with Terry Sanderson, yet she had all these opinions. Let's listen to that.
Okay. Not rendering diagnosis. Let's talk about what you are doing. Could you, is appropriate, is responsible for a neuropsychologist to comment on somebody without actually seeing them clinically in the office?
Again, if he was my patient, yes. He's not my patient. I was hired to review records and provide opinions on the facts in the records.
Aren't there standards for the American Psychological Association that recommend that you see someone before rendering opinions on them?
Those ethical principles apply to clinical practice and patient-doctor relationships, which does not apply in this situation.
So you don't have the.
So I did like that answer. I did like that answer, that certain rules apply in clinical situations and different rules apply when it's forensics. I did like that. Another doctor said kind of something similar. But then this was the interesting part.
Same ethical principles in this case that you would have future patients. That's the idea.
Ethical principles applies to clinical care. This isn't clinical care.
Okay. Do you agree that if you're going to evaluate someone and then come before a jury and tell us about it, that it's better to have more information or less information about them? What do you think? More information or less information?
The more information, the better.
Okay. Do you get more information if you actually have a clinical interview with someone?
As a neuropsychologist, my job is to evaluate for brain injury, and he had had numerous neuropsychological evaluations, and none of which have found evidence of brain injury. And so a fourth neuropsychological evaluation wasn't going to uncover brain injury that nobody else uncovered. So there was no point in me providing another evaluation.
So what was the point of you reviewing his records and giving an opinion? I don't want my expert to be like, yeah, there was no point for me to do that. Because then what's the point of you coming up and testifying at all? Why don't we just use those records? Why don't we just believe those people? So I didn't love, in my opinion, I didn't love how she was just like, other people have already, evaluated him, so there was no reason for me to. I don't like that. I don't like that explanation personally. Now, you guys might have thought it didn't matter. That's just kind of how I took it and didn't like it.
I'll step in here for a second because I feel like talking again. Let me get this up. The screen, that is. So this is where I don't agree with Peter. I still think there was anything wrong with that. I thought it was fine. I also think she's a great witness. So I don't agree with what he said there. And I know he's very unbiased and what have you. And I've agreed to both things that he said up until now. And there you asked whose side he's on. He's pretty Gwyn orientated. I don't think that he would have taken on this case. He does all civil cases, and I don't think he would have taken on the case of Terry's. Basically, he did mention that. So, but this one, he's criticised the witness here. I'm not sure how she's supposed to answer these questions. I think she's answered them very well. So, Pete's my favourite. He's my favourite law tuber. But Peter, I'll give you a slap on the wrist there. Criticising the witness I like. Not only joking, but I don't agree with him there. But anyway, let's see what else he says. Some of you want me on screen, so I'm going to put myself back on screen.
Then Everman turned down to do an IME. It was really interesting. He kind of got into it with her, like, you could have evaluated him. This is what I would have done with the other witness, because he's the one that said he would have liked to evaluate him. She was like, I didn't even need to. So why he went down this road about, did you do the IME? Did you not? Did you turn it down when she didn't? She didn't think she needed to do it. So I wouldn't have had that argument with her. And I didn't think that came off well for Sykes. She also, I thought this was a good highlight by Sykes. She basically totally disregarded the girlfriend's testimony. And then in other times we heard defense experts say all the witnesses had something to gain from their testimony. One person who had nothing to gain for her testimony is the ex-girlfriend who has a new boyfriend. She didn't gain anything from coming and testifying. I felt like she was pretty unbiased as a witness. But then we get to me, the comment that made her seem most argumentative and biased. And maybe this is what soured me on her, because as I'm remembering her testimony, I did like a lot of it, but I really didn't like that she did this. And, you know, sometimes the last thing you remember is how you kind of feel about a witness. And this is the last thing I remember about her testimony. People are saying they don't agree. Totally fine.
Polly, what Polly Harris said. I'm sorry, Polly Gresham. And you gave me a 2-minute Queen of Denmark answer. Now, why did you feel a need to add all that detail when the question was very simple? Why?
Because it's important for the jury to understand. I don't want them to be misled.
Okay. All right. So,
do you hear that? It's very important that the jury understand. I don't want them to be misled. I'm going to back it up a little bit so we can hear what he said. She's basically telling the jury that Bob Sykes is misleading them.
the jury understand?
Observing and aware of his level of functioning in the year prior to this.
Yeah. The jury understands. That was a 2-minute answer to a very simple question. The simple question was, can you tell me what Polly Harris said? I'm sorry, Polly Gresham. And you gave me a 2-minute Queen of Denmark answer. Now, why did you feel a need to add all that detail when the question was very simple? Why?
Because it's important for the jury to understand. I don't want them to be misled.
Okay.
So she doesn't want her to be misled. That's why she answered her question the way that she did without. Some people said she thinks she's great with that. Fine. That's fine.
As well.
And I agreed with her. She was so rude. People said, okay, that's fine. I disagree with her. And somebody's saying I'm totally mischaracterizing everything she said. I think you should go back and watch again and talk about how much she actually considered some of these depots, which she admitted she didn't even read. If you don't read them, you can't.
Wise, but right. So I think Erin is spot on here. I think you're spot on. And also, to go against Peter here, he was awful to her. Yeah, you're right. Completely, absolutely. Sorry, Giovanna. I see you there. Sorry. Hi, Giovanna. Welcome back. Pete Trigos. Just recapping. Agree the jury would hate that. Yeah. Erin's point here is bang on the money, I think. I don't agree with Peter here because I loved that comment. To the layperson, like Erin said back here, I think Peter is looking at this too far in depth as a lawyer. As a juror, and we are potential jurors, I'm not because I'm fucking British and Rosie. I really loved that answer from her because he's attacked her so much. And I thought that she's restrained herself so much. I was really proud. I was like, you go, girl. So I think he's thinking too much here. I'm glad that his audience are also sort of agreeing. And that's what I like about him. he loves people to come back at him going, no, you're totally wrong, totally wrong. He takes that on board. And on this one, I genuinely think he was wrong with his opinion. That's my thought, and I think that's your thought as well, from looking at your comments. All right,
Consider 'em.
let's just go see.
All right, on redirect, did anything change in your opinion? No. But then, one last time, she wants to take her stab at saying something without
this is
a
funny.
question even pending. If this does not show bias, I don't know what does. There is no question pending to her. So let's listen to how this kind of exchange happened at the very end. People are saying, I don't agree with you at all tonight. That's fine. I mean, again, and I'm not telling you to leave if you disagree with me. You can if you're like angry because you disagree with me. I'm not angry at you for disagreeing. So feel free to stay and tell me your opinion in the chat. People disagree with me all the time in this chat, so it makes it fun. But listen, this was really interesting. We haven't seen this yet at all, this trial.
And is it still your opinion that plaintiff's course and evolution of self-reported symptoms is inconsistent with the known trajectory of concussion-related symptoms?
Yes.
And is it still your opinion that plaintiff's medical history is notable for a number of comorbid conditions that better explain his reported course of decline?
Yes.
No further questions. Thanks.
No further questions. Thank you. He's done. But she's not. I think I'm going to have to guess that she's not an experienced testifying witness because of how she handled when objections happened and then also how she did this to the end.
Can I add something, please?
Sure, go ahead.
Okay. I have a lot of compassion for Mr. Sanderson. I do believe that things are changing for him. It is terrifying when one starts to lose their faculties. And I'm not.
I object to this.
Sustain it.
Non-responsive, thank you.
It's a narrative. If you got some more questions, go ahead.
Okay.
And James is like, man, I wanted to give this answer, but he couldn't think of a question. This is totally inappropriate. I realize some people are like, she's an empath. I like what she was saying. It was nice. I agree with you. It was nice. It was empathetic. It's totally improper. That is not how an expert witness is supposed to handle herself in this situation. My opinion. Okay. Just my opinion. That is absolutely inappropriate. Okay. And James wanted to ask a question. Look at him. He's trying to think of a question to ask.
Motherfucker, why does it keep doing that?
That could bring out that answer. And I think if James would have asked something like, so basically they're making it seem like you're paid to sit up here to lie and to hurt Terry Sanderson. Is that what you're trying to do? And then she could have given that answer. I think that would have potentially made it relevant. James is like, I got nothing.
I think we can be done.
I think we can be done. I love James. I like that dude.
I totally agree with you, Rosie. I'm not trying to be critical of him because, as you know, for both of us, he's our favourite law tuber. But I normally agree with most things he says, but I understand he's got to be careful. But I didn't see anything wrong with this one. I thought she's quite humane. That would have represented well with the jury. So she crossed the line. I mean, yes, she did, but at the same time, she's only human.
And that was on 1.5 speed. So he sat there and thought about it for a second. All right. Let's see what else we got here. All right. So the next doctor, lots of doctors, is another expert who specifically was responding to Dr. Fong. And whenever you can give your background and your resume and your CV, and you can say the words Princeton and Harvard, you're doing something right. And people usually will listen to what you say. And I actually thought she did a really good job.
No, she wasn't rude, Joanne. She wasn't.
She's board certified. Fong is not. And there's only like she's one of 6 people in the country with the qualifications that she has. Okay. So I thought her resume, very impressive. Very, very impressive. And then she gets into, we don't even necessarily recognize persistent post-concussion syndrome. John, if you haven't posted the poll yet, let's go ahead and post it to give people an idea of where you would put the damages for pain and suffering for Terry Sanderson right before we get to his testimony. She focused a lot on the before and after, which I thought was good. Again, he punched someone and had a restraining order. Juries don't like people that punch other people, and they don't like people that get restraining orders against them. There were brain scans. Oh, and I loved this. I don't know why. Once one witness says something like this, I'm like, why didn't some of the other witnesses, when they're saying there was no symptomology when he got the brain scan, she did a great job. She said, no, there was complaints of persistent and worsening migraines. That's why he got a brain scan. I was like, why didn't I hear this before? Good job by her. Good job by her. Sometimes he embellishes, sometimes he downplayed. That sounds like our boy Terry. Sometimes it sounds horrible. Sometimes it sounds like nothing. Very interesting. He waited forever to get his cancer treatments. I thought that was kind of telling. She talked about the 45 minutes he was knocked out with a bump on his head, and he didn't even go to the doctor for it, which is wild. Heart conditions not related to her opinions, but may show how he approaches medical conditions. Okay. Borderline. He is an unreliable reporter of his own medical conditions. He had no permanent symptoms. She gave him the benefit of the doubt and would say he did sustain a concussion. And then she also said the rules for forensic situations do not demand meeting with the client in person. I believed her. I was like, she seems legit. I believe her. Yes. Hit that like button if you haven't already. We still have not had a Paltrow video hit 10,000 likes yet. That's my goal. See if we can do it. On cross, she talks about how an evaluation was not necessary. Yes, she wrote a 55-page report. She did not disregard lay witness testimony. He said he tried to make it seem like she disregarded lay witness testimony, and I think he's going to kind of say she disregards lay witnesses. And there were some things she said where it did seem a little dismissive. Actually, I think what she said when I wrote this down was she agrees with expert testimony more than she agrees with lay witness testimony. And if I had a witness said that, here's what I would say. And I'm going to answer this question about the poll here in a second. People always have problems with the polls, but there's a method to the madness. So if a witness said something like, well, the experts are really who you should rely on, not the lay witnesses, which doesn't mean she disregards them, but I would say, members of the jury, normal people can sometimes understand and perceive things better than experts, because sometimes experts are looking for something specific to do their job, what they get paid for. And guess who? I wouldn't say this part, but guess who else is a layperson? All of you guys sitting on this jury are lay people. Your opinion matters. Your view matters. What you think matters. I would say that without saying it. Redirect. You can't fake good in these situations, which I thought was great. The daughters were not knowledgeable about their father's mental health history. That was true. And no, she hasn't changed her opinion. Okay. Another time check. The plaintiff had 2 hours and 45 minutes, but then they took 14 minutes away because of a sidebar. Defense had an hour and 21 minutes, but then they added 14 minutes, so they have an hour and 35 minutes. So they were planning on spending 30 minutes on Terry Sanderson today, 5 minutes on rebuttal tomorrow, and 1 hour for closing. Plaintiff has plenty of time. They're going to do an hour and 10 minutes for closing. And they said, I think they only had about an hour of rebuttal tomorrow, but it seems like they're going to have over an hour if they want to use it. And again, I just think it's absolutely hilarious that at the end of the second to last day of trial, the defense has 1 hour and 5 minutes left, and the plaintiff has like 2 hours plus left. And the defense was acting like the plaintiff was delaying the case. And they split it 50-50 the time. Very interesting. Somebody just asked, can they use Jenny's depo and closing statement? Absolutely not. That is not in evidence. Okay. You need to weight your poll towards smaller end of scale. 1, 1,000, 10,000. Let me just tell you, as a plaintiff's lawyer, whether you award Terry Sanderson $1 or $10,000, it does not make a bit of difference that is a big, fat, capital L loss for the plaintiff. So if you clicked that button, the plaintiff lost. I will just tell you. Those are not the numbers you want or expect to see in a case like this. So that's why I did it that way. I'm not going to go up by $1 increments and have 1,000 options. You'll get the gist of, does somebody think this is a low value, mid value, or large value case? That's what I want to know. It brings us perfectly into the time. Actually, first, he had another court TV violation that he had of Owen's second round with Terry Sanderson, because I thought it was incredibly effective. And as I'm trying to think about non-economic pain and suffering damages, how did Terry's life change as a result of the injuries he sustained in this accident? Owens completely dismantled it as the last thing the jury will see before coming back tomorrow for closing arguments and deliberation. So before we go through this, if Terry Sanderson wins on liability, here's what the people think in the chat about what his damages would be. 72% say $0 to $10,000. 1% says over $1 million. 1%. And then that leaves about 25 to 30% that have a mid-value range on it from $10,000 to $1 million. I got to be honest, anything under $300,000 probably is a miserable loss for them at this point. But very interesting to hear what you guys think about that and think about the damages, as that was the focus of the case today. So let's listen to the beginning of this cross-examination together for a few minutes. And I actually like it on 1.5 speed because it even seems more like a machine gun coming at Terry Sanderson's case. So let's listen to it together. I know some people don't like it, but we're gonna get through it. Don't worry. Here we go.
Do you swear that the testimony you are about to give in the case now before the court will be the...
So we're trying to work our way in. I'm on a 30-minute clock, so I'm going to try to ask questions very directly and just have you say yes or no.
If I can, I will.
Did you, upon filing your lawsuit in a press conference, compare my client to King Kong coming out of the jungle? Yes or no?
That was not my intention.
Did you do that? Did I make up those words, or are those your words to the press?
I'm not sure, but probably sounds familiar.
Do you dispute it?
I dispute my intentions. That's all.
King Kong coming out of the jungle.
Press conference.
Pardon?
Press conference. I was pretty.
Did you say those words about my client?
I was pretty what? Like juiced up, adrenaline? You were pretty what? You called the press conference. Like, not great.
I just chased someone out of the jungle. That's what I meant.
Did you refer to her as Godzilla to your daughter?
I did not. I don't remember that.
She testified to that.
I don't remember that. It's gone. Sorry.
You told everyone it was a hit and run, right? Wrote to your own hometown newspaper and said, she hit and ran me.
I did say that.
And that's been dismissed by this court. You understand that?
Yes, I guess so. Yes.
I want to talk, please bring that up. This is D110. And do you see it on your screen, sir?
And now we get to the pictures.
Yes. Page 400.
Can you maybe...
As Owen said, he's a poster. He's a poster. He likes to post stuff on Facebook.
Here's the first half. Post-incident travel by Dr. Sanderson, Mr. Sanderson. Did you go to Peru?
Yes.
After the collision. All of these are after the collision, okay?
Yes.
Visit Machu Picchu?
Costa Rica, yes.
Walk the Golden Trail?
Yes.
Machu Picchu is in Peru.
Yes.
Floated down the Amazon?
Yes, I guess so.
Costa Rica. Did you do a zip line?
Same trip, yes.
Did you go to Europe? Visit Netherlands, Germany, Switzerland, Italy, France, Belgium?
With my daughter, Jenny, yes.
Bottom half, James, please. Did you go to the
So sometimes I say woof, and you guys wonder why I say woof. It's purely from Home Alone. Buzz your girlfriend, woof. It's like, ouch. And that's what I found myself saying as he went through Peru and Machu Picchu and what's it called? Whitewater rafting in the Amazon and zip lining in Costa Rica. It's like, and Kelly's comment here, I think, goes to that. But I mean, wow. This is all post-accident, which once again, they would have gone with my theory, 4 broken ribs, concussion, out, 3 to 6 months or whatever, pain in the ribs, it took a year to heal, whatever. Make a reasonable demand, try to settle the case. If you don't settle the case, go prove it and see what that's worth. I think somebody said they think broken ribs would be $5,000 in the UK. It's worth a lot more here. It is very painful. and we get a lot more for broken ribs in this kind of case. So that's what I would have gone with, because it changed my life forever. It was like and I'm going to hold that quote until we get to his cross from his side. But everything was different after the accident for him. It's like, different how? Different good? Eisgul's comment, different good?
Netherlands 3 times.
I don't remember.
Well, if you're disputing it, then we pull it out of your deposition.
I don't remember. I have no reason to dispute it or agree.
Okay, Morocco twice. True?
Likely, very likely.
Canary Islands. I need to know if you're disputing these things.
I can't dispute it, no.
Thailand. Did you go to Thailand after the collision?
Yes.
Did you visit at least the states of Washington, Oregon, Montana, and Idaho after the collision?
Probably, yes.
1147. You're a Facebooker, right? At least you were at the time. You posted a lot on social media.
Relative to other people, it didn't seem like I did. Very little.
All of these pictures are from your personal Facebook after the collision.
Okay.
Let's go to number 47. And is there a way to enlarge it, James?
Hey, look who's sitting in the audience. It's the doctor, the good doctor, who I think really wants Gwyneth Paltrow to win this case.
Doing a selfie in your backyard.
Beautiful sunset, probably so.
Page 48. Having a party in your backyard.
No.
These were weird. The sunset and the backyard picture were weird. Now the skiing and all that stuff, I'm totally with. But like, for defendants to act like a plaintiff can never smile again or can never talk to people again because they've been injured and permanently injured is annoying to me and frustrating. But that's not what we have here. We have a lot more than that here, okay, before the chat explodes. We have a lot more than that here. But like a picture of him smiling, come on. He's never had a good day in the last 7 years. He didn't say that. He kind of got close to saying that, but most plaintiffs don't say stuff like that.
That was somebody else's party. I just dropped it. It was my renters party.
If you can straighten it up.
Cinco de Mayo. And she wanted to use the back deck.
And enlarge it if you can. You went to a party in your backyard after the collision, true?
I just visited to make sure they had everything they needed.
Yes?
Yes.
Page 49, not very good quality. This is from you and your girlfriend at the time smiling, true?
Yes, yes.
Next one, number 50. This is a picture of you and your girlfriend.
Yes.
And smiling big, right?
Smile, camera, yeah.
I really don't like the smiling pictures. They had so many good pictures. Why even use the smiling pictures? But whatever. We get their point.
151. This is you and your girlfriend. Is that Southern Utah hiking?
I don't remember where.
It looks like you have one of those cool backpacks with water on. Is that true?
Yes, that's true.
Next one, 52. This is you going on a hike, taking a picture of a moose, right?
Yes.
Nothing like fresh, cool air, a running brook, and easily entertained and hungry company. That's your personal post. Is that true?
Yes.
53. You on a hike, true?
Yes, trying out my camera saying smile.
Every one of these pictures is after the collision. Page 54. Very same year, 2016, as the incident in question. This is you and your girlfriend on your Facebook, all smiles, true?
Yes, true.
56, let's look at another picture, you and your girlfriend on a hike, smiling, true?
Yes.
You have that cool backpack on again?
Yes.
Camelback, is that the brand?
It is.
Page 57, let's go again. Is this you, same year of the accident, hiking?
Yes.
That looks pretty steep.
Trying to get back in shape, yeah.
I don't know how steep it is, but again, so let me make another comment that got some heat on Twitter. All of these posts about the fact that Terry Sanderson still skied, still hiked, still zip lined, still white water raft, still did all this stuff, traveled the world, my life. Post-accident proves that the defense does not even buy their own baloney about how Terry Sanderson has dementia and is decrepit and has osteoarthritis to the level that he can't turn his neck without hurting. That is a totally disingenuous argument. That is not true at all. The records do not prove that. Terry Sanderson's life has not proven that. It is not unsafe for him to walk around and ski and hike and do these things. And that's why I was annoyed when they were trying to use some of those prior complaints at a primary care physician, basically, against him to say there's no way he could have possibly been injured. But you know what's great evidence? So while I don't agree with that argument by the defense, this is great evidence. Pictures like this, testimony like this, evidence than most healthy people. And he is supposed to have had a catastrophic injury from a ski crash where he flew in the air and landed and blacked out for 0, 2, 5, 40 minutes. Everything changed for him that day. Nothing was the same. Everything was worse. His life is terrible now. This is evidence that literally nukes pain and suffering for a plaintiff's lawyer. Even if I believed that Gwyneth Paltrow caused this accident, it would be nearly impossible for me to get to 6 figures in pain and suffering damages for a guy that was able to do all this, some of it within a year of the crash. And there's more.
Page 58. Is this you kayaking after the collision? Just now, we're 7 months after the collision.
Absolutely not.
Is that a kayak above you?
I don't know what it is.
Sir, I asked you about this in your deposition. Is this you kayaking?
No, absolutely not.
Oh boy.
I was trying on helmets to protect my head.
Did you go kayaking after the collision?
I don't remember that, but this is not it. This is in the local.
It's a whole different question. Let's ignore the picture. Did you kayak after the collision?
No, I don't think so.
All right, let's try to find it. You went scuba diving, right?
So if Terry Sanderson was a little more savvy, he would make Owens impeach him over and over again, knowing he only has 30 minutes. But instead, he just decided to agree with all of this. Just fine.
After, I don't even care what year. After the collision.
I did go sometime after that.
I don't even care what
you went to an auto show in Germany. Does this sound right?
With my daughter, yes.
Went to a shooting range. Does this sound right?
Yes.
BMX bike show, right?
Maybe, not sure.
Scuba diving 4 different occasions. Is that true?
Probably on the same week, on the same trip, probably.
Went on a boat ride several canals in the Netherlands. True?
Yes.
You rode bikes?
Yes.
Did bus tours?
Yes.
Boat tours?
Yes.
Auto show we talked about. Explored older towns in Central Europe. True?
True, with my daughter. It was wonderful.
Morocco. Is there a word called Marrakech?
Yeah, yes.
What is that again?
It's a city.
All right. You visited there twice?
I did. Shakia.
Explored Jewish markets there?
Yes.
Cultural sites, the Dior Museum. Is that cool?
Yes, I did.
Is that cool? He's looking over at the jury. What do they think of me?
All right, let's move on. The kayak. Is there a reason are you wearing a helmet for a kayak with a kayak right above you?
You know, I'm in a sporting goods store on the west side that has everything in it, and there was a mirror right there. And I was trying on helmets for protection, not for kayaks, just for general protection. Maybe.
I don't know
For skiing
what that
that time. I was looking. They didn't have anything I wanted.
All right,
I was looking for a MIPS helmet.
Let's go to 59. You went to a rock concert. Is that true? After the collision?
I probably did.
Same year. Let's go to 60.
I think this is when I tried working for the Green Team Recycling again.
That's after the collision?
Yes, that's the team. I tried it.
That's you on the first row on the right with a big smile. True?
Yes, that's me.
Let's go to 61.
Oh, and Carlene's there.
61. Is this your girlfriend at the time in a cool looking waterfall?
It is.
Let's go to 62. Is this you after the collision up in the ski resorts, or what is this?
About a year later. I think I was just walking up the hills above the house.
Okay, page 63. You skiing after the collision.
It could be. I did go with Robin one time to try it out. I tried it by myself twice.
Okay, 60. Well, I'm asserting that this is you skiing after the collision. Do you dispute it?
It was that following year. I don't dispute it.
Okay, 64. Is this you out with your drinking buddies?
Yes.
Did you have an installed breathalyzer in your car? Yes or no?
I had a personal
With your drinking buddies. Owens throws that in there.
one that's just holding your hand.
Page 65. Is this you and your notes? Is this you and your
Yes, being proud of my daughters, being strong daughters, because we're in an exhibit that was about strong women.
page 66? And you went to that exhibit, right?
I did.
Is this you? This is a post highly recommending the escape room for fun, family engagement, and problem solving. Yes?
Especially if you go with teenagers, it's a ball.
Okay, but you're actually contributing to figuring out how to get out of a kind of a scary, mysterious room.
You just put the kids in charge. They figured it out. It's amazing.
67.
So there are parts where I think he thinks the jury is totally with him and totally buying all this. But Just wait. I'll tell you where I think he's going at the end of this.
Is this you wheels up at Salt Lake bound for Europe the year after the collision?
That's the empty seat next to me that Robin was supposed to sit in and told me she didn't like me anymore, that my personality changed.
Did you go to Europe and did you post this? Wheels up bound for Europe.
I posted it.
It doesn't say, I'm really sad that my girlfriend won't come with me. It doesn't say that. It's like,
nope.
Okay.
I
Page
just wasn't sure that would happen.
68, Switzerland. Lots of wondrous sights in my travels through Europe, right?
Yes. My daughter took Robin's place. I got
69, the Frankfurt International Auto Show, year after the collision.
Yes.
The Mercedes exhibit, page 70. Another beautiful day in paradise with your girlfriend. Is this your post after the collision? Feeling happy, it says at the very top. Did you post this?
I believe I did.
71. You're on some kind of tour boat in the Netherlands or something. Does this sound right?
I don't remember where, but yes.
Page 72. Is this you and your girlfriend in the Netherlands?
That was a new friend, yes.
Page 73. Is this you on a bike ride looking fit and happy? Yes?
Yes.
Page 74.
Looking fit and happy.
Is this you at the Siam Park with some friends?
Just the two, just Akia and her son, Shaquille.
And what country is Siam Park in?
I think it's Canary Islands, just off Morocco.
Page 75. You and your buddies. One night, it's my turn to be wingman. There's no chicks and dancing girls. Do you see that? That's your post?
I do.
Page 76.
It's embarrassing. And again, social media can be really embarrassing to a lot of people, but you get the idea. And he continues on with this. And then, just to drive it home and redirect, I was told to travel as part of the healing process. Jenny traveled with him, which I thought was interesting. Jenny, who we heard from the depot, yeah, but nobody actually put her depot into evidence, which was interesting to me. He never said he couldn't travel, but he did say his brain injury changed everything in his life. And here's the quote I saved till now, because even after seeing all of that, after seeing it all and explaining it all to this jury, he still has the gall to say it was like a light switched and everything changed after the accident. It's like, sir, you traveled more than most people will do in multiple lifetimes. You did things physically that normal 50-year-old people can't do. Everything changed like the flip of a switch after this accident because of this accident, after what we just saw and heard, and he still says it. That she was hit by a very large man. You're 5'5", she's 5'10". We get into that. He recounts the fall again, how he was on the right side, and how that's been misstated. The hit and run. Listen, it's obvious he feels like she hit and ran. Owens was like, the judge dismissed that, right? Pretty good point. But then, one of the weirdest parts of this entire trial was right near the end of his testimony. And so people have some comments about whether or not he regrets bringing this lawsuit. But let's listen to his kind of the end of his testimony with his attorney.
A moderately to high full is what it seemed like. Lots of people.
And were you skiing back and forth on the run, or did you stick to the right side?
We'll get there in a second. We'll play here kind of the end of his testimony with his attorney.
Another fact that's been changed. I was on the right side, exactly like I said. I saw all the people congealed in the middle and just went diagonal straight over to the right side and stayed inside of that 5-yard boundary where nobody was. One lone person coming out once in a while that I was wary of, that was down a ways.
And that's when the scream happened, and that's when you were hit.
Absolutely, and there was no one in front of me.
And how did you land, to your recollection?
Downhill, of course. I'm going downhill, so our heads are downhill. So that's, I saw down the hill and crashed there. And I didn't remember doing this, but I did put my hands out to catch myself. That was instinctual, save my face. But we landed, and I remember lurching off the right foot. As I got hit, I thought I got to use whatever I can, and I pushed it deliberately a little bit to the right because I did not want anyone in the crowd to get tangled up in us as they're going by. And I did see, just before I hit the ground, I just remember seeing a scooter on the left.
Mr. Owens asked you, hit and run. You said it was a hit and run. Why did you say it was a hit and run?
I always considered a hit and run was something when you ran into something or somebody and then you just let down and knocked out and nobody's around.
For a number of days, you've heard all the doctors testify your entire life.
Here we go.
You've been here for a number of days. You've heard all the doctors testify. Your entire life has now been broadcast to the world.
I feel like I've been fleshed out, and anyone up here, I think, would feel the same way.
In
Very
fact-
painful.
In fact, I think you
That's true. And it absolutely sucks. And we've said it here already on this channel. This is
So I paused it because there might be a result in. On the actual stream for this case, a timer just came up, 20-minute timer. And the judge said that there'd be a 20-minute countdown. So I'm going to go back. I'm going to go back to the stream in case they start talking. I was lying down on the couch then. It was comfy. Right, hang on. Oh, we can finish this off. Yeah, because it's. Oh, hang on. We'll watch this part and then I'll stop it.
This is what happens to you when you bring a lawsuit. They try to tear you down any which way, whether it's relevant or not.
Take it over
But
now.
then it gets weird.
just told me back there, well, I could never go on another dating site again.
It's true. Everyone knows. Too much.
Do you regret bringing this lawsuit?
Well, that's the purpose, I think, is to make me regret this lawsuit. And
That's absolutely the purpose. He's right about that. And I think this is the
I
moment
don't know, but it might be
where
it
we
for
start to see
Gwyneth Paltrow,
that maybe Terry Sanderson knows he's going to lose this case.
Paltrow.
Because what he does next kind of reminds me, I don't know if there's any like college football fans. It happens a lot in college because the kids are a little younger.
Oh, right, Peter. Sorry.
But it's like you're in a
skipping forward a little bit.
Was it important to you to bring this lawsuit?
it was. I felt like I was seriously injured. And then I had so many insults added to that. I think, as I said the other day, so many insults added to that and layered on that after a while.
Your Honor, post-collision conduct is not an issue. Layered on insults is not part of the lawsuit.
Overruled?
Yeah, I disagree with him. I do disagree with Owens there, but we haven't gotten to the wild comment yet.
I'm classifying as an insult that's absolutely ignoring me, ignorance. And that's what it felt like. It's like, what is going on here? This is obviously an issue that someone needs to be accountable for. And if they're never accountable, what are they going to do? They're going to do it again. Now we have the molesting of young children on an island denial.
What? What did he just say? We have, like, if Gwyneth Paltrow wins this case, it's like covering up molesting young children on an island. Is that the connection he was trying to make? Because I'm not following. I know he didn't actually say that, but is that what he's trying to get this jury to think? Let's listen to it one more time, see if anybody can figure out what the heck he's talking about.
They're going to come on here. This is obviously an issue that someone needs to be accountable for. And if they're never accountable, what are they going to do? They're going to do it again. Now we have the molesting of young children on an island denial.
This is ridiculous testimony. He's talking about
Sustained as to relevance, the last part, the jury should.
Right, I'm going to switch over because we'll all watch this together now. Hang on. Sorry, Peter, you're my favourite, but there's important things to look out for you now. I'm not going to put comments on the screen anymore. Thank you, Giovanna. My rug is same color. Most people don't like this because I need to decorate, but I don't know. I'm a man. I don't know how to decorate, so I don't know. We'll do. I also need to get a new light shade because look at the bloody back. It's don't. Right, present. Share screen. Yeah, Joe. I think there is a verdict, but we're not sure. What's it called? Watch live. I just spotted it. The countdown's on. Like, I've not heard, but I mean, hello. So I need to get on Twitter to try and get some people here. I don't know. When did they take a break? I don't know. Oh, I'm confused now. Hang on. It's just period. Insights. So when did we broke up about half? I'm trying to get it at my time. I think they broke up about well, say 9 my time. So it's close, but I think it would have been about 2 hours if, in fact, this is the result. So yeah, I mean, result might be in because the counter was on 2.5 hours for ages. Let's get this back up to live, and then it just changed. I just a little detective. I was like, "Oh, I could be wrong, but I won't be surprised if it's. I would be surprised if Terry wins, but yeah, we're close enough. I mean, this has been like probably 2.5 hours, 2 hours 45 that they've been, but no, a bit less than that because they have to give the warning as well. So, Rumble people, them, they're cool. So the results are in. Well, I don't know if the results are in, but yeah, it's just weird why the timer's on. Yeah, thanks, Lou. Welcome back. Yeah, you're right. Again, laziness, mate. If I'm being completely honest with you, this you see. So my room is white. Well, not white, but I call it white and grey. They're actually named something else, but I don't remember what they're called. Uh, and then this is trying to break up the room. So I got it. The carpet is not carpet. The rug is exactly the same. That's why I have it. Because I do want it to be too plain. But you're 100% right. I need to do that. Whole TV coverage just got. So I was right. I was on it. Let's go. This is why you follow this stream. You get straight insights. There we go. So Twitter. Yeah. So yeah, here we go. It's intriguing. Oh, so it's gone up to 12 again. I was 4. So that means, yeah, it's in. It's in. Right. Which is good. I'm glad that I'm glad it's been done this early because I just don't want to. I thought, oh, here we go. Got to stay till 2 o'clock in the morning. Hey, the result could still be on Thursday. It's half past 11 in the evening here. So, yeah, me and Rosie, we could go to bed before midnight. Let's go. Sometimes now it's boring now. And this speed's resulting. So I got what we're going to do tomorrow. I can't. Well, I was going to do a video or something. Those I haven't watched it, I've done a Gwyneth Paltrow like final recap, just a quick 8-9 minute one. It's on my channel. Have a look if you want. So relieved I know. Same here. We're going to put this trial to bed. Ooh. What I would be like watching that with Peter Trigos now. I still feel a little bit sad for Terry. Do you know what I mean? But I just don't think he deserves to win. Why have we only got 5 followers? We're up to like fucking 12 earlier. Here they are. I know, right? What are we supposed to do tomorrow? Jeez, yeah, I'm gonna be lost. I'll probably start the stream by accident. Where's that? There we are. How are we doing that? Shifty bunch. You're right, Luke. You're right. This could be interesting now. There's a volume up and everything. Put the volume up a little bit more. Yeah, I know. What? Who's that guy? Looks like a mob. Sanderson looks nervous. I mean, yeah, I mean, I would be in this position, to be fair. It's wherever it is, it's not nice, is it? Was waiting. It's for us, it's excitement. But for them, it must be, oh, horrible. Okay, so welcome back, enough of that. Enough of that. What's, okay, fair enough. We got them. If anyone hasn't liked the video, please like it. Enough of that. I'm doing a job for you. What are you thinking, Lou? Are you on the Paltrow side or are you on the Terry side? I think we're on the Paltrow side. He's got everything pinned on it. Everything. Yeah, not saying everything. He's probably got money behind it, but I think the fame and everything was. But also, he's gonna get paid for an exclusive interview and all that. So I think he's gonna be fine. Joanna, well, we're sorry, we're on. Yeah, Lou, you're in the right stream. It's not the right stream. I mean, I think majority here, if not everyone, thinks the same as you. To be fair, we did have a couple of people that disagreed at the start, but they then came back for whatever reason. I'm still gonna get paid, So yeah.
Yeah, it's too Jody.
I try not to.
I don't have any preference, so it's up to your clients. They want to.
She wants to be here for the jury. Are we not letting the press in, or what's the purpose of this moment?
I assumed everybody was already in. You can go ahead and let them in.
Chris Palmer's just explaining something.
Oh, he's just going through the guidelines? Okay. Thank you. And just to verify with the court TV and with the AP reporter, or the AP photographer, if you could listen to me for just a minute. No, I mean, I know this goes without saying, but no pictures of the jury. Thank you.
Maybe, but I hope not.
So no objection to bringing in the audience if you want.
And they're just being briefed right now.
Well, the orders have been briefed to say, do not react. Rosie, you could be right. They could hate. But, I still don't see it. I still don't see it. Yeah, they have been quite wild, to be fair. I agree, Joe. I agree.
Jody? Okay.
That's a good point as well. So Oh, Weds, take your mask off, man. You only got cold. Jeez. Normally, in a criminal trial, this would be bad news for the defense. But in a civil trial, I've no idea if this is good news or bad news for the defense. Oh, hey, this trial, right? I got the Murdoch trial wrong. I got the Zachariah Anderson trial wrong. I got well, to be fair, the ice cream man, I wasn't 100%. I didn't watch everything, but I did feel he was not guilty. And now this one, Gwyneth Paltrow. So this is my first. I could be like 0-4, or I could be 1-3.
All right, I think we've got everyone in here that wants to come in. If you could be seated, and I'd like to just say a few things before we call the jury in. There is a verdict in the case. I think you've all been told that. Before the jury enters, I just want to say a few things that I say in every case. The court appreciates that this has been a long and difficult trial for the parties and their counsel, and that emotions may be running high. The court reminds everyone that there should be no outward reaction when the verdict is read, and that these proceedings are not over until the court has been adjourned. Most importantly, and regardless of the verdict, the jury has sacrificed more than 8 days of their time to serve, and they are entitled to be shown the same courtesy and respect that they have been shown throughout these proceedings. I want to remind the people that are all here that there are strict orders that are in place concerning the use of phones, cameras, recording devices, unless you've been approved, and there are only 2 people in here that have been approved for capturing anything by video, by audio, or by still, you should not use your cell phone or any other device that might capture those things. Thank you. Ready for the jury? And I have been impressed with how well everyone has been throughout this proceeding, so thank you all.
So here we go. So we all think Paltrow, do we?
For those that are arriving late, there's no use of any recording devices at all.
Captain Murdoch review. Alan Anderson review. I hope it's quick. Well, thanks for being here, guys. I know there's only a few of us, but I appreciate you spending the time with me. As I say, that's someone leaves. I can mute myself.
Thank you. For the record, the jury is now in the courtroom and the parties are present with their attorneys. Would the foreperson that the jury has selected please stand and state your number?
Number 19.
Thank you. Has the jury reached a verdict?
We have here.
Will you please hand it to the bailiff and the bailiff will bring it to me? Thank you. You may be seated. Thank you. We'll now have the clerk read the verdict.
Was Gwyneth Paltrow at fault? No. Was Gwyneth Paltrow's fault a cause of Terry Sanderson's harm? Oh, skip that.
There's just no response there.
Okay. Was Terry Sanderson at fault? Yes. Was Terry Sanderson's fault a cause Gwyneth Paltrow's? Did Terry Sanderson's fault cause Gwyneth Paltrow's harm? Yes. Comparative fault. What percent of the fault do you assign to Terry Sanderson? 100%. Damages. What amount fairly compensates Gwyneth Paltrow for economic damages? $1. Signed March 30th, 2023.
Thank you. So to juror number 19, the foreperson, is this your verdict?
Yes, sir.
Thank you. And the attorneys have asked that I poll the jury, and so I need to ask each one of you if this is your verdict. This is not an unusual thing to happen. It happens quite often. So number 16, is this your verdict?
Yes, Your Honor.
Thank you. Number 11, is this your verdict?
Yes, Your Honor.
Number 8, is this your verdict?
Yes, Your Honor.
Number 2, is this your verdict?
Yes, Your Honor.
I've already covered number 19. Number 28, is this your verdict?
Yes, Your Honor.
Number 29, is this your verdict?
Yes, Your Honor.
And number 32, is this your verdict?
Yes, Your Honor.
Thank you. So to the attorneys, is there anything further before I discharge the jury?
Nothing for the plaintiff.
No, thank you, Your Honor.
Okay.
Thank you.
Let me just read you the last jury instruction. Ladies and gentlemen of the jury, this trial is finished. Thank you for your service. The American system of justice relies on your time and your sound judgment, and you have been generous with both. You served justice by your fair and impartial decision. I hope you found the experience rewarding. You may now talk about this case with anyone you like. You may be contacted by the press or by the lawyers. You do not have to talk to them or with anyone else, but you may. The choice is entirely yours. I turn now to the lawyers and to the press and ask them to honor your wishes if you say that you do not want to talk about the case. If you do decide to talk about the case, please respect the privacy of your fellow jurors. The confidences that they may have shared with you while deliberating are not yours to share with others. Again, thank you for your service. You may now retire. And if everybody else would please remain here, we've got some things to do.
All rise for the jury.
Now we see a smiling. Eric, once again, spot on.
May be seated. So I've got a few things I'm going to do with the parties, and then I'm going to ask everyone who's still in the courtroom at that point to remain seated while the parties leave. So anyone who wants to be outside when the parties leave, please do that now. So, Mr. Owens, I'm looking to you to prepare a judgment on the jury verdict.
Perfect.
Will you do that?
Yes.
Okay. Mr. Sykes, is there anything further for the court before the court adjourns?
No, my client just wants to say thank you to Your Honor for the effort you made. Okay.
Thank you. Mr. Owens, is there anything further from the defense before the court adjourns?
No, thank you, Judge, and to all your staff and the bailiffs.
Let me just comment that I appreciate the professionalism that all the attorneys have shown and the parties, so thank you. This court is now adjourned. Thank
Can I
you.
let my client slip out before.
Yes, everyone remain seated while the parties leave.
I'm going to make a quick statement. Ms. Paltrow is not going to be making a statement today.
So you can make the statement outside, Mr. Owens.
I will do that.
Okay.
That's not what she said to him, but so yeah, where's Chrissy? We're not seeing Chrissy much, have we, lately? So 1-3 now with the results.
Right, we're now adjourned.
I think she's a classy lady. Oh, well. I don't know what to think. I'm so glad. Yeah, sorry, I'm way behind on the these. But anyway, I think the same. I think she's too classy to do anything else. But what do you say? Should have taken the fucking settlement, you prick. She's not gonna do that, is she? Do you know what I mean? Someone said earlier on that she might just pay for the lawyers herself. She may well do. Do you know what I mean? I think she wants an end to this now. I think the results of this now, she needs to put it to bed. And what she has to pay for lawyers, she might be like, do you know what I mean? Yeah, I'm the same. I think I agree with that. 7 years, yes. Yeah, we don't know, Joe. But yeah, I think she should as well. Just to put it all, like, as much as, it's great she's won, and think she deserves to win. It's still this guy. I mean, he's a chancer, but I do think there's something wrong with him due to old age and stuff like that, and his mental health and stuff. Yeah, or something like that. Yeah, we just need to put this. It's nonsense. This trial is. So there's a separate trial, Joe. Not trial, separate hearing for that. The judge makes that decision if they want to. For lawyers' fees, she probably did. I mean, she might. He has got the money for it, and he will get millions upon millions for. He's going to end up with more money after this trial than he had beforehand, due to press. Probably going to be a film, or something about it, Netflix series about it. There's going to be money pumped into it, so I wouldn't worry about him at all. Yes, yes. I think that's enough of deterrence now that she won to try and stop others doing the same. But but if he has to pay the lawyer's fees, I don't know. You can look at it several ways. What did Giovanna say? I miss Giovanna's. Oh, did he call her a clown? Rosie. Uh, I reckon she'll waive it unless they do want to make a showing out of him in order to make sure that no one else tries these kind of things. God, it must be a hell of a thing for her to go through. I don't know what that means. Be called a clown, Rosie. What's going on? Giovanna, you too nice to call anyone a clown in this chat. So, this has been fucking hell. I don't have to have coffee as much now. This has been a long 2 weeks. And the majority of us did it together. Unbelievable. How do we cope with it? I think there were days where numerous ones of us were like, I'm done. I'm spent. But we got through it. 2 bloody weeks of this. For my sins, I've said I will do the if everything goes well, the Johnny Depp one and Amber Heard, because I have been told by Rosie and by Crime Spies. You know who you are, bloody hell. That it's worth doing because it's the same kind of case and it's more exciting. So I'll do that at Christmas if I get a chance. Because I do want to see something again. I'm a coffee man. I'm not a tea man. I drink 1 cup of tea a day, and that's for lunch. But that's it. My parents drink tea, but I'm a coffee man. You know, I'm a bitter guy, so I like bitter taste, like coffee. But I don't like it strong. I like it, I like a lot of milk. When I drink my coffee, I always put in about a quarter. Oh, so I put in, there we go. So you see, I put about that much worth of milk, so about a quarter. Oh, can you read that? Can you all read that? That's Wales in Welsh, Cymru. Cymru, that's Wales. AM is 4, Wales 4. And this is ever, BYTH, Wales forever. And these are some of the rugby players, as in they're not no Welsh. This is a gift from my nieces for when I moved to Glasgow. So Cymru and Byth is Wales forever. And Welsh forever. Dimple Herds. Yeah, I'm going to restream it, do a trial. Some people have said that they would like to do it, so just do a low key rewatch party Christmas time when it gets quieter. See you American. I wish I was. I wish I was. Well, no, I wish I was Welsh, but lived in America. We had this conversation earlier on, Joanna. I think you were here. I love American women. Steve Nash. Rosie, thank you. Thank you. Thank you very much, Rosie. We'll catch up again, all right? You go to bed. I've done recaps on it and stuff like that. I did, I'm not going to do much more than Zachariah Anderson case. No, I'm going to take a few days off now and then start the Sarah Boone case. Go straight into that one. That's my plan anyway. But I felt, as I say, I had it down as not guilty. But it's all of my recaps, man. If you want to have a look at that. But other than that, I don't think I'm not now anyway. I'm not going to do anything about it now. But in the future, maybe. Like what balls. No, I drink too much coffee to make it too strong. Murder, yes, we got Sarah Boone started on the 10th. So most Welsh people, right, when it comes to sport, they hate each other, especially rugby and football or soccer. I don't like outside of that. I got no issues with the English. I mean, there's obviously some that got some arrogance, but the Welsh have got some arrogance as well. No, I'm friends with a lot of English people, but when it comes to sport, there's a big rivalry there. So We're not friends when it comes to international soccer, football, and rugby union. But apart from that, I don't mind. I know there's a lot of people that want independence and hate the English and all that. Like, there's a conversation to be had about royal family. I'm nonplussed about them. Some people love them in Wales. Some people absolutely despise the royal family and want to get away from it all. So yeah, there's a bit of a bit, but also it's not just Wales. It's Scotland, Northern Ireland, Republic of Ireland. They're all against the English, really. It's England against everyone else, basically. Yeah, good night, Rosie. Night, Rosie. No, I know. I know, but I went into women and that was on my mind. Sarah Boone, the suitcase murder, Joe. Um, that's going to be my next one. That starts on the 10th, so I'm going to watch that one on the 10th. So we'll see. I need a bit of a break. It's going to be odd tomorrow. I'll jump in on my computer about 2 o'clock tomorrow and starting the stream because I'm like, what? Why is there no stream? So it's going to be an odd one. But it'd be nice. I'll consider making some videos on the weekend, maybe. Maybe I'll just take a weekend off and just do something next week. I'm going to do a live watch next week, probably next Wednesday evening, about the Sarah Boone case, Joe. Just do a live reaction to a couple of her interviews. So that'll be like 2-3 hour stream. But that's it. Yeah, see you soon, Joe. Thanks for being with us, man. Appreciate you. Appreciate it very much. The other one I'm looking forward to is the Idaho 4, Brian Kohlberger. That's what I'm really looking forward to. Coming back on the live stream. I'll be doing a live stream probably on Wednesday, Giovanna. But apart from that, I'm not gonna do anything. Probably just do some videos. But then the following Monday on the 10th, I'll be back online to cover Sarah Boone, unless anything happens beforehand. But no, I will be live at some point on Wednesday, I think. Yeah, I know. I do need rest and sleep. I genuinely do. I've not had a day off since starting this, so enough of that. Thank you very much. Good night. I didn't even know you were still here, so thanks for being here. Yeah, so there's plenty of time till June, but I'm looking forward to it, Giovanna. So do Sarah Boone, hopefully for most of April. Then we got May then. Hopefully there'll be a nice trial in May. And then, maybe 1 or 2 more trials before then. Erin, thank you. We didn't. We didn't. Thank you very much to you. Thank you to all of you, actually. We've done it together. Can't believe it. It's been 2 bloody weeks. But thanks, Erin. I know we gave you a bit of shit at the start, but I did actually enjoy it. But looking forward to go back to the, as Joe said, murders rather than this again. So, right. So yeah, that's about it. As I say, I wasn't prepared to finish this early, so I'm quite glad. It's midnight here in Wales, so midnight in Wales, and I'm tired. It's been a long. It's not just been 2 weeks, though. It's been the Zachariah Anderson. Before that, I was up a lot for the Murdoch case. And generally, we've not had a day off filming, whether it's streaming or whether it's filming films. Kitten Poppy, and I say, night night, Poppy. Night night. Yeah, that's what I'm doing, Giovanna. And thanks, Shannon. That's what I'm doing. I'm going to do a live view of the interrogation and some video at her house. Those are the 2 videos. The interrogation was about 2 hours apparently, and the one at the house about 45 minutes. So it'll be about a 3.5 hour stream. I'm just going to react. I've not seen any of them, so I'm just going to react to them because apparently some of them are crazy. And then from that, let's start the stream properly then. Where are we at with this one? We are now just going to look, see how many subscribers we got. Jesus, 491 subscribers. Wow. Wow. That's good. We're 9 away from 500. Fucking hell. That's good. That's flown by. We were 248 subscribers 2 days ago. Oh, yeah, Star Day yesterday. Star Stream yesterday, we had 248 subscribers. Today, we have 491 subscribers. It's Giovanna. It's exactly 3 weeks ago I started my first stream. I started before that because I did a couple of videos. So I've done this for about 4 weeks, this channel. But my first stream ever was 3 weeks ago today. So I've been doing exactly 3 weeks of live streaming. And I say I've not, okay, weekends you're off, but I'm not off because I'm doing videos. So if you go on my channel, you see all the videos there. That's what I do on weekends. So I probably have this weekend off and do some of them next week, or something like that. But I also want to recharge my batteries because I'm a bit tired. But this is my full-time job now, so I can't really, take days off. Well, not that many. But I don't want to burn out. That's the only thing. So I will. I will. Well, you're on Twitter now, so make sure you hit the notification bell, Giovanna, so you know when I go live next. I say I'm hoping to be Wednesday night, but I'm not 100% sure yet because I got the dentist. So, and I don't know what time I'll do it at. It'd probably be late evening. Yes, Saturday, Sunday night off. You're right. I am probably going to. It's either that or I'll take Monday, Tuesday off because my nieces might be here. So I will be taking a couple of days off, definitely. Oh, right. I think with that, I think we'll end the stream, guys, because it's just gone past midnight, and I'll be streaming to about 1:30, 2 o'clock every night. So, again, thank you very much to everybody on Rumble, on YouTube, on Twitter, and even though we're not on Facebook today, on Facebook as well, for supporting and being with us. And I see people dropping out now. So with that, I'm going to close it very quickly. Giovanna, have a good evening. Have good night, Giovanna. You missing the interviews? Oh, are they interviewing now? Where? Well, if it's on now, I will put it on. Ooh. No, it's not on Court TV, is it?
And the economic damages could actually be higher than that. The players, the figures in this trial, whom you have seen for days now, have all either not talked after the verdict or stated their piece. Live in
Oh,
Park City,
yeah.
Brian
Why
Leahy,
is it no?
KUTV2 News.
Why is there no? I got it here, but there's no noise.
Let me see what this is.
It's just, oh, hang
They're
on.
not. Are they here?
I'll try to get out to that one now then. I will rewind it now.
You know, big finish.
Why is it
Maybe
no?
not so
Hang on,
much
let me just
today.
try this then. There's no volume.
Brought it for that reason because I wanted to see if justice prevailed.
You can't get volume for it.
Prevails in those situations, but
Why can't I get volume for it? I'll try my phone for seconds. For some weird reason, he won't play.
it becomes character assassination.
That works.
Does it? Becomes
Yeah, there's no volume on it. That's that.
Tons of times, and it's not a run where people go very fast very often, and I ski it usually to get to another run so that you can get something that's a little more challenging.
No, I can't hear it. Sorry, guys. So, but you go yourselves and watch it. KUTV2 News. That's so stupid. Why can't?
And to all your staff and the bailiffs.
Let me just comment that I appreciate the professionalism that all the attorneys have shown and the parties. So
It's so weird because it.
now adjourned.
I forget the actual results,
High burden for her to have
but nothing else.
and there's always negatives.
That's
No.
that run, and no reason.
Oh, fuck it.
Yeah.
Right.
It was just
Anyway,
past those. I just
thank you
passed
guys.
those. I
Thank you,
just
Nathan,
knew
for
that. I
thinking
just
of me.
sliding.
I didn't even think about interviews, but can't get it.
You
So,
answered questions on the
with that,
stand. You
have a
were
good evening
cogent,
and have a good
you seemed
weekend.
very attentive.
Catch you on the other
How does
side.
that jibe
Good
with
night.
the